What has happened after your lordship's my lord, direction? They have served the copy of the affidavit late hours yesterday. But let the matter be taken up any time, my lord, today or any date.
What is the urgency?
Urgency is that my lord, sale is confirmed by your lordship's my lord, AGOT property, my lord. What has happened? There are order that per kata price is 21 lakhs.
Correct.
Subsequently, I filed an application, GA application, saying that another client, my lord, I have the GA applicant willing to give 25 lakhs per kata. And this is for the interest of the trust, my lord. Let the order be recalled. This is my application. There is a direction for affidavit.
But today it is not possible.
But the matter is fixed by your lordship on 13th February.
13th February, that is over.
Yes. That's why I am mentioning, my lord. Until unless, my lord, if the sale is completed, then my application will be infructuous.
Tuesday, Wednesday.
My lord, please. Departmental proceedings are already complete, my lord. Departmental proceeding complete as per order of the Honorable Court. Please listed the matter.
Departmental proceeding?
Yes.
What department?
The citation and special citation and caveat check as per order.
In which PLA matter?
PLA matter.
Come after Monday. Come after Monday. PLA matter I am not taking now because already several matters are there. Come after Monday, I will take this.
My lord, may I mention a matter, my lord, from that is non-commercial matters in the supplementary list, item number 36. The presentation of the plaint, my lord. I am waiting till 10th February, my lord.
Presentation of plaint?
Yes, my lord. Item number 36.
36. Item number 36. Item number non-commercial. Yes.
Item number 36, Miller. Your lordship may take up, Miller. It will take hardly.
Can be done. All persons will say all matter is to be taken. Then I have to sit over there. You come on my head, and I will take all the matters.
This is my request, Miller.
What can be done? Everybody is telling that my matter is to be upgraded.
Your lordship, please.
Already in the list presentation, every one of the alternative, I am giving all chance to all advocates. It will come Monday or Tuesday or Wednesday.
May I have you leave to mention a matter? Lordship had passed a judgment in that La Martiniere group of schools on 27 February. Lordship, in your judgment, had mentioned an equity suit 2602 of 1967. Lordship, we had applied for the certified copies. Lordship, the department is saying a leave is necessary from your end to get.
Granted to grant certified copy. Leave granted to grant certified copy.
Lordship, much of
Yes.
Yes, I got
down for the plaintiff.
Yes.
And for the decision.
Sorry, Mr. Sarkar, I had allowed chapter 13A.
Lordship.
13A and other applications I have dismissed.
May I prefer stay for a short while so that we can approach the.
After the judgment is delivered, learned counsel for the defendant has prayed for a stay of the operation of the order.
One thing, we have not filed any execution application. Till we file the execution application, he can apply for.
That's why I'm planning. So, prayed for a stay of the operation of the order. This court only allowed the chapter 13A application. Full stop. Unless this court find that at this stage no necessity of granting any stay of the operation of the order, accordingly, our stay is refused.
Well.
This matter is appearing at our instance, my lord. There was an application under the Charitable and Religious Trusts Act, which was filed.
Yes.
My lord, in that, my lord, regarding certain Debottor properties, my lord, this Debottor estate had certain properties. Your lordship would kindly have a look at page 8.
Page 8.
Page 8, where the prayers are there. And A and B were granted.
Advertisement.
Yes. My lord, by an order dated 3rd of February 2022, this Honorable Court was pleased to grant that. We did not receive any offers. So we did not mention the matter. My lord. Now we have received an offer, and my learned junior had mentioned yesterday in a sealed envelope. We have not opened. So, my lord, this is what has been given.
Paper publication was made. Paper publications were made as per the.
I am told it is made, but we are not carrying that.
So you do one thing. Take this paper, the paper publication what you have made. That along with this, give the supplementary affidavit. Then the court will consider it and necessary order.
Your lordship is permitting us to open this one.
I am opening it,
Very good.
but you file your
I'll file.
paper publication. Then I will take that. Hey, इसको open करो.
Or privately.
Yes. I am keeping it. You file this affidavit in disclosing this paper publication. You are ready for this?
I do not know.
2 crore.
2 crore. I'll take instructions. This is a fully tenanted building.
Need
100%
through.
tenanted, but
give.
the paper, it is there in the next.
One is there. You give the.
But we'll give the. But whether we are agreeable, I cannot say as of.
That's why.
Yes.
So what? You want the copy of this?
Yes. Yes.
So and so approving for the plaintiff. The plaintiff has handed over a seal cover letter received from Ragini Kanoi, Samta Ghadian. This one, Ragini Kanoi, Shreya Gupta, Samta Godhan, Devash Agrawal, Josna Seth, this one, Preeti Jha, wherein they have informed the plaintiff that they are ready and willing. They have gone through the paper publication made on 9th April 2022 with respect of sale of the property, that is so with all legal tenants with good title and free from all encumbrances for a total consideration of rupees 2 crore.
May I take your lordship's leave?
Counsel for the plaintiff submit that in terms of the order passed by this court dated 3rd February 2022, the plaintiff has made paper publication, but no offer has come. That after the period of 3 years, the plaintiff has received the offer from the above persons.
May I take your lordship's leave, my lord?
This court find that full stop. The plaintiff is directed to file the paper publication published in the year 2022 in terms of the order passed by this court by way of supplementary affidavit. Full stop. The proposal received from the Ragini Kanoi and others dated 25th of February 2025 be supplied to the learned counsel for the plaintiff for taking instruction whether the plaintiffs are ready and willing to purchase the sell the said property for the proposed amount. Let the matter appear on
1 week.
on
Next
12th 13th March. ये कॉपी करके दे दो orders में
Lord, a trust property, your lordship has allowed us to sell to my learned friend's client.
Lordship, I am appearing for the
Now,
purchase.
my lord, we have received the entire sum, deed of conveyance done, but my lord, we require some time, my lord, to get the copy of the deed of conveyance because it is
conveyance registered all the
registered.
things or completed
Registered and the
Possession?
IGR has also been given.
possession.
Possession, Lordship, we are in the process of taking possession.
We'll require some time.
That
to
is
take
the
possession.
problem, sir. Money
Lordship,
is not the
because
problem. Problem is the
tenants are there.
Lordship would recollect there are
Tenants, illegal occupants.
so we have to do the
Nonetheless,
legal-
my lord, only one thing, my lord, your lordship has directed in the order dated 12 December 2024, internal page 7.
petitioner directed to submit the report
Yes,
before this court.
this is with regard to all those things. My lord, I have got, my lord, part.
Okay, I am
not
I am
invested.
extending this period.
Yes.
I am extending. How much time? For 3 weeks, 4 weeks?
My lord, on the safer side, let it be, my lord, 20 days,
Okay, I am giving 3 weeks.
3 weeks.
So and so appearing for the plaintiff, petitioner / trustees. So and so appearing for the purchaser. Now a purchaser,
Purchaser.
not proposed.
No,
Purchaser. Full
Just
stop.
pay.
Counsel for the
He's basically my savior, my lord.
Counsel for the petitioner prays for time to file the report. In view of the submission made by the counsel for the petitioner, time to file report in terms of the order dated 12th December 2024 is extended for a further period of 3 weeks from date. Please the matter on 2nd April 2025
I'm grateful. my lord.
under the same heading. Next. Yes. Yes.
Yes, there are, my lord, if I'm allowed, my lord, there are 3 applications before my lord. One is my injunction application, which was initially an order was passed by your lordship. Subsequently, an appeal was preferred there. Now, my lord, that order has been modified by the Honorable Appellate Court, and the order is continuing. Now, my lord, on the last occasion when the matter we prayed for extension of interim order, the interim order was extended on January 30, 2025. But by mistake in the ordering portion, my lord, the interim order was extended till January 27. Though the order was passed on the 30th of January.
Okay.
And the matter was made return.
How the responsible litigants, responsible counsel did not mark it earlier?
My lord, I marked it earlier, my lord.
If the responsible litigants is so much, he overlooks these types of mistakes. Sometimes you are responsible. The litigant will be very proactive. Thereafter, he will enter into the sleeping country. Then what can
No, my
be
lord,
done?
I mentioned the
Therefore, there
matter.
is no interim order.
My lord will remember. I mentioned the matter, but that day, my lord, was of the view, my lord, that let the matter appear on the 5th, and then my lord will look into the matter. My lord will kindly see. We mentioned the matter upon notice to
We are
them
not
in the
on
morning.
technical point.
Now, my lord, that is 1 minute.
Now what is-
I'm just giving a recapitulation as to what has happened up till now, my lord, and then my learned senior friend will take the arena. Now, my lord, second application is at the very outset, my lord, the defendant had filed an application saying that the leave should be withdrawn because specifically it has not been pleaded in the plaint that which is within the jurisdiction and which cause of action is outside the jurisdiction. So in counter to, so we have taken out an application being GA3 as an amendment because certain portions were in fact omitted. While in an hot-haste manner when we filed the plaint, though it is neither changing the nature and character nor any new pleadings are being introduced, it is only that the adjective is being used with that this was out of jurisdiction, this is within jurisdiction, and in some portions, not in all. And that needs to be adjudicated by my lord on the basis of affidavit if they all at all want to file. And my lord, so these are the 3 applications.
I don't think Mr. Banerjee will go out of the jurisdiction.
Can
now, my
there
lord,
be an amendment to the
and what I'm
objection
humbly
when the
submitting
objection
that
has been
now,
taken?
my lord,
Objection
a
has
good,
been taken.
now nobody is negotiating with the Norwesters.
My lord, I was telling that you are very responsible person. My lord, I tell you one, if one enters into a politics, he should not be much sensitive. What is saying, what is not saying, what is not saying. You know, what has happened, I shall tell you, Lordship. Before Justice Dattu, Chief Justice Dattu said, "Na, my skin is thick to." So one matter I was doing, I said, my Lord Chief Justice Dattu, you know, my skin is thicker than you. Well, why? Because in the profession I tolerate, in the politics I tolerate. You have become you are a political man. You must know how to tolerate. If the degree of tolerance has gone, then how can you remain? Degree of tolerance is there.
My lord, with deepest of respect to my learned Milord, my client is not a politician.
Of course. Yes. That is the whole thing. You ask your client after the retirement. He was a secretary of the ministry. I know him very well because I was a standing chairman of the standing committee of the coal and steel 2009 to 14. Of course, he was. Then in between, he became a political man.
This court can't say anything.
No, he came to Calcutta also, West Bengal, for the complaint lodged by the BJP regarding these mass killings, etc. by the post-poll violence. Don't say political man. Simply because you are political man, that's the reason you have got this assignment. Otherwise, you would not.
Let us say
So now
we are all semi-political people.
All are semi-political people.
Let us have a truce on that. What I'm humbly submitting, what is pursuant to what all my learned, respectable seniors are appearing, Milord. So, Milord, what I'm humbly submitting is, Milord, because, Milord, the interim order is there, Milord, which has not been challenged by my learned senior friend, or which has been passed by the Honorable Division Bench. Milord, that may be extended pursuant to whatever falls from my lord. And Milord, since there are two applications, one is, Milord, the injunction application, and the other are co-related application, one for withdrawal
one is for your amendment, another is for
lordship. So for the
rejection.
amendment, if my learned senior friend's client wants to file any objection, then let
not completed.
Milord, amendment we have filed.
No, with regard to the pleadings not completed.
Not
because injunction was being heard, then Milord, they filed the written statement at a belated stage, Milord. Of course, the time was extended. Now, Milord, more or less, Milord, the injunction application, Milord. So, Milord will fix it up in the. I have to file a reply to my injunction application. It is ready, Milord. But my client was not there, Milord, so we could not get it.
Will your client remain in Calcutta?
No, he is there in Calcutta. My lord, be that as it may, Milord.
Your client.
Let everything be fixed.
At your lordship's order of 30th of January.
That's
happened, sir. You too, sir.
Very good man, not like me.
Now,
you are also very good man.
Now, my lord, kindly have a look, my lord, at the middle of the order. Counsel for plaintiff. That's my lord, Mr.
Prays for extension of time to file reply.
My lord, he pays for counsel for the plaintiff, pays for extension of time to file affidavit in reply in connection with GA 1 of 2024 and affidavit in opposition in connection with GA 2. GA 2 is my application for rejection and revocation.
Correct.
And my lord, he was to file an affidavit in reply in his main matter.
Correct.
Sadly, my lord, both have not happened. Now, my lord, for the interest of justice, as a matter of last chance, time to file opposition and reply by the plaintiff is extended for a further period of 2 weeks.
2 weeks.
Now, my lord, this was a last chance.
Not
Done. So, my lord, kindly, my lord, take up the matter. There's no, my lord, question of, my lord, them getting any further opportunity.
Yes.
In the meantime, that is, my lord, by 5th March, the defendant is also at liberty to file affidavit in reply to affidavit in opposition in connection with GA 2 of 2024.
No affidavit, no.
My lord, that is, my lord,
That is all.
Affidavit opposition to the first
opposition.
Yes. And my lord, our affidavit in opposition which we had exchanged, my lord, may I just file it, my lord? We've been carrying it. They were to file, my lord, their reply.
Yes, Mr. Trivedi.
My lord, we had,
my lord, the short, my lord, issue. My lord, because
my lord,
may I just indicate the application they have taken out for amendment. My lord, one of our main points was, my lord, first, the plaintiff does not disclose a cause of action. Even if it does, my lord, leave which has been granted, my lord, under clause 12 should be revoked. There is nothing to show that any part of the cause of action has arisen within. Now, my lord, my learned friend now has filed an application for amendment, my lord, trying to, my lord, introduce, my lord, places where cause of action had, my lord, arisen. Now, my lord, the plaint as it stands, if the court did not have jurisdiction, then, my lord, there is no question of any amendment to bring the suit within jurisdiction. There's division bench, my lord, of our High Court. So, my lord, that can be heard.
Yes.
My lord, let it be heard. I am not shying away because
No, no, with regard
whatever
to-
my learned friend is
So
saying.
you will not file affidavit then?
No, my lord, my lord will kindly appreciate. My amendment application is there. If they
Correct.
don't want to file an objection there too, then, my lord, both the application with regard to revocation of clause 12 leave and my amendment application may be taken out by my lord simultaneously. Let my lord be fixed a hearing, my lord. And, my lord, as far as the injunction application is concerned, my lord, that also can be heard. But, my lord, what I'm humbly submitting and praying, my lord, my lord, on 30th upon notice, 30th of January, upon
My lord,
notice.
amendment was not moved at all.
No, my lord,
Question
it has
was,
come
yes,
for the
no,
first time. Yes,
Amendment was first time, so we'll file, my lord, there.
that's what I'm saying, my lord. I'm not at loggerheads
No,
with
tell-
my,
tell-
as far as
tell-
procedure is concerned. my lord.
tell.
What I'm saying is, my lord, we mentioned the matter upon notice on the 30th of this month.
Mr. Trivedi,
Lordship.
seriously, the matter is being pressed for.
Are you serious?
That is the thing.
Mm.
If it's serious, then
Are you
it's
serious?
okay. Then it's over.
Yes, yes.
My lord, what I'm
Unnecessary
submitting,
thing.
subject to whatever falls from my
So give the
learned.
chance to the public to place the why the state is placing their matter before the
Governor. The
Governor,
point,
sorry.
my lord, another
My
interesting.
Let
governor,
the- let
My lord,
the-
another
General-
interesting.
General
Governor in
public
his
get
personal
the
cap-
chance to place
No, no,
their
my lord,
queries.
another interesting thing
Okay,
is
well-
this. That if it is, I don't know, if you want to take this, you take it. But I have so many, Mr. Mukherjee is there here, my lord. Point is, when no one can initiate a proceeding against the governor because of the constitutional provision, the governor is having the privilege to do it. Was it the makers of the constitution had thought it?
What has happened to that? Any orders for Supreme Court? Nothing.
No, no. This is in this respect,
No,
nothing
not
happened.
it. With regard to the whether the government.
Chancellor.
No, no, with chancellor, no, with a criminal case,
Launch.
sexual harassment case.
No, my lord,
No, no,
that is-
nothing has been done as yet. No, I am not on that. Simple. Leave aside any matters, etc. Constitutional provision says that I cannot lodge any proceeding, whether criminal or civil, against the governor. Because
Constitutional.
protected person, constitutional. My lord, when once is protected, he will come and lodge proceeding against the citizens. My lord, one cannot think about this. Really, one cannot think about this. If you, my lord, the protection is only for him and he will do whatever he likes. It cannot be, my lord.
Okay.
Makers of the, may I tell your lordships is, this is I am telling in everywhere, including parliament, I am telling, the makers of the constitution never thought these types of governor will come in the country after 2014, then this protection should not have been given. They
My
would
lord,
not have
less-
given this.
Less of the better. I have befitting reply for that. I've got befitting reply for that, but I am not
If you
missing
have
matters, no.
reply, give the reply.
So
Lord,
okay, I
I
am
will.
fixing for hearing.
Don't,
Yes, my lord.
you
My lord,
don't
what I'm
worry.
humbly submitting, my lord, what I'm humbly submitting is that, my lord, will kindly extend the interim order because, my lord, and my lord, give us a chance to file a reply to the objection. And as far as
Which reply?
to reply to GA1,
But last chance is over.
benevolence, I'm praying for.
No, no, no,
My lord,
Chan-
let it-
No, no, no. My lord, on other litigants, it can be done.
Last
Such a
chance.
responsible litigant, my lord, no.
What about them, my lord? They did not file their written statement. I gave my consent. My lord, this is not expected from my learned senior.
No, no, no.
As far as
In any other case is concerned, no
No,
problem.
sir, apni
But
consent-
it no,
no, sir,
it's
apni
such a
consent-
responsible and respected litigant.
Amar Abdar, apni consent deal, please. Amar Abdar, personal. But now he will not say nothing.
Now governor is requesting.
Personally.
No, my lord, I am.
And I when,
because it is my personal request.
and when I told him, Dhiraj, listen, There is no use of this.
Correct.
Chai pe charcha khatam it.
Sit with
My
the governor. Sit with
my
the
lord will
governor.
kindly, my lord's officer, as my lord's officer, my lord, I am saying my lord will kindly fix up a date whenever it is for everything. And in the meantime, my lord, I will take personal responsibility to see that, my lord, there is a truth. My lord. But then my learned senior friend also should take responsibility with his client, my lord.
What?
So that
It is.
about chai pe charcha.
Chai pe charcha, you invite first.
It's not good.
My lord, I shall. My lord, I totally bow down to whatever is falling from my lord. My lord will extend and fix up a date anytime, whatever suits my lord's diary. And my lord, by that time, my lord, I will make serious efforts, my lord, because I've also told my client, my lord.
Correct.
Yes,
That is
my lord is saying.
No, my lord, when it falls from my lord, I being my lord's
Yes,
officer
that-
first, my lord, I will
Yes.
adhere to.
My lord,
Cover-
Mr. Trivedi's request, we can, my lord, try and comply with.
No, my lord, I am so grateful to all my learned senior friends.
No, you also take in.
And in the morning, what I have said to him, he never thought it what I have said to him. I love him so much. I said, you should have been the additional solicitor general. Why you have not? Well, Dada, kya karega? Don't worry. Don't worry. Next time, whenever I will meet. Don't worry. Next time, I will tell that you
My
should
lord,
do it. But he should have been, and then irrespective of any fact, I will say he should have been at Delhi as additional solicitor general. This is my.
My lord, these comments, whether they will
Next time you place.
I will tell the law minister.
I'm grateful, my lord, will kindly.
He was my neighbor earlier, 2009.
That also I will record here. So appearing for the plaintiff, so appearing for the defendant number 1, so appearing for the defendant number 2 and 3, who is appearing?
Kisar judge.
So 3, so
Baba.
appearing for the 4.
Kisar junior
Police staff. 1, 2 and 3 and 4. Counsel for the plaintiff. Prays for extension of time to file affidavit in reply in connection with GA1 of 2024 and affidavit in opposition in connection with GA2 of 2024. Police. Counsel for the defendants has brought the attention of this court to the order dated 30th January 2025. Wherein this court has given last chance to the plaintiff to file affidavit in opposition and affidavit in reply within a period of 2 weeks. Counsel for the plaintiff submitted due to some difficulties. The affidavit in reply and affidavit of opposition could not be prepared, and he prayed for extension of time. As a matter of special chance, time to file affidavit in opposition and affidavit in reply is extended for a further period of 1 week, 2 weeks.
My lord, 2 weeks.
2 weeks.
My lord, it will require time also to me to pacify. That is
weeks.
why it is not
2
affidavit is
weeks
ready.
from date.
But my lord,
And what about the there are
GA3, if
Yes.
he's moving, my lord, then we'll file an opposition.
you will move the
my lord,
GF.
yes, my lord, opposition
The
file.
counsel for the
With the
defendants
maintainability of
prays
GA3
for
kept.
time to file affidavit in opposition in connection with GA3. Let counsel for the defendants prays for filing affidavit in opposition in connection with GA3 of 2024. Let affidavit in opposition file within 2 weeks or 3 weeks. 3 weeks. Reply if any there to be filed within a week thereafter. Police stop. Counsel for the plaintiff submit that the interim order granted earlier, which was modified by the Honorable Appellate Court, may be extended,
It's
for-
actually expired, my lord, but
may be extended. Police staff. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier, which was modified by the Appellate Court, is extended till 2 weeks, 3 weeks, only 4 weeks, no? आज क्या तारीख है 6 अप्रैल till 10th of April 2025 or until further order, whichever is earlier. List the matter on 9th of April. 9th April. 9th April.
my lord, and one request I have, my lord, it would, my lord, help everybody. My lord, the parties, my lord, the plaintiff, my lord, being the first citizen of the state, my lord, should actually, my lord, take steps to settle the matter. He also observes that, my lord, that.
No, my lord will not observe. My lord,
In a cup
since it
of
has
tea.
fallen-
That has happened in the Supreme Court order also.
That First is the orally, otherwise then I will give in writing.
My lord, I shall personally.
Please,
My lord, I shall, my lord. I am again at the cost of repetition.
Then
my lord.
again it will be
My lord, I always believe, my
maintainability
lord,
and all these things. It is not good. The governor and state
my
is
lord, I
fighting
totally
before
bow
the
down, my lord.
court.
And my lord, even at
Let
the
the
cost of
court be
repetition.
left to the litigants only.
Lordship, I shall.
Thank
Deeply
you.
obliged to that.
Thanks. Thanks.
Grateful.
Yes, Mullahs, item 5, Mullahs, comes at the instance of the defendants. Now, Mullahs, in this, Mullahs, by an order of 6th of November, your lordship had declined the ad interim relief to the plaintiff, and Mullahs given us 3 weeks time to file the affidavit of opposition. Now, Mullahs, in this matter, there has been some delay by us, but 19 affidavits of opposition are now ready. My colleague, Mr. Roy, who's in court, Mullahs, can tender those affidavits in opposition. My only request is, Mullahs, let those affidavits in opposition be taken on record.
Hello.
Yes. Have you received?
I'm sure.
Yes, yes.
Milord, I am, Milord, on the basis of Article 14 of the Constitution, praying for equal amount of time that they have taken. Equality before the law.
I don't mind it, Manoj. My friend has not got the ad interim relief. He can get more time.
Kindly give me 8 weeks, Milord. Mr. Sharkar, Milord, and Mr. Sen have to do 19 affidavits.
And they are the competent.
Yes, yes.
So and so for the plaintiffs. So and so bring for the defendant number 2 to 23. Defendants number 2 to 23.
Manoj, it's excluding 4 and 21, everyone. So I'm not representing 1, 4, and 21. So it will be 2 to 3, 5 to 20, and 22.
And Mr. Devan, 23 also we are not representing.
Oh, so 23. So yes, so I am representing 2 to 3, 5 to 20, and 22.
5 to 20 and 22.
Yes, I'm grateful.
The defendants have filed their affidavit in opposition in connection with GA1.
GA1.
19 affidavit in opposition.
19, my lords.
Defendants filed their 19 their separate 19 affidavit in opposition in connection with GA1 of 2024. After serving the same to the learned counsel for the plaintiffs, let the same be kept with the record. Counsel for the plaintiff prays for time to file affidavit in reply. Let affidavit in reply be filed within 4 weeks, 8 weeks.
8 weeks,
within 8 weeks. 8 weeks. Let affidavit in reply be filed within 8 weeks. List the matter on 6. These are non-commercial, na? On 14th May.
Yes, I am so deeply obliged.
Grateful. Yes, next.
My lord, item number 6 is appearing at my instance. My lord, there was a wrong submission on my part, my lord, under a mistaken impression. Kindly takes page 2 of the order of 20th February.
Yes. What is the?
By mistake on that day, I submitted that we have already filed the Vakalatnama. But my advocate record was not there with me. I'm so sorry for that, But we will be filed. Kindly corrects that, and give us leave to file the Vakalatnama. That's the only mistake I committed mistake on that day. And I'm carrying the original Vakalatnama. Can grant the leave to file in department. That's my mistake.
Cases today, some kind of compensation.
What
During
Mr. Banerjee is telling? Some kind of the compensation. I don't know what.
During recess, some kind of.
Can I record or you go with Banerjee in the recess or after?
I can meet him at ILS.
Suffering for the plaintiff, suffering for the defendant. Full stop. The matter is listed as to be mentioned on the prayer made by the counsel for the defendant. Counsel for the defendant submitted on 20th February 2025 when the matter is taken up for hearing. Inadvertently, counsel appearing for the defendant submits that Vakalatnama has filed, but but it was not a correct submission. He submitted the wakalatnama is with the defendant. If the leave is granted by this court, the defendant will file the wakalatnama in course of the day.
Yes, yes, Miller.
In course of the day in the department.
My learned friend Millard intends
In
to
course of the day, I'm carrying the wakalatnama. I'm carrying it. I'm carrying it.
Millard directly, Millard, instead of the summons being served upon the client.
No,
Millard,
dispense
we had served it, Millard, at the address.
No, already order is writ of summon upon the defendant is
Yes,
dismissed.
that, Miller, that,
A copy of the plaintiff is served on.
Very good. And the direction
is-
for Millard's furnishing us the right address of Millard, the defendant, because we had served and Millard, it has come back saying that Millard, the address has moved.
Yes,
So, Millard,
counsel for the plaintiff submit
Miller, that Miller will take Miller necessary steps, Miller.
the plaintiff submit that the plaintiff
So
has
that we
taken
can amend the
steps for
cross
service of
title
writ of
also.
summon, but nothing was written with the endorsement addressee left moved addressee moved. Accordingly, counsel for the says for direction upon the defendant to furnish the correct address of the defendant so that the plaintiff may take appropriate step for correct the address of the defendant in the cause title of the plaintiff.
Yes, ma'am. Great.
As the defendant already appeared and this court has granted you to file wakalatnama on behalf of the defendant, accordingly the plaintiff is directed to serve the copy of the plaint along with the document to the advocate on record of the defendant within a week from date.
Yes. Once you are informed of Millard, the wakalatnama being filed.
The counsel for the advocate on record of the plaintiff defendant is directed to inform the correct address of the defendant by way of communication within a week from date, and also to request for supply of writ of copy of the plaint along with the document, and on receipt of the request from the advocate on record of the plaintiff, the defendant, the counsel and the advocate on record of the plaintiff is directed to serve the copy of the plaint along with all the documents to the advocate on record of the defendant
It should be considered as effective service of summons.
within a week from the date of receipt of the request from the advocate on record of the defendant. Full stop. Accordingly, issuance of the writ of summons from the defendant is dispensed.
So grateful.
My Lord, so grateful to you, Lord.
Order
Deeply obliged to you, Lord.
Order dated 20th February 2025 is modified to the above extent.
Great. Great.
Yes. What's the return statement?
উল্টো কি অপোজিট এ এখন আবার অন্যরকম বলবে complete মানে dilemma হয়ে যাচ্ছে মানে he is making one kind of a case, then Mr. Banerjee মানে is the original case, so we are in a complete dilemma.
Don't worry, I will make a fourth case.
Let me, Millard, align to what Mr. Banerjee was submitting yesterday.
That's an admission.
Yes. Millard, firstly, Millard, important facts. The clause, kindly see the clause once, Millard.
Clause of?
To distinguish rule 22.
Rule
22.
Yes.
At page 104.
Yes.
Any member of
No, Mr. Mitra, because their grievance is the opportunity. That's why this court is giving the opportunity of hearing here.
Yes, best. Again,
the court.
double grievance.
They won't have a grievance against the court.
No, this is, Millard, ultimately, if it boils down to something, Millard, for me, I'll show the audit report also. For me, indicating that there are apparent anomalies which have been admitted by you. You throw me out of a club where I've been a member and a president just because I'm raising a voice. This is vindictive. Millard, please see Rule 22. Any member of the committee may temporarily suspend any member from the use of the club for any breach of rules or bylaws until the next meeting of the committee, whose decision shall then be ascertained. If it is alleged that any member of the club has committed a grave breach. Now, please see the language, a grave breach of any rule or bylaw, or has been guilty of or responsible for any conduct, act, or omission, whether within or outside the club, such as to affect the character or good name of the club, or to cause any annoyance to other members, or if the committee is satisfied that a member or any relation of a member enjoying club has given money, etc., etc., committee may request such members to appear, fail to appear, give explanation acceptable. Committee shall have the power to A, cause or reprimand such member, to suspend such member from the use of the club for any period not exceeding 3 months. 3, where a member is suspended as above, to call upon such member to resign from the club. Now, we could have, assuming, my lord, that indicating that your my statement that your balance sheets have financial irregularities, which is backed by a 20-page clear auditor's report, is so disturbing that you feel it's a grave misconduct or I've denigrated the name of the club. Why are you not cautioning me? Why are you not reprimanding me? Why are you not, my lord, suspending me for a period less than 3 months? Why do you have to suspend me for 3 months and, my lord, to expel me? Proportionality. Also, my lord, please now also see the transcript. In the transcript, your lordship would see the mind. Look, page 18. Lord, please see what Rishi Bajoria says at page 18 of the supplementary affidavit. Their mind, my lord, is completely, my lord, tarnished.
Yes.
Now, see, my lord, number 1, Rishi, 2, Rishi, 3, Rishi Bajoria. Sir, even Donald Trump was impeached. He was impeached, he was president of USA. So, my lord, back of their mind, the members relationship committee already knows he's going to get rid of me. Because
he won the election.
Yes.
So if you
but
equality to the Trump, then you can go for the
but
election.
then Trump did not lose his citizenship. I am losing my citizenship.
No, you'll be dead citizen, don't worry. Will remain.
Okay, no problem.
But general expulsion clause to the bottom. Now, my lord, rule 22 again, my lord.
Yes.
D, page 105. My lord, they keep saying that this is, my lord, like an interim order. Your final decree is being considered and you're delaying the matter. My lord, please see 105. What will I get from this? My lord, see, if having been called upon to resign as above, the member concerned shall not do so within 24 hours thereafter, the committee may refer the matter to the special board for decision as to the expulsion or otherwise of the member, and special board shall be constituted. Chairman, who's the president, 3 members of the committee. So there are 4. And, my lord, 3 gentlemen permanent members nominated by the committee. So I'll put in 3.
Correct.
So, assuming, my lord, that these 7 people sit together and decide, assuming that my representatives, my lord, consider them, I'll always be a minority and be expelled. And on top of that, such ex-presidents of the...
You are telling the minority, you will be in minorities. Your voice will be taken to your word will be taken into consideration by this.
So it will always be 4:3 plus such ex-presidents of the club as may be in Kolkata.
That's why, Mr. Chaudhary. See, that is not the final. If suppose, therefore, You are 3.
I accept
Correct.
what your lordship says.
Correct.
That
if
yes,
if
that
suppose they have taken what you have to narrate your story, whatever
Yes.
whatever the case, your suggestion, what is your case, you have to say before the committee along with your 3 members will be there, they are the 4. If that the committee is not accepted,
correct.
that is not the door closed, you have an opportunity to challenge that.
I do, but I'm expelled from the club. I'm expelled from, I'm 67 years, 65 or 67 years old. By the time I'm able to set aside this vindictive expulsion, I'll be 77. Please look at, and now, 2, 3 very important facts. What your lordship says is absolutely correct. That is looking into a ideal hearing where if it's a division bench or 3-member bench, my lord, judges may not confer upon themselves before passing the order. So the views of, if I'm able to convince my nominees, and my lord, they will have a chance to interact with the other 4, my lord, committee members and the ex-presidents which will be piled up, my lord, against me. Because so that's in an ideal situation. But this is not an ideal situation where you're proceeding with a closed mind. My lord, I'll just take 2 minutes, my lord, with what I was submitting yesterday, and I'm quite convinced on this. So, my lord, even though Mr. Banerjee then went, my lord, into the minutes, my lord, I just want to show you, this is what, my lord, just keep quiet. This is what, my lord, I am finding disturbing, my lord.
The plaint.
Yes, in the plaint.
The plaint.
Number 1, where it is an admitted position that natural justice has to be observed. In that case, all facets of natural justice are required to be observed.
I'll miss the fun. I'll miss the fun.
It's better. Better. Because for a long time, I would find it very difficult to submit if Mr. Mitra was in the courtroom. But after I joined, after 1 or 2 years, when I started, I would find it very difficult if he was there in the courtroom.
I'm sweating.
Now, please, think of it. Please envisage this situation. All facets of natural justice have to be followed. Therefore, now, my lord, kindly, I'll just, take 1 minute, and I've just made a compilation of the law, my lord. 1 minute. Please, opportunity of question 250, 252, 260. Just see 260. আমার নোটটা দাও আর জাজমেন্ট গুলো নাও মিলন হ্যাঁ 260. You have made a mass announcement that there have been significant financial irregularities. You have chosen to send an unnamed and undated letter on a plain white paper without any prior clarification of facts. Being a past precedent, what was the purpose of sending such unprofessional communication in this manner, knowing very well how it can tarnish the goodwill and demean the repute of the institution? Please explain. Your action has caused unprecedented and unwanted speculation and has attacked the integrity of the committee. Please explain your views. Your good self, being a past president, should not have, without verifying the true and correct facts from any of the committee members, made false and frivolous allegations of financial irregularities in the said undated letter. Said undated letter, signed and circulated, admitted by you in social media, was with the intent to provoke the members of the club and have caused loss to the dignity of the club and the members of the committee. My lord, first rule I learned while, my lord, settling show cause notices in my senior's chamber was that predisposition kills a show cause notice. Now, please read this. I don't want to read it again. If this is not predisposition, show cause notices, my lord, we were taught to write, it is alleged. This is predisposition. Mind is clear. Number 2. 14.9 though. Lord, I just to meet their case that this is not a show cause, this is a show cause notice, because that's their argument. Lord, just 2 paragraphs, and your lordship knows this law. Yes, I copy the other side. Okay? 2014 9 SCC 105. I won't multiply, my lord, just
blacklisting.
Paragraph 21 and 22.
Yes.
Lord, contents of a show cause notice. The central rule, however, pertains to the requirement of stating the action which is proposed to be taken. My lord, please see page 260. Not a single sentence, my lord, that I may be suspended and then expelled is mentioned in this. And they want your lordship to believe that this is a show cause notice or a notice where, my lord, I am called upon to explain, which will ultimately lead, my lord, to a suspension or expulsion. My lord, every known principle pertaining to a show cause notice or a notice asking for explanation is breached. May I just read on, my lord? The central issue, however, pertains to the requirement of stating the action which is proposed to be taken. Lord, please read the judgment. The fundamental purpose behind the serving of a show cause notice is to make the noticee understand the precise case set up against him, which he has to meet. This would require the statement of imputations, detailing out the alleged breaches and defaults he has committed, so that he gets an opportunity to rebut the same. Another requirement, according to us, is the nature of the action which is proposed to be taken for such a breach. That should also be stated, so that the noticee is able to point out that proposed action is not warranted in the given case, even if the defaults breaches complained of are not satisfactorily explained. Proportionality. If he had said that you are to be expelled or suspended, I could have said that what I'm saying is correct. And otherwise, I'm sorry that I said this. But what I have done is not so grave that you will expel me or suspend me.
Yes.
My lord, from page 26 now, my lord, see page 260. I have made a mass announcement that there have been significant financial irregularities. And they have already decided that I have caused unprecedented, unwanted speculation.
Yes.
It's not a show cause notice. You had to say, my lord, and I am not going to stand here and indicate what a show cause notice should contain. Your lordship has seen enough of them in service matters. This does not, my lord, detail out the breaches and default. You have to say, as per rule such and such, you can't do this. As the club rules say, you can't do anything which is contrary to the interest of the club. That rule is there. Does it say that? Yet you have issued a notice. Therefore, it is alleged that you have acted contrary to that rule. Therefore, this action is proposed again. That's a show cause notice. This is not a show cause notice. More important, my lord, more important. Show cause issuing authority has to be prima facie satisfied, must issue show cause, listen to the cause shown and decide the matter. Rule is, my lord, show cause issuing authority has to hear the matter and pass the order. Show cause issuing authority is also the decision-making authority. Can never be the other way around. Now, my lord, see just one letter where, my lord, they say MRC, my lord, has the show cause framed. My lord, please see that letter. Page 263. Paragraph 2. As you were informed before the start of the meeting, secretary is not available due to health reason. Entire proceedings are videographed, which you have concurred to. Pursuant thereto, questions have been formed by members relationship committee and the same have been sent to you with the entire video clipping. So, my lord, the questions, page 260, has been framed not by the executive committee, which under Rule 22 is the only body that is entitled, my lord, to suspend me or to expel me, or suspend me, not expel me. So, my lord, MRC has no jurisdiction to frame questions which I have to answer. Questions, it has to be by the executive. It is possible that before a show cause there is preliminary inquiry. MRC has been formed for preliminary inquiry. MRC gives its report. Executive committee sees the report. Executive committee frames a show cause, comes to prima facie satisfaction, which I am not entitled to get, frames a show cause, I have to answer, hearing, suspension. Possible. Absolutely correct. Now, my lord, 263 says executive committee has not framed questions. 260 is framed by MRC. Lord, please see this. This is a void show cause notice. Lord, please see this, my lord, 263. And I'm sorry.
Whatever he's saying, so close. No, that's what he's saying. Yes.
Now, my lord.
So, in the minutes of the meeting, that's a video recording.
Yes.
What was the conclusion?
Yes, my lord, that's what I was wanting to show. My lord, please come to page 24 of the supplementary affidavit. My lord, right at the bottom, my lord, Rishi Bajoria says, no, we have not placed this before the committee as yet. Then Rahul Singhi, there might be an error of a statement. The committee has not even met. Once the committee meets, this will be placed before the full committee. That such is the outcome. The minutes of this meeting will be placed before the committee. Minutes will be placed. So, my lord, and also I want your lordship to see another statement. I'm sorry, my lord, I should have read on. And then what? And then Rahul Singhi continues, my lord. And then whatever minutes will be placed before the committee, and then whatever is the final call, it will be taken at the committee. And the same shall also be intimated to you, prior to which the minutes of this meeting shall also be intimated to you. So, my lord, on the one hand, at the meeting, they tell me they'll give me minutes. They tell me that we'll just place it before the general body and they will decide what to do. On the other hand, without giving me the minutes, as Mr. Banerjee said, There's no conclusive, my lord, recording without minutes. There's no conclusive, that's what, my lord, my leader submitted yesterday. There's no conclusive recording without minutes. And they're acting totally opposite. And also, my lord, look at the impression which they want to give me. Page 10, my lord.
Page 10 of?
Of this same supplementary affidavit. Mr. Mahesh Punjabi.
Yes.
My lord, now the third box, my lord, from the top. Sir, our intention was not even to call you, sir. Maybe the letter was. Normally, the communication goes to the secretary. Fair enough, your point is well taken, but it has gone with our instruction. The only point we want to understand in this letter, which is written, sir, let me finish. Is it written by you or not, sir? Nothing else. And, my lord, and then page, my lord, page 21 now, my lord.
Yes.
Now, my lord, again Rishi Bajoria, fifth, my lord, box from the top. None of them are from the top, my lord. I agree there are 5 examples, understand English, etc. I confirm that. I am confirming. You, my lord, please see, my lord, the 5th, my lord, from the top. I am confirming that, sir, because you raised all these issues in the AGM and it got passed on to the unanimously. So, my lord, they admit at the MRC that, my lord, all this was raised at the AGM by me, my lord, me and certain others.
Yes.
So now the case which is, and if it got passed, if, my lord, and what else, my lord, please see this sequence of events. They give me, my lord, the balance sheet. I'm asked to respond in 6 days. It's not possible. Some issues raised in the AGM. Before that, I issued a circular saying that this is all, my lord, a problem. The balance sheet is replete with problems. And I'll show, my lord, the auditor's report, replete with problems, evident mistakes. Now, if you consider everything and the chapters closed at the AGM, then why pick out my WhatsApp message from before the AGM, persecute me, suspend me illegally?
Okay. Next.
Milord. Kunta. Milord, I also, my lord, the Bombay judgment.
My lord will kindly grant me
No,
next
one
time
minute.
for
They-
Oh,
No, I
my
mean,
lord, they have been making a new case and giving new judgment.
Now, my lord, time after time, my lord, we keep wondering what is the effect of a suspension. Suspension, my lord, in a club matter is not the same as, my lord, in a service matter. Because my whole reputation, my lord, is at stake. If today, my lord, Mr. Banerjee doesn't permit me to enter a particular club, I'll be defamed. I can't even go and do arbitrations.
You can choose the other club.
No, no. But I always go to that club to do an arbitration.
Yes.
Now, my lord, I'll be defamed. Mr. Ray will ask me, let us do arbitration there at 4:30. I'll say I can't enter. My lord, please. My lord, please see paragraph 5. My lord, I'll just read this and pray for leave for my leader to take over. It is true that ordinarily, no action of a private club quits members can be challenged in a court of law, save and except when such action is ultra vires the constitution of the club, or is in breach of the principles of natural justice, or is actuated by malafides or bad faith. Here, my lord, we come into every of these grounds. At the same time, it is important to note that expulsion or suspension of a member entails serious civil consequences. A large part of modern day urban civic life consists of brotherhood of and intermingling in social clubs. Any expulsion or suspension order, in true sense, has drastic implications from the point of view not just of private rights of the persons involved as members of the club, but also their honor and reputation. These actions cause nothing else than social disgrace and acute loss of esteem, both self and public. It is also a notorious fact of club life nowadays that its elections are fought with such keenness and ferocity that the atmosphere at the club is completely vitiated, what with conspiracies abounding every now and then. Bearing all these aspects in mind, we have to assess the facts of the case and consider the relief. It must also be borne in mind that the application is presently being considered at an ad interim stage, at a stage even preliminary to the interim notice where the court considers prima facie merits. Now, this is the situation. This is almost akin to blacklisting, personal denigration, my reputation, my social standing, everything, is intrinsically connected to a club. Where, I have been a committee member for 9 years and a past president. When I keep repeating that, I don't say, that I am an important person in the club. I keep saying that because I have spent a large part of my life at the club. And, what is also very important is my reputation is also connected to the club because I am a past president. Everybody knows me as past president of Calcutta Swimming Club. Now Calcutta Swimming Club throws me out. I can't enter. And for what, Now, if I may just summarize, for what? All that I have done is said that there are financial irregularities. Okay. That is supported by auditor's report. Proceed, all judgments say natural justice. Show cause or letter asking for explanation is a facet of natural justice. That falls short of every, charge not made known. Rules which I am, infringing are not indicated. Consequence not mentioned. Order of suspension. Consequence not mentioned. Order of suspension has no reasons. So, four things are required of a show cause notice. Paragraph 21 and 22 of the judgment I placed. All four are not there.
Yes.
And next action, is illusory because no reasons have been given by you.
Yes.
And they can't say that you have not said anything. Mr. Banerjee showed the letter on the last occasion that after the hearing, I came back and issued an email and I recorded what had happened at the meeting. And I said everything at the meeting. Now, you had to deal with it, but not a single sentence. So what will I say before the committee now? How can I attack the finding? Non-reasoned order and effect. Now, kindly permit Mr. Banerjee.
Just 5 minutes. Just not 5 minutes. Just 5 minutes. Not more than that. That's one I didn't want to just want to distinguish one of those decisions.
Which one?
Mr. Senior Mr. Mitra had relied on certain decisions. We'll look at 64 Calcutta page 57. I'm not going to distinguish the entire lot because I think that would be taking up too much time from my lot. This was on the question of maintainability. 64 Calcutta page 57.
Yes.
On the question of maintainability.
Yes.
Here, the question was, kindly looks at paragraph 3. The suit is instituted against the Royal Calcutta Turf Club in paragraph 20 of the petition. The petitioner alleges that he was all along under the impression
that the Royal Calcutta Turf Club is a registered society under the Societies Registration Act. Paragraph 21 alleged that on March 15, 1963, petitioner solicitor served with a copy of the Chamber Summons and come to know from the affidavit, society is not registered under the Societies Registration Act. Well, this was an unincorporated association. Now, in that situation, if one looks at paragraph 6,
yes,
in the then what they did was try to change it by incorporating. If one looks at sorry, just before paragraph 6, the last 7 or 8 lines. Thereafter, the plaintiff took out a summons for amendment of the plaint and for leave under Order 1, Rule 8 to sue the defendants in their representative capacity, and for leave under Clause 12 of the latest patent, it was held that a suit for damages, breach of sunset. Then, kindly come to paragraph 8.
Yes.
Counsel for the respondent contended proposed amendments in the present case would have an effect of first converting the suit into an entirely different suit by bringing on record different parties in different capacities in place of an entity who is not a legal entity, and secondly, of relating back a cause of action by amendment when the cause of action is barred by limitation on the date of taking out of summons. Thirdly, of bringing to record as defendant's representative capacity persons who had nothing to do with the decision of the stewards. He also relied on decisions and such. In support of his contention that as to unincorporated members club, proposed defendants in representative capacity could not first represent members who might not have been members at relevant time. Secondly, they would not represent the steward who entered into adjudication proceeding pursuant to the racing rules. In my opinion, counsel for the defendant right in this contention. To my mind, the present application misconceived. I hope that there is no misprescription and it is not curable by amendment as contained for. Secondly, I hold allowing the application would be doing incalculable harm to the defendants by reason of the plea of limitation. Thirdly, that bringing into record the defendant representative capacity would be to change the suit into one of an entirely different character. For these reasons, I'm of the opinion application failed, the application is dismissed. Now, my lord, how I don't know, with the greatest respect, I don't know how this decision applies. Because in the first place, we have sued the club in a representative capacity.
Correct.
My lord, here, my lord, what they did was, my lord, they sued the club and then they tried to amend it to, my lord, have it, my lord, in representative capacity. So, my lord, all these decisions, my lord, 64 Calcutta 57, 2003 8 SCC 413, and my lord, the other unreported judgment. This was on the question of maintainability because, my lord, they were all unincorporated association. Now, here, my lord, yes, unincorporated association, it's an association of persons, but they've been sued with, my lord, leave under Order 1, Rule 8.
Okay.
So, my lord, the formation, my lord, of the suit, my lord, is not, my lord, incorrect, my lord, it is correct. Then, my lord, one more judgment which I want to distinguish, my lord, from the from defendant number 13's bunch. I don't know whether my lord has had a look at that.
Which one?
My lord, this Ram
Kumar Kashyap.
Yes, my lord, Ram Swarup Sundarlal.
Yes. Specific relief.
Yes.
Section 14.
Yes. Now, my lord, with the greatest respect, my lord, I find, first of all, my lord, I think, my lord, this was, if my lord looks at it, this was in respect, my lord, of a registered society. In the bunch, my lord, will find Ram Swarup Sundarlal Goyal versus North Indian Association, Mumbai.
Correct.
This case, my lord, it's a single judge of the Bombay High Court.
Yes.
Seems to suggest that, my lord, if the plaintiff was removed from life membership of a society, then, my lord, under the specific relief act, my lord, has that, my lord?
That after the return statement.
Sorry, my lord.
File the return statement in the matter. Come to the page 6, page 69, paragraph 6. Defendant filed return statement opposing
Yes,
the plaintiff
yes.
claim for
My lord.
according. The conduct was invincible, rowdy, and the grave misbehavior
Yes.
plaintiff.
And, my lord, here, my lord, will find this a registered society.
Correct.
So, my lord, what will apply, my lord, to a registered society, my lord, will not apply, my lord, to a social club, because this seems to suggest that you can't challenge, my lord, a suspension because of, my lord, provision of the Specific Relief Act. And, my lord, in all the other judgments, including, my lord, the Supreme Court judgment, my lord, the Masonic Lodge, my lord, which is Debr case, my lord, will find where, my lord, everywhere there has been a challenge in a social club, and, my lord, that has been considered. This judgment, my lord, in fact, I found, my lord, does not, my lord, even consider the Supreme Court judgment, my lord, of 64 Supreme Court. So, my lord, 3 submissions I make on this, my lord. This is, my lord, has to be restricted to, my lord, the case of, my lord, a registered society. Whatever, my lord, principles they think, my lord, will apply, my lord, to my lord, a registered society, my lord, is not something, my lord, which will apply to a social club, where, my lord, my standing is important. Because the very fact that, my lord, I'm part of the club,
yes,
my lord, have, my lord, a social life, otherwise a professional life, social life, and, my lord, that is part of, my lord, my social life. So, my lord, if I'm expelled or, my lord, suspended without, my lord, the rules being followed, then, my lord, quite naturally, my lord, I should have a cause of action. That's, my lord, 1. 2 is, my lord, that, my lord, section 14, my lord, would not apply. 3 is, my lord, this judgment, my lord, has to be, my lord, considered, my lord, as either per incurium, because, my lord, it does not consider, my lord, 64 Supreme Court, which, my lord, we have relied upon. And, my lord, will kindly, my just, my lord, keep in mind, my lord, one thing, my lord, and which, my lord, I think, my lord, are the 2 principles, my lord, which we have rated. 1, my lord, is the breach of principles of natural justice. Nowhere, my lord, did it say in any of the notices that the purpose of any of these meetings were, my lord, to take further action against me. None of these. Not, my lord, the first meeting, or, my lord, the membership relationship committee, my lord, which in fact ended by saying that we are going to place everything before the committee.
yes,
The committee also did not say that give me explanation, otherwise this is going to happen. And, my lord, we still do not have, my lord, any minutes, or, my lord, with regard to, my lord, the final, my lord, decision with regard to, my lord, suspend. That, my lord, I've submitted, and, my lord, will consider, my lord, our letter of 29 January. This also, my lord, I've submitted. My lord, we have prepared a set of notes as well, my lord. We'll, my lord, hand it up, my lord.
okay. Yes.
First, Mr. Mitra will.
Only 5 minutes.
Yes, yes. Well, kindly take a look at the minutes of the meeting. Kindly come to this minutes. Minutes. No, sorry. Minutes. I can't use the word. That will offend them. Kindly come to page 12 of the supplementary affidavit.
Yes.
Internal page 5. Very important. The second question.
Internal
Mahesh,
page 5.
internal page 5 of this
Correct.
transcript. Not minute. Transcript.
Yes.
Kindly see the second box. Mahesh Punjabi. Just after Jai Surana, Mahesh Punjabi.
Yes.
Exactly, sir. You then it has gone blurred. Jai Surana's answer will show what was the other question. See, nobody asked me any question except whether it is my signature or not. Now I am not prepared to answer what I don't know, what you will ask. So you give me a question, I will give you a written reply so that everything is in paper, pen and paper. So apropos this, letter was sent to them on 18th of November. That is page 260. And several more. I'm just showing the first one, 260. So he was not given a chance to respond. Kindly see. 260.
So
Written
Mr.
query he
Mr.
wanted.
Mitra, I want to ask
Yes,
one
yes,
question to you. Okay, he stated that he will give in writing in pen and paper.
So we
What
asked him
is
the
what is the decision taken in the meeting? What was the conclusion
Yes,
of
yes.
the meeting? Show me that.
Yes, Minister. Executive committee.
No. This MRC meeting committee, which is the videograph, because they have to take if a minutes of the meeting is taken, some conclusion would be there. What is the conclusion in the MRC?
So, but MRC Lordship kindly sees 22B. 22B is where it's 22B of the rules. Lordship, can you take a look at the rules?
Yes.
If it shall be alleged that any member so and so Lordship kindly comes to if it shall be alleged that any member of the club has committed a grave breach of any rule or bylaw,
Correct.
or has been guilty of or responsible for any conduct, act, or omission, whether within or outside, such as to affect the character or good name, or to cause any annoyance to other members, or if the committee is satisfied that a member or in relation of a member enjoying the club facilities under the responsibility of the member has given any monies, gratuities, or other inducements to any staff of the club. Next, the last six lines. The committee may request such members to appear before them at such date, time and place as may be specified, and if the member shall then fail to appear as requested, or on appearing shall fail to give explanations acceptable to the committee for the matter alleged, the committee shall have the following power. One is to caution or reprimand, to suspend, and Roman 3. Now, Lordship kindly comes. Apropos this, which is the notice called to calling him to attend the meeting?
Oh, the committee meeting is later.
Lordship kindly comes to my note where I've given. Oh, we haven't given our note. Have we given our note? In the form of a list of days, it may be some use. Of some use. I may have to get page 12. Page 12. Copy there. Copy there. This
right, it starts from here. You see, 8th November he appeared. Therefore, he was given opportunities from here onward by the MRC, 4 opportunities.
Lordship kindly takes a look at page 9 once. Page 9. Page
9 of your notes.
Of my notes. This is really the list of dates. 8th November is the MRC meeting. Lordship was inquiry. 9th November, email by the plaintiff to the secretary requesting for video recording of the meeting held on 8th December. It is pertinent to know that the plaintiff does not raise any demand. So he asked for the video record. The 18th November,
This is not annexed.
this is not annexed here, so I've annexed it here, page 37. They have suppressed this. 18th November is the first opportunity to answer these queries. Then his responses, no response.
So that's why.
Give me the minute.
That's why I'm asking. 18th November is the 3 explanation you have called for.
Yes.
Correct. After the MRC meeting. So that's why you have now pointed out with regard to the internal page of page 10. Page 10, not 10.
Page 10, page 12.
Page 12.
Yes.
Correct. He will say that he will give everything in writing. So my only question is that if any meeting is conducted, okay, you are telling that there is no minutes of the meeting. So this is the recording. So what was the conclusion of the meeting? Whether yes, you have stated that you will give in writing, a so-cause will be issued or a letter will be issued asking the explanation. Is there any decision here?
Of the MRC.
Yes.
Of the MRC, Lordship 22 does not require MRC's decision.
Correct.
Lordship kindly comes to page 12 of my note. List of dates. Page 12 of my notes, 17th December is where 22B kicks off. Can you see 22B and page 12 of my note?
Yes.
17th December 24,
Correct.
email by the Secretary CSC to plaintiffs stating that despite several requests and reminders, the plaintiff has failed to point to reply to the 3-point clarification, so and so. In such premises, the plaintiff is required to meet the executive committee on 20th December along with the answers to the 3 point. So this is 22B, last 6 lines. Now, 22B, let's see 22B, the last 6 lines. The committee may request such member to appear before them at such date, time, and place as being specified. And if the member shall then fail to appear as requested. Now, Lordship will see 18th of January 2025. The meeting is fixed 27 January. Then 27th January, page 12, he asked for.
So that, yeah, that
yes,
you have
those,
already
and,
pointed out. That is not.
And then Lordship will see page 13, 27 January 25 is the EC meeting. MRC can't take any decision. Lordship, 27 January 2025 is the minutes of the the meeting of the executive committee.
Correct. So the MRC was constituted.
MRC was constituted just
correct. And MRC has called the petitioner. On 8/11, a meeting was conducted. There is no minutes of the meeting. It is a video recording. Correct. So the MRC in the meeting, what has been done and what is the recommendation of the MRC to the executive committee? Because the secretary has issued the letter.
Yes.
Secretary has issued the letter, not by the MRC. Not by the MRC, it's the secretary has issued the letter. Thereafter, there is no MRC. So with regard to the executive committee, the secretary has issued the letter on 18th of November. That is the page 260. How the secretary has come to know these 3 questions, which is not in the MRC meeting. This question was not raised in the MRC meeting.
Those were raised in the 8th November. Lordship sees the 8th November notice given by MRC. 8th
November notice.
No, not 8th November, which is the notice given by MRC.
18th November, that is the
Sorry,
secretary.
18th November.
How did the secretary?
8th November was the meeting.
The secretary
How immediately after the MRC secretary has issued the letter, where is the recommendation the MRC to the executive committee? Yes, he has not cooperated with that. He has not given the letter. Please take appropriate action by the committee. We are not authorized to do so. Where is that?
Oh, how did the MRC communicate to the secretary that these are the queries?
Lordship's queries. So how does secretary know about it?
Correct.
How does secretary?
How the secretary knows? And secretary Somoto cannot issue the letter. It is the executive committee has to decide. Yes, he has not cooperated with the MRC. Okay, call for the explanation. So the executive committee take, because the suspension letter has been issued by the secretary.
Executive committee.
Executive committee. The secretary has issued. So where this the recommendation of the MRC that he has not cooperated, so that the executive committee take action appropriately.
Even before the whole
Lordship, may I just check this? Lordship, tomorrow first thing, Lordship keeps in the morning, because this. Let me check this up.
Because this
is a very pertinent query.
Lacuna.
Yes, Lordship, let me.
Just find the something.
Let me just check this.
Because the minutes of the MRC, okay, safe. No
MRC
problem.
was not didn't have minutes because secretary was not there.
Okay, no problem. No problem. We'll see to that. I will deal with that, or whether it is to be accepted or not. But with regard to MRC has taken, because in this meeting, this meeting, the video recording, there is no such decision taken by the MRC. Correct. So the MRC will say, yes, you have not given this, so we will refer to the executive committee and
taking necessary action.
Take action. So how the executive committee has taken action, and how this 260 has been issued by the secretary, on what basis?
On what basis? Lordship, I will just check.
That is the only thing.
I will check this up tomorrow. Lordship, I'll keep it first thing. I will just ask.
So and so appearing for the plaintiff, so and so appearing for the defendants. Full stop. Counsel for the plaintiff has concluded his argument. Only with regard to the reply of the plaintiff's argument in reply, नहीं क्या बोला Arguing counsel for the defendant has made submission in reply, but during the reply, this court intend to know, this court want to know what is the decision taken by the MRC on its meeting dated 8 November 2024 and how, under what circumstances this has been gone to the executive committee and where the executive committee has taken any decision giving authorizing the secretary to issue the letter dated 18 November 2020. That's a clarification be made. That's it. And that the defendants may clarify the set point by tomorrow. This is the matter tomorrow at 10.
Great.
अच्छा not. अच्छा कल तो commercial है. Then Wednesday. Wednesday will not be there.
No, whatever.
Come on Wednesday. On Wednesday that is on कितना तारीख? 12. 12. At the top in new motion.
Lordship, I was praying for short passover. He was here, Lordship. Mr. Thakkar was here.
Yes.
He was here, Lordship. He had just left. One matter was about to take one, Lordship. It was 11:30. He was sitting here, Lordship. Only short passover, he will come, Lordship.
Next.
Your Lordship, I am for the petitioner. I kindly grant me a short passover. I am led by Mr. Shakku Sen. He has another fixed matter.
Next.
This is my application as an intervener.
You are for the plaintiff?
No, I am for the intervener.
You are intervener. Who is for the other side? You have filed the GA3?
Yes.
You have filed an application? No.
Application. I filed an application.
What is the application number?
আমার তো petition সেই জন্য আমি এদিকে রাখছি
মানে application এসে
नहीं है. When you file the GA3, GA1, it is not in the record, it is listed. Listing it.
মানে file it is mentioned in the listed.
It is not
the
there.
list মানে
Other parties, you are for the
the petitioner, my lord.
plaintiff.
Yes, my lord.
What intervener? What is your objection? Have you gone through?
He alleged that there is no legal necessity. We have already stated that we have a legal necessity in the matter.
But deletion the name.
No, my lord, I want to add myself.
Add in.
Yes, my lord, because it is in respect of a trust of 1938. Now, my lord, I am the grandson of the original trustee. Now, my lord, the purpose for which the trust was created, my lord, for maintaining something with regard to the family members. Now, my lord, the purpose of trust now, my lord, at present is, my lord, no more existing, because, my lord, the functions which was mentioned in the trust, that has already been, my lord, over. Now, my lord, my learned friends, my lord, want to, there are several properties in respect of the trust. Now, my lord, my learned friend wants to sell one of the properties in Calcutta. Now, my lord, and my lord, earlier they have also sold some property.
So who are you? Who are you?
And I am the grandson of the original trustee. I want to add myself.
As per the trust, you. As per the trust deed, you whether your interest is protected in the deed.
No, my lord, the trust, my lord, created for some purpose. My lord, there is mention that who will be the trustee after the demise of the original trustee. Now, my lord, now the plaintiff before your lordship, my lord, they are not the trustees, because my lord, they have formed a trust, and my lord, they have made themselves as trustees and my lord, proceedings with this.
When the trust was created?
Original trustees of 1938.
No, you're telling that when they came into the
My lord, they have formed the committee, my lord, that they are now, my lord, managing the trust.
So when they have become the trustee of the trust?
My lord, they have created the trust.
Okay, your application is not here. Let the application come.
Trust is about my lord 1st December 1934. My lord, I am led by Mr.
But have you got the application what he has filed?
Yeah, I've received.
Yes, we have received. My lord, I would like to use an affidavit because it's an application for addition of party
Correct.
alien and originating summons suit.
Correct. That's why I'm asking him what is your right on that.
We'll try and demonstrate that possibly he doesn't.
So offering for the plaintiff, so offering. So offering for the plaintiff, so offering for the intervener. Intervener has filed the present application being GA1.
Yes, ma'am.
Yes.
GA1 of 2024, praying for addition of party. Full counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition file within 2 weeks. Reply, if any, there to be filed within a week thereafter. List the matter on 3rd April 2025.
Great.
3rd April. I'm good.
Great.
Let the adjourn motion. Next.
Appear for the plaintiff petition.
So this is my application. It's an application. There are two applications. One is an application, my lord, under Order 7, Rule 11 for return of plaint. Because, my lord, they have filed this suit in the non-commercial division. Disputes pertaining to this matter, my lord, arises out of a development agreement. Now, my lord, the main application, which is GA1, that is Mr. Mitra's application, that is for injunction. They have preferred an appeal from an order passed by your lordship, whereby your lordship has been pleased to direct filing of affidavits. My application for rejection of the plaint and or return of the plaint needs to be taken up first. Mr. Mitra has indicated that he shall not be using an affidavit to my application.
Yes.
Yes.
So
Now,
your application is GA?
Lord, GA2.
GA2, So what has happened in the appeal?
Appeal, my lord, it has been adjourned at least 5 times because
there is a kind of protection that
which is contested, my lord. There is no protection according to us.
Okay, I am not
there
going.
is wish and trust, that hope and trust, nothing will be done. Hope and trust.
Okay. Yes. So you will not use affidavit?
Not to the
J2.
Not to it should be J3, I think, I'm not mistaken.
J3, I am correct, my lord. It's J3.
GA3, it's on the face of it. I can't improve upon it by giving affidavit, whatever the plain.
Yes. What is the point?
The point is, my lord, the pleadings from the pleadings of the plaint and the documents annexed to the plaint, which the plaint and the documents have to be taken into consideration together. What you will kindly see that the disputes are such that these are commercial in nature. Mr. Mitra will, of course, rely upon Ambalal Saravai for the purpose of arguing the fact that the nature of present user is not commercial. That will be his defense, I presume.
Yes.
May I, my lord, take your lordship through the relevant paragraphs of the plaint for indicating as to how this is a commercial dispute.
Yes.
Lordship takes paragraph 1. The plaintiff number 2 is a partnership of Messrs. PS Group and Manjushri Realtors LLP and Salarpuria Properties Private Limited, each of whom have one designated partner in the plaintiff number 2, which is a limited liability partnership firm. Court resolution is annexed. The defendant number 2 is the owner of 211 kathas, 2 chataks of land, which is, my lord, effectively the owner of the property at Russell Street, which is Turf Properties. The defendant number 3 was an unincorporated association of persons, which is a club. Paragraph 5 below, turning over to the next page. The defendant number 2 owns and holds the premises in the capacity of a trustee for and on behalf of the defendant number 3, which is the beneficial owner of the said premises. This would appear from 2 declarations of trust, both dated 31st of May 1932. In or around 21st May 2007, a memorandum of understanding was executed between the defendant number 2 and Imar MGF Land Private Limited for the purpose of facilitating development of the said premises by Imar MGF Land Private Limited or its nominee on the terms and conditions contained therein. The plaintiff number 2's advocates were shown a copy of the said document. Imar MGF Private Limited subsequently nominated the defendant number 1, its wholly owned subsidiary, to develop the premises on the terms and conditions contained in the memorandum of understanding. Thereafter, my lord, skipping over to the next relevant paragraph is paragraph 15, my lord, page 19 of my application.
Yes.
In the opposite circumstances, the partners of the plaintiff number 2 were approached and negotiations ensued between them and the defendant numbers 2 and 3. The said negotiations ultimately resulted in a memorandum of understanding dated 28th of May 2021 being entered into between the defendant numbers 2 and 3 and 3 partners of the plaintiff number 2, wherein it was agreed that 3 partners of the plaintiff number 2 would form a consortium and would develop the said premises through a special purpose vehicle. The said memorandum of understanding containing the entire essential terms and conditions of development would be subject to approval by the members of the defendant number 3. It was also agreed and is recorded in the said memorandum of understanding that no objection certificate would be obtained from the defendant number 1, recording that on the payment of their dues, the defendant number 1 would have no claim over the said premises and would hand over physical possession and title deeds to the defendant numbers 2 and 3. The memorandum, my lord, is enclosed to the plaint. I have not included, my lord, the documents. If your lordship can request the court officers to hand over the main plaint, the document is annexed to the plaint. It is at page 79.
Didn't I? Please. कुछ नहीं है यहाँ पे. It is a J1. J1 you enclose, na?
No, no, my lord. We have enclosed just the plaint without the annexures.
Okay. Okay. Yes.
My lord has the plaint, my lord, with the documents, my lord. Very well.
Your junior has provided.
Lordship, grateful to her. My lord, I'll place the plaint and then I'll take your lordship through the documents, my lord. Well, paragraph 17 of the plaint. Subsequently, the defendant number 1 issued a letter of 33rd of July 21 to the defendant numbers 2 and 3, indicating their no objection to the proposed transaction that the defendant numbers 2 and 3 intended to enter upon. The said defendant number 1, however, reiterated their right to receive the said sum of rupees 47 crores. The defendant number 1 further recorded and confirmed that it would have no objection to handing over title documents to the defendant numbers 2 and 3. A copy of the letter is annexed to the plaint, my lord. The defendant number 1 was aware of the plaintiff number 2 and its partners would have this payment made through the defendant numbers 2 and 3 after obtaining initial approval from the Kolkata Municipal Corporation. Pursuant to, I'm sorry, my lord, this would be evident from the dealing and correspondence and is also a term recorded in the memorandum of understanding dated 28th of May 2021. The defendant number 1 was unaware. The defendant number 1 was aware that the defendant numbers 2 and 3 were not in the position to make this payment, and the defendant number 1 would receive payments after the project received initial approval. This was also accepted by the defendant numbers 1 and 4. Pursuant to the said memorandum of understanding dated 28th of May 2021, the plaintiff number 2 was incorporated on the 27th of September 21. Thereafter, on 14th of January 2022, a development agreement was executed between the plaintiff number 2 and the defendant numbers 2 and 3, which was registered on 15th March 2022. The relevant clauses of the development agreement has thereafter been set out in the body of the plaint. I will not place it from here, my lord. I'll show the document itself after I conclude placing the plaint itself. Lord, then if your lordship is pleased to turn over, lordship kindly note, my lord, the development agreement is annexed at page 106 of the plaint.
Yes.
Lord, accordingly, my lord, the power of attorney was also executed. And my lord, then if your lordship is pleased to turn over to paragraph 21 of the plaint, in terms of the development agreement and escrow agreement was also executed by the plaintiff number 2 and the defendant numbers 2 and 3. Copy is annexed, my lord. The development agreement also placed before the members of the defendant number 3 who approved the same unanimously. It was agreed by the members that from an unincorporated association of persons, the defendant number 3 would be converted into a registered and regulated entity. Accordingly, my lord, the minutes are also enclosed. Thereafter, my lord, in the plaint, they have specified, my lord, the COVID-19 situation which was faced, followed by, my lord, their applications before the Heritage Conservation Committee. Because, my lord, at the premises in question at Russell Street, there's a building which is a clubhouse which is already there. Now, my lord, the cause of action and attempt has been made by the defendant numbers 3 and 4 through their representative named in the complaint to have the same quashed by filing a writ petition. The plea was rejected. A copy of the order passed in writ petition is annexed. The criminal case is also pending, which is indicated. It is for the above reasons, that is the difficulty in getting initial approvals for development of the said premises, that an omnibus force majeure clause was incorporated in the contract. The force majeure clause is applicable to any event or circumstance which is beyond the control of the parties. Approval from the Heritage Conservation Committee was a circumstance which was beyond the control. Now, my lord, the steps taken by the plaintiff has been pleaded it in the paragraphs thereafter. Turning to, my lord, paragraph 54. In fact, my lord, paragraph 53, if I may be permitted to place. Paragraph page 45 of the application. The plaintiff states that the development agreement has not been terminated and is valid and subsisting. The plaintiffs had not accepted the unilateral termination by the defendant numbers 2 and 3. Paragraph 54. The development agreement is expressly not terminable. It is an irrevocable development agreement. Power of attorney dated 14th of March by the defendant numbers 2 and 3 to the plaintiff is coterminous with the development agreement. The said power of attorney is registered, it is valid and subsisting, and the plaintiffs have therefore not accepted the purported termination thereof. The plaintiffs, along with the other 3 named power of attorney holders, continue to remain the power of attorney holders of the defendant numbers 2 and 3. The wrongful refusal to perform the development agreement read with the supplementary agreement by the defendant numbers 2 and 3 has not been accepted by the plaintiff number 2. The plaintiff number 2 has always been and still is ready and willing to perform the development agreement and all terms thereunder. The plaintiff number 2 has not been in breach of any term or condition of the development agreement, despite having specifically applied to the defendants for performance of the development agreement. The said defendant numbers 2 and 3 have failed and or neglected or refused to do so, and have instead wrongfully issued the purported notice of termination dated 17th of May 2024 and or have otherwise wrongfully refused to perform the agreement. The said wrongful refusal has been accepted by the plaintiff. Inasmuch as the defendant numbers 2 and 3 are denying the validity and subsistence of the power of attorney, plaintiffs claim a declaration to that effect. Defendant numbers 1 and 4 as stated, inducing the defendant numbers 2 and 3 to commit breach of the development agreement. The defendant numbers 1 and 4 are inducing the defendant numbers 2 and 3 to develop the said premises through them. The defendant numbers 1 and 4 are thus invading the plaintiff's valuable rights by inducing the defendant numbers 2 and 3 to have the said premises developed through them. The defendant numbers 1 and 4, along with the defendant numbers 2 and 3, are interfering with the plaintiff's valuable right to develop the said premises. In accordance with the said development agreement, the invasion is such that compensation in money will not afford adequate. The plaintiff number 2 is therefore entitled to a decree for specific performance of the development agreement dated 14th January 2022, entered into between the plaintiff number 2 and the defendant numbers 2 and 3, read with the supplementary agreement. So, my lord, twofold praise of the plaintiffs in the suit. One is a declaration that the letter of termination is illegal, null and void, which is at page 50 of my application. The prayers are there, my lord. Prayer for injunction and prayer for specific performance. They have also sought for a declaration that, my lord, which, however, my lord, is at page 52, that the power of attorney is a subsisting power of attorney.
So whether this agreement can be treated as a joint venture?
Yes, my lord. That is where I am coming in.
It is a development agreement.
Development agreement where they have certain rights.
Can be treated as a joint venture. That is the
question. Is no, my lord. I'll just indicate what is the question.
Supreme Court has already decided with regard to the joint venture. That
yes, my lord. Supreme Court has decided on the joint venture issue.
Yes. What is the joint?
I am on the issue whether, my lord, this particular agreement of developing the premises with defendant numbers 2 and 3, where, my lord, the plaintiffs have certain rights under the development agreement and the defendants have certain rights under development agreement. It is not, my lord, that interse between the plaintiff and the defendant, the nature of user, whether it's residential or commercial, is in dispute. Interse between the defendant numbers 2 and 3 and the plaintiffs, my lord, the question is whether this is a contract which would qualify under, my lord, 2(1)(c) as a commercial dispute in the category of a transaction relating to immovable property. Now, going into, my lord, the aspect of, my lord, the documents which are next to the plain, the memorandum of understanding, the development agreement, and the supplemental agreement, I'll take your lordship through that and read. The same has to be read as part of the plain. Well, following Liverpool's judgment, my lord, the meaningful reading would include the plain has to be read with the documents annexed to the plain.
Correct.
Going into that issue, my lord, if your lordship sees the obligations and the counter obligations under the agreement are such, my lord, that the transaction is a commercial transaction. There are factors in the development agreement which, according to me, my lord, would make this particular dispute and the suit become a suit which arises out of a commercial dispute. And in such circumstances, my lord, this plaint should have been filed before the commercial division, taking the leave or after going through the entire process of mediation.
Show me which are the clauses
yes,
which
I will place the same. I will just indicate that.
As a profit, and there is a, as per the agreement, there is a profit.
Yes, my lord. I'll show that. I'll show that. Now, if your lordship is pleased to take the plaint with the document, my lord, the development agreement is at page 106.
Yes. It is your copy, madam. It is your copy. How it can be marked? Hey, suit आया नहीं क्या? हमारे पास नहीं है.
You have a extra copy of the plaint?
Because the suit is under scrutiny, so plaint has not come to this court. You have not annexed the document. You have any access copy?
Yeah, I'm just looking for it.
Extra copy, if you are having, please give that. Otherwise,
Printed copy or extra?
The problem is now everything is here. Achhe,
Well, may I do this, my lord? Maybe make a photocopy of the entire set and hand it
to
over
have,
to the-
Mr. Have given.
Grateful, Mr. So grateful, Mr. Lord. Well, I was actually thinking of coming, but in the meantime, I thought that would be the 11:30 matter would be taken up, so I couldn't come over.
yes. 106.
Yes, my lord. 106 is the development agreement.
Correct.
My lord, clause 3.1 at page 120, my lord. The owners hereby appoint the developer as the developer of the said premises and irrevocably permit and grant exclusive.
Where?
120, my lord, 120.
Yes.
Grant exclusive right and authority to the developer to develop the said premises by constructing the project thereat for mutual benefit. Lordship has that? For mutual benefit and for the consideration, not merely monetary consideration, my lord, but you will see what is the consideration, and for the consideration and the exclusive right to market, commercially exploit, and transfer the residential areas and do all acts and deeds and things to be done or cause to be done in connection therewith on the terms and conditions herein contained. Merely because, my lord, the property which is being constructed, going by Anumati, my lord, the agreement there was for the purpose of purchase of flats. Here, my lord, it is not covered by Anumati with the deepest of respect because it's a transaction for development between two on a principal to principal basis.
Yes.
Now, my lord, the developer hereby accepts the said appointment by the owners and has agreed to undertake, carry out, and complete the development of the said premises and construction of the project at its cost as per the building plan within the period mentioned hereunder, and to transfer the residential areas thereat in the manner as per the terms herein recorded. Clause 3.2 thereafter. On and from the effective date hereof, the developer shall acquire an interest in the project and have the sole and exclusive rights, authorities, and be entitled to develop and construct or cause to be developed and constructed the project at the said premises in terms of this agreement, to administer the entire project in the manner until the period as more fully contained herein, to the developer's share, to the entirety of the extra charges and deposits, to retain or transfer of the residential areas of the project and all other benefits and rights to which the developer is entitled hereunder. So, my lord, these are rights which flow from the development agreement in favor of the developer.
That is the right of the developer shares.
Yes, my lord, that is
get the benefit from his share. What is the ratio of the shares?
Yes, my lord, that I'll indicate to you about. Now, my lord, clause 3.3, the developer acknowledges and agrees that the existing clubhouse of the owners forming part of the premises is a heritage building. 3.4, my lord. The developer agrees to deal with the heritage building as permitted under the applicable law and in terms of the conditions imposed in the approval granted by the Heritage Conservation Committee of the Kolkata Municipal Corporation. Now, my lord, clause 3.5. This is the relevant clause. The parties have agreed that the project be constructed on the said premises shall be predominantly residential in nature. The developer will be at liberty to change the overall development mix at its absolute discretion without the consent of the owners, subject to total saleable area, super built up area to be comprised in the retail areas, not just Miller residential, also retail. In the retail areas, not being less than 90,000 square feet or more than 110,000 square feet. The retail areas shall be premium luxury retail project with all standard amenities associated with such a property, such as a state-of-the-art building, adequate escalators, elevators, HVAC, power backup, fully done toilets, signage, hard and softscaping, dedicated car parking spaces, car parking management system, and other specifications as recommended by the project architect. The retail areas shall have ingress and egress as detailed in clauses 15.4 and 20.1 herein, and shall have the frontage of Russell Street, the residential units, flats, duplex, apartments, etc., shall be completed a bare shell condition. It is hereby recorded that the proposed retail areas shall also include approximately 19,000 square feet of the heritage building standing at the said premises, which shall be renovated during the development of the said premises, as may be permitted under the applicable law. The developer, next plot 2.6, shall be entitled to market and sell the residential areas of the project, decide the price of the residential areas, and enter into agreements or execute deeds of conveyance and hand over possession of the residential areas to the residential area allottees. The parties have agreed that the retail areas in this project shall exclusively belong to the owners out of the owner's share, and owners in their exclusive discretion shall be entitled to let out, lease, sell, or otherwise deal with the constructed space, execute and register all necessary documents, and hand over possession to the tenants, lessees, and purchasers, or any other transferee, as the case may be. For avoidance of doubt, it is hereby clarified that save and except pass-through charges, the entire rent, sale proceeds, or any other receivable in respect of the retail areas, including the car parking spaces attached hereto, shall exclusively belong to the owners, subject to the compliance and of the terms and conditions of this agreement, upon due receipt of partial completion certificate issued by the Kolkata Municipal Corporation. The owners shall have the option of taking possession of the retail areas on its completion, and in such event, the owners and any person or persons claiming through, under, or in trust for the event, the owners and any person or persons claiming through, under, or in trust for the owners or their representatives, agents, and employees shall have full access to such portion from the date of possession without any hindrance from the developer or its contractors, agents, and representatives and allottees of the residential areas. In case the owners desire to sell.
Stop here. Now 12.
Very well, my lord.
It's covered. Issue by Mr. Ghosh wants to argue, my lord, is covered by a Supreme Court judgment directly and a division bench judgment of this Honorable Court directly. My lord,
then by judgment which?
In my lord, that Lord Griha matter.
Lord Griha Nirman versus Merlin projects.
He's aware. And my lord, Supreme Court, my lord, clearly says three things, my lord. Number one, this development agreement is not, my lord, a joint venture. It is not a co-adventure. So therefore, my lord, it can never be a commercial. The last thing hasn't been said.
And in another judgment, the development agreement has been defined by the Supreme
Yes. Supreme Court says this, my lord, that landowner has no right, my lord, to say how the development is done. It has no right, my lord, in management of the joint venture. So therefore, it's never.
So suffering for the plaintiff, so for the defendant. Defendant has filed an application being 3 of 2024 for rejection of plaint. Police counsel for the defendant has argued at length, but due to not be completed, let the matter appear on. Let the matter be listed on 12th March under the same heading.
Grateful.
Yes. Yes.
Sorry, my lord, I was not there.
No, there was some delay. This court from this court also.
Kindly, if your lordship is fixed, please.
You will not be available from tomorrow.
Yes, but I can do on virtual if your lordship permits me, my lord.
Time it's
order expiring. Today, if your lordship's list permits, then otherwise.
It's the total.
Monday onwards, any day, my lord, virtual I can do, my lord. If your lordship only gives me a time in the second half, any day. Because they are suffering an interim order, so they are in some urgency. I am not.
Difficult. How
any day other than 17th, my lord, any day other than 17th, any time, my lord. Or no time is also required, my lord, let it come in the list.
Top of the list.
18 तारीख को ना top of 19 17 आपकी 6 है
2 तारीख
Census suffering for the plaintiff, census is the commercial, na?
This is commercial.
Census suffering for the defendant. Full stop. Though the matter is fixed today as a specially fixed matter at 11:30, but due to paucity of time, hearing could not be, the matter could not be taken up for hearing. According case is adjourned. Let the matter appear. Time I am not fixing. I am.
Please, ma'am. We will be here, my lord.
It is a new. It's the adjourn motion, hai na?
Yes.
Adjourn.
Let the matter appear on 10th January, 10th March 2025 as adjourn motion at the top.
Grateful, ma'am. My lord, may I
and part as
my lord, may I pray for extension of interim order till that date because it is expiring on the 8th.
Counsel for the plaintiff submit that interim order granted earlier is going to be expired on 8th of March 2025. Accordingly, the interim order is extended till 21st of March 2025 or until further order whichever.
At the top.
Obliged.
Grateful, deeply obliged.
Yes, call the matter.
One more matter, my lord, for extension of interim order, item number 21. I've spoken to the other side. He was just here. He's gone for a matter. But that contempt matter, this
Which one?
21. It's only till today. I've spoken to Mr. Acharya. He was just here. Lordship keeps it any day, no problem. So that Ravi Sanai contempt matter, my lord, the interim order is till today.
As sensation suffering for the plaintiff.
Right. Yes, come.
Petitioner, sensation suffering for the alleged contemptor. Counsel for the petitioner submit that the interim order granted earlier is going to be expired today and prayed for extension of the interim order. In view of the submission made by the counsel for the plaintiff, petitioner then. The interim order granted earlier is extended till 4th of the commercial, non-commercial. Till 3rd of April 2025 or until further order, whichever is earlier, let the matter remain in the list.
In this matter, my lord, I appear for the alleged contemptors, Mr. Ghosh is
Which
there.
one?
The same matter where your lordship has extended the interim order. My lord, I'm only praying if your lordship could, my lord, fix the matter, my lord, for any day, because my lord, the urgent the situation is that, my lord, the suit has been filed, my lord, before the Alipur court. And there, my lord, the interim application is being heard. Interim application by the plaintiff is being heard. Yes, my lord, there's an ad interim order, status quo. I'm only seeking if your lordship could, my lord, fix the matter for some way, any day. It is running in the list, but my lord, yes, it may be. But
so no, if want I will fix the matter, then it will go to the last week of April.
Last week of April.
Last week of the April.
Then, my lord, I'll not make that. Let it be there in the list.
You're not finding any date in between.
I
Yes, call them.
Great.
Yes.
No.
প্যারাগ্রাফস গুলো একটা মার্ক করা ছিল
You understand? Yes.
blue mark করা আছে বলটা ওটা পরে আসছে Millard, so far as GA1 is concerned, Millard, I have more or less concluded my submission. 7 except Millard, there is one judgment I'd like to show as so far as GA1 is concerned. Millard,
Your Lordship, the Millard, Lordship will keep that for timing because Millard, my marked copy is somehow misplaced. So Millard, I'll come back to this. Millard, kindly now take Millard GA2. Millard, the reason why GA2 was filed, Millard, your Lordship will find.
GA2 filed by whom?
By my client. Millard, this, Millard, is
Interim order.
yes, in the nature of an administrator pendant liability. Now, Millard, that was necessitated because of the fact that during the pendency of this application, Millard, we came across, Millard, a will made by the deceased in respect of whom, Millard, the letter of administration has been sought.
Yes.
Yes. Millard, if you, I'm sorry.
Yes.
Millard, this will is a registered will, which is Millard was made and published on 11th of February 2020. Now we find Millard from the will that Millard, the deceased, Millard had his last desire to bequeath the properties to certain family trusts, as well as Millard to one of her sisters, excluding the other in its entirety for reasons given in the will itself. If I may just trouble your Lordship, Millard, with clause 8.
Page number?
Page 98 of GA2.
Will starts from?
Will starts, Millard, from 94. Millard, your Lordship will find will Damodar.
What is the date of the will? What is the date of the will?
Millard, the will of the date your Lordship will find at page 102, 11th of February 2020.
Yes.
Now, Millard, your Lordship will find the name of the testator, Millard, is at page 94. Kindly come to page 98, clause 8.
98.
Clause 8 at the bottom, Millard, the clause 8.
Yes.
Ludia Markaj.
Joint executors.
But 98 clause 8, I am unmarried and have no children.
Yes.
I have two elder sisters, Anushwa G. Pujara and Kusum Lakshmikant Asani. My sister, namely Anushwa J. Pujara, Millard, who had applied for the letters of administration, stays with her son and is well looked after by her sons. Thus, I do not wish to make any provision for her under this will. My other sister, Kusum Lakshmikant Asani, is widowed and stays with me in my residence. I wish to make appropriate provisions in this will to ensure that my said sister Srimati Kusum Lakshmikant Asani is financially secure and stable and is liable to lead a secure life after my death. To this intent, I wish to make the following provisions for my said sister, namely Kusum Lakshmikant Asani. I give, devise and bequeath the sum of rupees 25 lakhs. I direct the joint executors to put such amount in a fixed deposit or in appropriate money. So and so, my lord, this direction is not necessary. Then, my lord, kindly thereafter, last 4 lines. If it would not be legally permissible for the said 5 nominees, then the joint executors shall nominate themselves and on the death of my sister distribute the proceeds to the 5 trusts in the same percentage of share as mentioned in clause 11. Then, my lord, I direct the said joint executors to ensure that my said sister Kusum Lakshmikant Asani is comfortably shifted to Mumbai for staying with her daughter who stays at Mumbai and shall take care of her mother thereafter. Cost of expense of travel and shifting Mumbai would be borne and shall come out of the estate. I am the owner of various movable and immovable properties, including shares, mutual funds, such and such jewelries. The jewelries are kept in locker number such and such, the State Bank of India, Lamatnia branch. Subject to bequeath in clause 9 of this will, it is my wish and desire that after my death, all my residual assets and properties are settled and bequeathed in favor of 5 trusts, namely Jerambai Seva Trust, and the 5 trusts are there. The proportion in which, my lord, the trust would have got the properties are indicated, my lord, in paragraph 11 itself. And, my lord, the residual clause, which is clause 15, my lord, I give, devise and bequeath the rest and residual of all my movable and immovable properties, whatever, whenever situate, to the said trusts in accordance with my wishes under the said will. So, my lord, whatever is the estate, first will go to the sister. One sister has been completely, my lord, provided for. The other has been kept outside the purview of any inheritance under the will, and the residual will go to the trust. This was the desire. Now, my lord, what is, my lord, I don't make any allegation, but I think that what I'm trying to say is that if this fact was before the court granting letters of administration, whether the court would have inquired into it or not. Is it worth inquiring? Let kindly come to page 97, clause 2. Okay. I appoint Mrinal Kanti Roy, so and so, son of late such and such, Indian by occupation such and such, and Mr. Ajay Kumar Chaudhary, son of such and such occupation, to be my joint executors of this will. Now, if your lordship, my lord, ki bolcho clear to? Ajay Chaudhary na Pita? Okay. Now, my lord, 2 things. The backsheet bar karo, petitioner backsheet bar. Lordship, my lord, kindly see page 22 of GA1 with page 102. My lord, kindly, sorry, my lord, not, very well, my lord, your lordship will find page 22 at the bottom, petitioners for the advocates is the same who was the executor.
Who is?
Who is the executor? My lord, the executor
Ajay Chaudhary.
Ajay Chaudhary, who is an advocate, my lord, had filed the letters of administration.
Just choke the dick like lift and email. And he's going to submit for till 115 years.
No,
Taking the risk. Okay, no problem. You can.
So, my lord, this executor
Yes.
This executor, as on the date of applying for letters of administration, knew that the person who is seeking letters of administration was kept outside the purview. That was the desire. Now, my lord, if your lordship sees 102 of the GA2, GA2 102,
Yes.
the first attesting witness, who has also drafted the will, advocate,
Yes. Parthaban.
my lord, I believe, my lord, I don't want to take the name in open court, my lord, lawyers are involved. Both are advocates, my lord, having the same address at Nico House. Both are two lawyers, attesting witnesses, and one of the attesting witnesses has drafted the will.
Yes.
Now, my lord, I have stated on oath in the petition that Preetha Basu, who is the attesting witness and the draftsman, my lord, is junior working in the office of
Chaudhary. Chaudhary.
I shall just read. Paras of GA, para 7 of GA2. The LinkedIn profile the कागज लगी छोटे opposition ने take
Yes.
so, my lord, a chain is now being established. Executor was there. Junior had made the will. Now, when I come up with this, they in their affidavit in opposition, can I only take the affidavit in opposition? Hey, opposition is annex করেছিল annex sir.
Affidavit
Kindly take
opposition
the
of GA2.
of Nirmal Pujara.
Of GA2.
GA2.
Paragraph 7.
They say that the deed of revocation was executed by the testator and therefore the will was not there. But what is very interesting, my lord, is this deed of revocation, my lord, has been, my lord, if your lordship sees, is also drafted by the same advocate at page 7. And my lord, now kindly permit me to place the deed of revocation. It's only half a page document. My lord, first page is, my lord, his description. Kindly come to, my lord, page 7. I had executed my last will such and such, which I appointed so and so as joint executors of the will. The said will was registered in volume such and such in the office. And whereas for personal reasons and consideration, it has become necessary for me to revoke the above mentioned will. Nothing more, nothing less.
Yes.
So, my lord, the testator, if assuming my lord had free will and consent to revocation, my lord, did not indicate as to the sister who, it has nothing to do with the sister. But kindly visualize this. If your lordship takes the stand in the affidavit in opposition, your lordship will find their stand is that under under section 8, read with class 2, the sister is the only legal heir. So therefore, if this will gets revoked, she has a right, and that's why she comes and says and claims that this entire estate should come to me.
That's a revocation.
My lord, as I say, my lord, had this fact been before the letters, before the court granting letters of administration, would the court, in my respectful submission, would have inquired into it. More so, when the executor named in the will has her junior drafting it, but that's not material, has filed the application for letters of administration. Now, my lord, coupled with that, there is another question. All these sisters, my lord, are in their late 90s, 80s and 90s. I was just thinking as to how they could catch hold of a lawyer to start with. So therefore, that boils down to, my lord, somebody had got them contacted to the lawyer. Which my lord, I don't say so in so many words, but it's before your lordship, my lord. I cannot say so because I cannot establish it because the court did not take evidence. All I'm trying to say is that had this fact been there, would the court have allowed it to be ignored, or would it have observed or inquired into it?
Yes.
Because, my lord, the presumption in law is that an unprivileged will cannot be revoked until and unless in the manner, that is section 70 I had indicated on the last occasion. So, my lord, I leave it at that. Thereafter, my lord, I don't develop my arguments because that would be conjecture. So, in these given facts, my lord, the question that arises is whether it was the duty of the person who is applying for letters of administration to bring this to the notice of.
To disclose the facts.
Yes. That this he had made a testamentary disposition. Thereafter, if you are so sure that his intentions were good and honest, then he would have come forward and said that this will was there, this is revoked, and hence, because the person who is getting deprived, the individual sister who is getting deprived is not being cited.
In terms of this.
Yes. So therefore, the person who is deprived is not getting cited. He is claiming the person who was not given anything under the will is getting everything under the will without citing the person who is being deprived.
Yes.
Now, my lord, on this, I just cite one paragraph. There is a very celebrated judgment. All India Reporter 1958 Calcutta, page 377. My lord, in your lordship's copy, my lord, my junior says it would be paragraph 26, which starts with the next ground on which.
(26)
Yes, my lord. 26.
Yes.
My lord, does it start, my lord, with the words the next ground on which revocation? Yes, my lord. The next ground on which revocation of probate is claimed is that the circumstances connected with the execution of the will are suspicious. Here, my lord, the will was there, the executor did not come forward. Learned counsel for the appellant said that the principle of Tidal versus Painton applied. That case confirmed the well-known rule of testamentary courts that where a will is prepared and executed in circumstances which raise the suspicion of the court, it ought not to be pronounced till all traces of suspicion are removed. As I have already stated, a revocation of probate can be granted only under 263 of the Succession Act, and it is not one of the reasons for revocation. It's not there in 263. Revocation, where there expressly mentioned that the will was executed in suspicious circumstances. It may therefore be argued that the revocation cannot be ordered merely on proof of suspicious circumstances. But it seems to me that it would be wrong to accede to such an argument. A creditor attacking the genuineness of the will as the appellant in our case would, if he had notice of the probate proceedings, have been entitled to appear and oppose the grant. This right was recognized in Kishan Dai's case, and I have already said that to this extent, I have no difficulty in accepting that case as a correct decision. It would, in my view, be strange reasoning to say that a person has a right to apply for revocation of a probate, but has no right to oppose the grant of it, for its rights in both cases arise upon the same facts. It would be illogical if he were compelled to wait till what he objected to was done and then only permitted to come in and apply for undoing of it. Now, then, if the creditor opposed the grant and showed that the circumstances in which the will was said to have been executed were suspicious, the court would have acted on the principle of Tidal versus Penton and would have refused probate. It seems to me to follow that where a creditor comes not to oppose the grant but to ask for revocation of a probate already granted, the position would be the same. And if circumstances be such that the court would not grant probate initially, it would in the same circumstances proceed to revoke the grant. It seems to me that a case which can be brought under explanation B in section 263, which provides that a grant can be revoked where it has been obtained fraudulently by making a false suggestion, or, I come here, by concealing from the court something material to the case. Then is very important, my lord. The circumstances throwing suspicion on the due execution of the will are, of course, material. And if they have been kept back from the court, that would be a good ground for revoking the probate.
Yeah.
So, as I say, my lord, this, according to me, is suspicious. This judgment says that I had a right then also, otherwise. So, if I had a right then, I have a right now also. If I have a right now and I can show before the court that the person who has the lawyer had not withheld these things, my lord, then it is a good ground for revocation. Now, my lord, the reason is my learned friend in his affidavit in opposition said that I have not indicated it because it was revoked. Can be. So, my lord, if he is so sure on his stand that there is no question of any suspicion, then is all the more reason, my lord, he should have come up and said that, look, there was a will, these were the beneficiaries, it has been rightly revoked, and therefore I am saying. But to withhold this information from the court, and now when I bring it, my lord,
concealing
it, my lord, it's concealing. So, this is one ground on the basis of which we say that in the event in the event my application is allowed, my lord, GA1 is allowed, my lord, then there should be an administrator pendentility because the estate over which my learned friends clients have obtained administration, my lord, contains huge amount of jewelry and movables and all. So therefore, my lord, on that basis, my lord, we had made this interlocutory application, but your lordship's desire was to hear all of them together. Even if, my lord, one gets disposed of, my lord, till such time, then what will happen? If one gets disposed of, he has to come and prove everything. So even then, my lord, in those circumstances, till such time, my lord, he comes and establishes his right. My lord, such protection of the estate is what we are praying for in GA2.
But this situation, if it is allowed, revocation has been made, court has passed an order for revocation. And already administration has been made, completed. Administration is completed.
Yes.
And the what would affect with regard to the articles which they have obtained?
Millard, so far as administration is concerned, Millard, my learned friend in his affidavit has said that I have filed accounts and administration is complete. Millard, with respect, Millard, there is nothing on record to show that whether administration, even if he is the executor and if he is the beneficiary, which is appears to be, then Millard, even there has to be an asset to legacy, or there has to his mother was, there has to be some document to show that the mother had been handed over everything and there is an acknowledgement registered in writing. And also and Millard,
because administrator pendant land, it's okay. But what if it is administration is done? So what would be the effect of the, because this is the gold ornaments and the amounts.
So the he will have to account for where it has gone. Because he is the beneficiary, because his mother, Millard, his mother was the sister. Now, Millard,
why I'm telling,
my lord,
if suppose the court is revoked the will, then they have to surrender. Court the probate.
Probate has to be surrendered.
Court the probate or letters, whatever, it has to be surrendered.
My lord.
If it has been surrendered, it has come to zero. If it has come to zero, it is the duty of the executor has to return the all benefits to the court itself.
My lord.
Where from they got.
My lord.
Correct. And at this stage, if the administrator is appointed, for what?
Administrator for
unless until it has to be see whether they have returning the materials back to the court as
Millard,
it is, then the administrator.
Millard, it's like this, Millard, when we ask for decree for specific performance, we say either you execute, telling which the register will execute. I'm saying something like either the probate is revoked, he has to return and account for it. If he doesn't, then the administrator will.
That's why, because you are, so whether at this stage your GA2 can be taken into
Millard, the thing is this, Millard, when GA2 was filed, at that stage, Millard, there is no affidavit in opposition in GA1. So, Millard, we proceeded on the basis that nothing is done. Even today, we have no reason to believe that administration is complete because there is nothing before the court, except for the statement. So, therefore, I proceed on the basis the estate has not been administered. Millard, what will be administering? They took possession after the mother, that jewelry is now he is claiming on the basis of the authority that he has given. He has to stop doing that and he has to account for the fact that as on the date, whatever inventory he has filed in court, that the inventory is there. If he has mishandled the estate to the extent that if he has parted with some of the jewelry and all, then in that event, Millard, the parties will have to file a suit if at all for recovery. That is all. So at that point of time, we did not know. Even today, we do not know whether the administration is complete, and if it is complete, in what manner it was complete.
Okay, let me see.
So therefore, as I said, Millard, the initial direction can be on him if I succeed. Then thereafter, failing which the administrator. But at that point of time, since we got an apprehension that this jewelries can go away, we came and filed an application that immediately appoints somebody to at least take custody till such time this issue is decided. That was the apprehension. Now, Millard, kindly take the opposition once, Millard. I just need to show
opposition of GA2.
Yeah, GA2. There is no opposition in GA1. Millard, the reason why I'm just very hurriedly, Millard, place what the case he has made out in paragraph 3. Paragraph 3, Millard, his first objection is application being say is malicious, Lordship can ignore it. There is no locus to ask for the orders. This, Millard, I have covered by the 2 Supreme Court judgments that caveatable interest is not necessary. Then, the entire properties of the deceased have been dealt with under the auspices of the High Court and the final accounts have already been submitted. There is no annexure. There is nothing before the court. I state that it has been attempting to delay the disposal of the pending proceedings. What is disposal if according to him, 3 and 4 are contradictory? What is there to be disposed if he has already administered and filed accounts? So I don't know what he means by D. Then I say that the petitioner is now attempting to rely upon a will dated such and such and register. I say that subsequently honor about such and such has himself revoked such will by a registered instrument such and such, a copy of the instrument. Under the circumstances, the application so and so is liable to be dismissed. And so far as my allegation in paragraph 7 that there is a connection that has not been denied. That has not been denied.
They have only taken that has been revoked, so there is no necessity to disclose that.
So that is the only point. The only last judgment I'd like to cite, Millard, is Millard, a decision of the Millard. I just handed over a copy to start with. Millard, this is of a Rangoon series, Millard. The judgment.
Yes.
Question framed is at page 40. Well, at the question framed is, oh, I had a copy then, Baba. At copy. Well, at the question framed in this judgment is at page 40, middle. Well, if I fix the following preliminary issue of law.
Page?
Well, at page 40. Well, at the top, your lordship will find the
40, yes.
Well, would it be my lord's pleasure
Fix the
to
following preliminary issue.
permit my junior to place because he's marked the, I've lost my copy.
Yes.
So he's placing for us. Lord, kindly, my lord, takes page 40 first. About the roundabout, the bottom of the page, your lordship will find, by consent of the parties, I fix the following preliminary issue of law. And the issue is, can letters of administration be granted to the surviving member of a joint Hindu family in respect of the property of that family? Your lordship will recall paragraph 1 of their application says, these member of the Mitakshara law. Then kindly carries on. The argument was addressed to the case of a joint family governed by Mitakshara school. And the issue should have been limited accordingly. And I think it should be further limited to an application for general letters of administration, such as the present application. If the issue is answered in the negative, the plaintiff's application must fail. When it was a general application for letters of administration, this is also a general application. But kindly turns over, come to page 41, the last paragraph, page 41. Starts with the principles of Mitakshara law. The principles of Mitakshara law applicable to the case of a joint family are clear and are not in dispute. I need only briefly refer to the passage in the textbook which have been cited to me. In my lord, Trevelyan's Hindu law, second edition at page such and such, it is stated, very important, that a male Hindu acquires by birth or adoption a vested interest in all coparcenary property, whether ancestral or not, and whether acquired before or after his birth or adoption as the case may be, held by his father or father's father at the time of his birth, or adoption as the case may be as a member of a joint family during their lifetime. Those persons who by birth or adoption so acquire an interest in the coparcenary property are called coparceners. 3 generations, your lordship knows. Then, and again, the interest that a son acquires is equal to that of his father, but separately and independently of his father. He has no
independent dominion.
Yes, dominion over the property. On page 236 of the learned author says, on death, this is what I am relying on the death of a coparcener, his interest in the coparcenary property does not pass by inheritance. It lapses, or as is generally put, his right passes by survivorship to the other coparceners. So it's nothing is inherited. Paragraph, and my lord, I'm not, kindly see thereafter, paragraph 417 of Maine's Hindu law, 9th edition, dealing with the extent of testamentary powers, states that a member of an undivided family cannot bequeath even his own share of the joint property, because at the moment of death, the right by survivorship is at conflict with the right by device. Then the title by survivorship, being the prior title, takes precedence to the exclusion of that device. I would refer also to the decision of Privy Council in Lakshman Dada Naik versus Ramchandra Dada Naik, and more especially to the remarks of their lordship at pages 61 and 62. Then last,
Applying these principles which I have said are not in dispute, I am of the opinion that a coparcenary property cannot be said to be part of the estate of a deceased coparcener within the meaning of section 218, because on his death it vests by survivorship in the surviving coparceners, and therefore there is no estate to be administered. So the letter of administration does not lie. Now, my lord, further it may appear too that just as the deceased coparcener cannot die testate in relation to coparcenary property, so he cannot die intestate in relation thereto, because at the moment of his death, his interest therein passes by survivorship to the other coparceners. So the moment, my lord, kindly may I give an example at this juncture, my lord. He has two houses. One house is his made by acquired with his own funds, own property. Other house is a coparcener because it's his not family property. So, my lord, and I will read later on, the house which is the coparcenary property, the moment he dies, nothing survives. The other generations automatically become coparceners. Yes.
Inheritance.
Inheritance. No, my lord, I'm sorry to say, by survivorship.
Correct.
That is the term used.
Correct.
So, my
Survivorship.
lord, if you do not leave behind anything and automatically on your death somebody else acquires a share in that, but nothing remains to be administered. And hence a letter of administration in respect of properties which are, my lord, coparcenary properties, which are, my lord, properties governed by Mitakshara law.
No, that's why, Mr. Dutt, I am finding here, because in the district judiciary, when I was used to appear, there was no written letters of administration by if there is no objection or a single family. If it is single family, if you are having the right, you have to go to the civil suit and declare the title.
If there is a dispute.
If there is a dispute, or otherwise it will automatically. It will automatically, because I here find even the husband died, wife is filing an application for administration, and the legal heirs are giving the
Because the Bengal follows the school of
Dayabhaga.
There, my lord, on demise, either by inheritance or, my lord, by testamentary disposition. In the Dayabhaga school, my lord, there is no concept of coparcenary. So that's why, and my lord, people, my lord, who come and settle here, my lord, since it's personal law, they carry their personal law. So that's the reason, my lord, in cases of Mitakshara, this law is different.
Because that has not been pleaded in any of the cases with regard to the Dayabhaga.
Reason, my lord, is that because, my lord, the reason why it's not pleaded, my lord, it's not always that a Hindu carries his personal law with him. He can give up, my lord, and can adapt this.
Correct.
So therefore, my lord, it's a question of evidence. So whether you are governed by Dayabhaga school or Mitakshara law, but here, my lord, it's an admitted fact. He says that I am Mitakshara.
Okay.
So, my lord, page 43 kindly, my lord, allows me to carry on. I am, so my lord, the last sentence in first paragraph. I am of the opinion, therefore, that the plaintiff's application for letters of administration must fail. First, because he is not a person interested in the estate of the deceased, and secondly, because the deceased left no estate in respect of which he was intestate.
Survivorship.
That is by survivorship. So, my lord, no distinction is made in this application. Which all properties are his, my lord, self-acquired properties, which all properties are my lord, coparcenary properties, and he has got, my lord, administration over everything. Now, my lord, kindly, my lord, it's my duty to point out, I am not troubling your lordship with the other decisions that have been relied on. Kindly come to page 51, because this is the decision from which it was appealed from. Kindly come to page 51. And finally, the appeal court has, my lord, concurred with the finding of the learned my lord, court of first instance. Kindly come to page 51, the last but one paragraph.
Yes.
My lord, will find, my lord, my answer. It starts with my answer to the issue is that general letters of administration, exactly this case here, such as are applied for in the case, cannot be granted to the surviving member of a present joint Hindu family governed by Mitakshara school in respect of the property of the family. His lordship dismissed the application with cause, the petitioner appealed. This was the order under challenge. And now kindly see, my lord, what is the final, my lord, finding, page 59. Page 59, the, my lord, reasons of the appeal court.
Yes.
Lord, second paragraph, if I may please. We do not understand the correctness of these principles to be questioned. A member of an undivided Hindu family during his life is entitled to the beneficial interest in the family estate, but on his death, that interest immediately ceases, and the whole beneficial interest in the estate belongs to other members of the family. There is no succession to the deceased estate because he has left nothing to succeed to. No part of the joint family estate is therefore the deceased estate within the meaning of section 218 of the Succession Act, and it therefore seems to us to follow that a member of a joint undivided Hindu family is not as such a person entitled to under section 218 to an administration of the estate of a deceased member of the family. It is the law.
Survivorship.
And my lord, as my lord senior has already cited, my lord, after 56 Act, even the daughters, my lord, now.
Come on.
Yes. So, my lord, my client, my client's husband, and thereafter my client who has made the application would have immediately succeeded to these to the joint family estate. And my lord, this entire administration, without this distinction, that which are his personal property and which are, my lord, his co-personary property, could not be granted as a blanket, my lord, administration over all the properties. Let my lord senior.
That's all. Thank you.
My lord will fix any date, my lord. I was requested by Mr. Ray to fix any date other than 12th. Other than 12th of March, my lord. Any day other than 12th.
Consensus suffering for the applicant. Consensus suffering for the executor. What you for executor?
My lord.
You are for the.
But I am for the son of the applicant for the letters of administration. Applicant has passed away, my lord. I've been many persons have named in the master summons.
Applicant of the letters of administration. The counsel for the applicant has concluded his argument.
Master summons है 5 का.
Let the matter appear. कौन सा डेट है 14 13 13 14 13 बुध बृहस्पति है ना 12th is
Other than 12th, my lord.
13th
14th, I छुट्टी तो.
13 March. 13 March.
Millard, my juniors say, Millard, that there are 2 sons left by the person to whom the letters of administration are granted. One son has obtained it, the other son has.
My lord kindly mentions the name Nirmal Pujara.
बोला ना निर्मल पुजारा. Namely Nirmal Pujara. Nirmal Pujara.
The 1958 Calcutta nominations are articles.
Mr. Chaudhary is
Well,
just
my
he's in
witness
the
is
lift, my
taken.
lord. Kindly give me 1 minute. Mr. Chaudhary
Okay,
is in
no
the lift,
problem,
my
no problem. Court is
My lord, he is taking a lot
is
of
fast.
time, my lord. My lord, you only pray, let my learned counsel tell which day he will finish off. My client goes here and there every
7-8 days of
7,
cross.
8 to 10 days of cross question,
Testamentary.
testamentary suit, my lord.
Let me see. Let me.
Nowadays, my lord, if one of my lord's fixed matters are not taken up, and if this is the lawyers get information earlier, now it's in the WhatsApp group. So that's a very important news. It goes in the WhatsApp group like
this matter will
yes,
not take on.
no, code 36 fixed at 2 p.m. has been adjourned. Everybody be aware. Yes. So it's like
Havoc.
yeah, be cautious so that other matters will be taken. I mean, it's in the it's like Akashvani is giving a to the public announcement. Mr. Sinha is very prompt on these. Yes, he's very prompt. Too much of excessive.
That's why, because if once has been adjourned, so other matter can be adjusted. So and
It's excessive. With this, our code 40, 41, 39, 40. This. As criminal revisions have gone in, my God, the 2 days gone.
total all courts are over.
All
but,
courts.
all courts are over, but it is
Waiting
not
for
one court.
waiting for 5. Something better than nothing. Right?
And it will be done. I think next
will be
by next. I think.
Okay. Minimum 10 is required, but still, what? It's impossible. When civil revision, if 5-6 days are over from the order you have challenged, then it becomes infructuous. Court is proceeding.
What can be done? Civil division, immediately.
Immediately before the next date.
Next date, because the trial court will not stop.
Supreme Court order you cannot stay unless there is a proper stay. Trial court will give you one date at best, one adjournment, not more than
because they are also binding.
They are also binding. Data, national data, and all these things.
Also binding.
Sure. Go.
Start.
Ready? Go.
You will start.
Yes, your lordship. My senior is coming in a while, but I can start.
Okay, no problem. No problem. Resume, huh? Cross examination.
Mahesh Kumar Kejriwal.
Shown question 512 of the cross examination of the deposition of the witness. 512.
Question 512.
Yes, sir.
Are you now in a position to produce the balance sheet, director's report, auditor's report, and company secretary report of Kejriwal Mining Private Limited from 2004 to 2015?
512 क्वेश्चन नंबर में आपने कहा था कि आप आज के दिन ये डायरेक्टर्स रिपोर्ट, ऑडिटर्स रिपोर्ट, कंपनी सेक्रेटरीज रिपोर्ट, बैलेंस शीट केजरीवाल माइनिंग प्राइवेट लिमिटेड के 2004 से 2015 तक का आज आप दे पाएंगे। क्या आप आज वो सब लाए दे पाएंगे?
हम पहले ही दे दिया था।
I have submitted that earlier.
Until it was given to us, there was on the last day they were supposed to send a letter asking these documents. The letter did not come, so we have ready set. We can.
Can please mark
This
this.
may not record. I have already given to my learned advocate. Then bracket then. The learned counsel for the plaintiff has handed over the said document to the learned counsel for the defendant in court, in open.
This must be exhibit bulletin. Let this set of documents be marked as exhibit.
It is not exhibited?
No, your lordship. It is not been exhibited.
We were supposed to give it 2 sessions back, my lord. Last time when I asked him questions, he said, I've given it to my advocates. So I didn't pursue. Now, advocates could have given it earlier. Today, he gives the documents. This is the only difficulty. A
No, no,
witness.
they were supposed to give us a letter asking for those.
Why should I?
No, no,
I've
that
asked
was
the
the
witness.
understanding that you have to produce it. And you kindly send. My witness has said, I've given it. No letter came from you asking for this.
Settle between both of them. The court will not interfere in that. Okay, continue.
Impossible. If I had been a part of it, I would have called up and requested what to do. So ego is mushkil. Exhibit R. RR.
Where is the document?
Yes, Milord.
Document is to be placed here. That is.
Copy thou.
Hard copy আছে? Yes.
Let this be fine. But it seems to be a more fresh copy. Let this be fine. Now the chena.
ঠিক আছে।
Exhibit
R.
Here.
ঠিক আছে, আমারই ছোট।
कोई मैं देख रहा हूँ। हाँ, record. The document produced by the witness
I think
as from page number 1 to page number 210. 210. Altogether 11 documents as appearing in the index are marked as exhibit RR. RR collectively করবে, হ্যাঁ?
I'll just take 1 second. In the documents that you have disclosed as exhibit RR, is there any key managerial person indicated? A key managerial person of Parijat Vyapar Private Limited indicated?
या अभी आपने जो डॉक्यूमेंट दिया है इसमें क्या किसी की मैनेजरियल पर्सन ऑफ पारिजात व्यापार प्राइवेट लिमिटेड का कोई की मैनेजरियल पर्सन का बारे में कुछ है बताइए।
बताया नहीं होता। अब आर्टिकल
नहीं है।
No.
Is it a statutory requirement to indicate key managerial personnel of a company?
हमको नहीं पता है।
I don't know.
I do not know.
I do not know. না এখানে গন্ডগোল আছে, পুরোটা নেই। Did you then I'll have to check these documents. Don't seem to be the complete set. Let me finish with the rest of my examination. I'll just keep this back.
You complete it only with regard to
Only with this I'll come back. Otherwise I am.
You complete that.
হ্যাঁ বাকিগুলো করে দিই। Shown question 113. And your answer. Are you in a position to disclose this document today?
सर क्वेश्चन नंबर 113 में जो डॉक्यूमेंट्स ये कहा गया था, क्या आप ये डॉक्यूमेंट आज प्रोड्यूस कर सकते हैं?
हम ऑलरेडी ये डॉक्यूमेंट्स अपने वकील साहब को दे दिया।
I have already submitted the documents to my advocate.
The record, the learned advocate has handed over the copy of the said document to this court as well as to the learned advocate appearing for the defendant.
এটা কত SS তারপর হলো এটা তো
Exhibit S.
SS shown question 126 and answer thereto. Will please produce. Are you now in a position to produce this document?
क्वेश्चन नंबर 126 में जो डॉक्यूमेंट आपको प्रोड्यूस करने के लिए कहा गया था, आप क्या आज वो डॉक्यूमेंट प्रोड्यूस कर सकते हैं?
हम पहले ही दे दिया था अपना वकील साहब को।
Yes, I have already submitted this document to my advocate.
Same. Learned counsel for the plaintiff has handed over the same to this court as well as to the learned advocate appearing for the defendant. TT.
Shown question 463 and answer to the same. Are you going to produce your call records?
क्या आप अपने कॉल रिकॉर्ड्स प्रोड्यूस करेंगे?
नहीं।
नो।
बस yes. Oh, last one. Shown question 422 and answer thereto. Will you please produce these bank statements? Bank statement. मुझे समय लगे।
क्वेश्चन नंबर 422 में जो बैंक डॉक्यूमेंट्स के बारे में कहा गया है, क्या वो डॉक्यूमेंट्स आप प्रोड्यूस करेंगे?
नहीं सर, ये डॉक्यूमेंट्स नहीं मिला, नहीं प्रोड्यूस कर पाएंगे।
No, I cannot produce this document as I could not obtain this.
2009 का है, ये नहीं कर पाएंगे। This is of 2009.
This is the document of 2009 and I cannot obtain it.
Not just half an hour on any day. That's all. I'll just all the documents which he has given and just see. Have 5, 10, 7, 8 suggestions are there, and maybe if any question, just 20 minutes. Any day, my lord, convenient to your lordship.
And further evidence, you are having further evidence?
Now I will have evidence.
I will not for me.
Huh? It is a তখন দেই করে দেবো।
So you will produce the witness on that day?
No, my lord, half an hour, 45 minutes. Let it be over.
Suffering for the plaintiff, suffering for the defendant. Plaintiff witness is present. Cross-examination resume. During the cross-examination, 3 documents were marked as exhibit RR, SS, TT. Counsel for the plaintiff, counsel for the defendant, press for time to further cross-examine the witness on the document that is exhibit on the document produced by the witness today in the
and
court.
certain suggestions
And further cross-examination. In view of the submission made by
Otherwise,
the
it's
counsel
over.
for the defendant, cross-examination of plaintiff witnesses deferred. So please the matter, give the date. 30 April
তুমি যদি
at
আমাকে এরকম situation না,
3
you ask me, I
30
will
April at 3
call
p.m.
you up and ask you.
30 April 3 p.m.
3rd April.
30.
Oh, 30.
Unless, my lord, we can get these criminal matters out of your lordship's court. We are trying very hard.
Yes. Committees.
We are trying very hard. And interlocutory court with criminal matters is impossible. As it is, my lord, we don't have time.
Unheard.
Interlocutory with suit.
As it
Any
is.
event. Interlocutory with suit.
Testamentary.
The testamentary, okay, ठीक है.
Testamentary is fine.
Fine.
Testamentary is okay.
Testamentary is okay. But
No, I'm
suit-
telling.
But testamentary interlocutory. Only
Testamentary
not
really,
testamentary doc.
testamentary really doesn't come to court much. You know, previously it used to be in, when we have
Absolutely
seen it was in
department.
chamber. Then, my lord, it was felt that having regard, my lord, to the fact that times are generally bad, there is no hesitation in making absurd statements. Therefore, in court. Otherwise, traditionally,
I have always seen that it is always a department. It's all done in the department.
and department goes to your lordship's chamber, your lordship signs.
Justice Indira Banerjee was the first in interlocutory court. The list started coming out.
You do it in court.
In
At
court.
least people can't make aspersion.
So they are in the court,
That's
public can see it.
Now, when I have been given the determination, then I find that the fiat. Then I said, okay, it is in the original side
It's a
rule.
fiat.
But once the probate is granted, and many of the matter is coming for the revocation, we could
Yes.
not get the order.
There is no order for the endorsement.
It is better.
So that's
What
why
nonsense has appeared in the probate department, we have
that's
also
why
heard.
I find.
Yes.
Now, initially they brought me. Sir, इसमें sign कर दो. I'm not sorry.
List with the which
The most dangerous thing.
revocation.
That's
There
why
is no order.
Only
for
4 or 5
revocation.
things is to be seen. So sitting here within 5
Better.
minutes.
2 minutes. Pass a small order, half a page order, but it's an order.
And to criticize take 2 minutes.
Yeah.
Yes, Zoe Baba.
And criticize 2 minutes, but it
Far reaching consequences.
Yes.
okay.
That is the problem.
Obliged.
Thank you.
Great.
30th April.
देव कौन से पासवर्ड कोई आएगा तो आएगा. Inform Mr.
Yes. Sinha. Sinha.
मैं fixed matter हुआ.
Yeah. I should have done earlier only.
CSOS.
Miller 13 Miller, I appear for respondent number 24. Miller, this is Miller an application Miller, I believe Miller filed by respondent number 10. Miller under order 7 rule 11. Miller challenging the maintainability of the suit. Now Miller, we have also filed Miller the maintainability application. Miller that has gone the Miller as Miller in GA number 3.
Which one? Which one?
Now Miller item number 13 Miller. It's Miller the order 7 rule 11 application Miller filed by respondent number 10.
I want
Now
to.
Miller, I appear for respondent number 24. Miller, I am sailing in the same boat with the applicant.
You also filed.
I have also filed Miller. That Miller had Miller passed Miller directions for affidavit. Affidavits are complete.
That is a J3.
J3 Miller that has gone down in monthly list. Monthly list item number Riyaz Khan.
No, I will correct this. I don't know why it is going here and there. And this is a GA4 who is appearing for the 10.
GA4 has been filed by Shuvrodal Chaudhary.
Defend number 10.
For defend number 10.
So you will file affidavit.
I want to
in this
file
also.
affidavits, my lord.
And with regard to Mr.
Miller, those are complete. Those are complete. Complete. Miller, it is item number. Miller, my is item number. Miller, 129
of
to
the
131 of the monthly list, non-commercial. So Miller can take back in the daily list any day. Miller,
suffering for the plaintiff. Let
I
it
appear
the J3, J4 along with because let this
They can be heard together then,
Yes,
my lord.
can be had together. Miller, I believe Miller, Mr. Shaha is Jishu Shah is appearing. He is
Okay.
seeking request, my lord, to get online from your lordship's operator.
देखो जिष्णु sir.
He is online already. I can see Mr.
Yes,
Mr.
yes,
Saha online already.
He is seeking request, my lord. I just saw that he messaged.
Main
that
person
that-
did not realize your lordship would be calling on the matter now. Well,
Yeah, Mr. Shah is there.
so far as this matter is concerned, well, I have only very small request. Well, so far as this is concerned, it's my application for rejection of plaint.
Yes.
But it has to proceed on the basis of the plaint itself. Well, no need for filing affidavits in this matter.
I need to file, my lord.
If your lordship is satisfied that
Annex.
my lord, the plaint should be rejected, then it will be rejected on the basis of the plaint itself. No other extraneous material can be used.
But the
In that
plaintiff is interested to file affidavit. Let the file affidavit. Both the application will be taken together.
Well, then in that case, kindly give short directions. Well, that is my very humble prayer, because my learned friends are proceeding in contempt on the basis of my alleged non-compliance of orders. My they have threatened, not proceeding, threatened to proceed in contempt.
But I'll indicate, my lord, I had also moved an application.
You are appearing for?
Agarpada Jute Mills Limited.
Your
I am the
application is
owner.
appearing right now.
But I am the owner of the property.
But
my
that
lord.
I'm disputing. I'm disputing. He may
Let
say
me
that.
at least
Wait,
submit.
I don't, is his application there on the list today?
Let me
My lord,
There on the
I am
list
not
today.
required to answer. This is how
Yes,
my lord,
yes.
my
But
lord, this
I had my lord filed that application that was moved. My lord, the special officer has also visited the property pursuant to an ex parte order in respect of my property. My lord, he has found that there is nobody who is there as a tenant in my property. Now, my lord, my tenants, like Mr. Shah's client, they are being given notices of contempt.
Yes, I got.
So, my lord, that application is listed as item 131 of the monthly list, my lord. In which
131.
the complete
129 to 131. 129 to 131
That proceedings
of
affidavit.
the monthly list.
Affidavits are complete.
Complete. Affidavits are complete.
So appearing for the defendant number 10. So appearing for the defendant number 24. You are a defendant number?
24.
Defendant, my lord, I have applied.
Intervener.
Yes, my lord.
You are for the intervener?
Intervener, my lord.
So appearing for the intervener.
Mine is GA3, my lord.
Defendant number 4 or defendant number 10 has filed an
10.
application being GA4 of 2025 for rejection or dismissal of the suit. Dismissal also rejection of plaint. What?
For rejection of the plaint. Right?
Of the
Revocation of leave under clause 12 and rejection of plaint.
of plaint and revocation of leave granted by this court. Police. The defendant number 24 has also filed an application being GA. What is your GA, Mr. Dasgupta?
J2.
GA2 of 2025.
2024, Milan.
2024, and it is submitted that in the said application, application pleadings have been completed. Full stop. But the application filed by the defendant number 2, defendant number 24 is listed in the combined monthly list at serial number
130 and
129 to 131.
129
to 131, Milan, all applications.
That injunction is not to be heard now as per your
They
lordship's
all have
last
to be
order.
heard together.
129 of 129 is of
129.
injunction application.
Yes.
Now, with regard
Yes.
GA
130.
serial number 30. 130.
And when mine is 131.
The counsel for the intervener submit that he in his application being GF3 also the pleadings have been completed and the same is listed in the combined monthly list at serial number
131.
131. Police counsel for the plaintiff submit that he has filed an application being GA1 of 2024 praying for interim order.
Which is item number 129.
In this affidavits completed.
Affidavits. Some parties have given affidavits.
I'll tell you.
My letter said that my lord hear out the point of maintainability first.
The last order records that GA1 will not be heard now.
Okay, no.
And GA2 and 3 will be heard, my lord.
Okay, no problem. Some of the defendants have filed affidavit in opposition in the said application. Full stop. Considering the above, full stop. Counsel for the plaintiff press for time to file affidavit in opposition in connection with GA4 of 2025. That affidavit in opposition we filed within 2 weeks. Reply, if any, there to be filed within a week, Mr.
1 week. Within
one week, if required, Milan. I don't think Milan will need to file.
Within a week, full stop. Let all GA being GA 1, 2, 3, 4 in CS number 2113 of 2024 be listed for hearing. Give the date. And 1 then 2. 2, 3 and 4. 2, 3 and 4 listed
2,
for
3 and 4 Milan may be hard.
29th April at 2 p.m. It is made clear that after hearing of all the GA number 2, 3, and 4, the application filed by the plaintiff being GA1 be taken up for hearing.
Well, could it be, my lord, on the week preceding that, my lord, 29th, my lord, I am in some difficulty.
Then May
22-23
उससे पहले
Oh,
कोई
well, if it could be taken up on the week, my lord, commencing from the 21st of April, anytime.
बीच में कोई date
Well,
नहीं?
29 we can start, my lord, if Mr. Shah can join, because there are 3
Very
applications.
well, very well, very well. Very.
Then I am
Yes,
fixing.
we can start on that, my lord.
Kindly
Yes.
fix 2 dates, my lord.
Then I will fix 2 dates because there are 2 applications.
Right,
Yes.
very well, very well.
We can start on 29th.
29 को 5th में 9 1 2 क्या हुआ?
First May is a holiday.
First में holiday.
Holiday nahi. There is no holiday on first.
কাজ করতে হবে
5th
আর
में
লেবার থাকতে পারবি না
5th में 3 p.m.
এই তো বলছি
29th at 2 p.m.
2 p.m. 5th में 3 p.m.
Very good. Grateful, man.
Grateful. God bless you.
Next.
My interlocutory application in connection with a suit for defamation. Now, my lord, we have tried to serve the respondents. One has come back with an endorsement refused. The other has come back with an endorsement insufficient address. My lord, we are carrying the screenshots from their website to show the address, which they have displayed in their own website. But it has come back as kindly sees, my lord. Affidavit of service. And we have filed the affidavit of service.
along with the filing you have to file
My lord, will kindly have a look at. My lord, kindly sees the screenshot. My lord, this is the screenshots we are giving.
third page to that
Kindly sees the third page. This is defendant number 3. Cine Talkers.
Cine Talkers.
Cine Talkers. Yes, well, it's a website. Online, my lord,
Yes.
news website. They don't have any publication, as in no newspaper. It's an online. Kindly sees the address 58A Crossroad number 1, Caesar Road, Amboli, Andheri West, Mumbai, Maharashtra, 4,58,000.
that's exactly
That is the address. Your lordship would kindly have a look at the cost title of my application.
Refused. What is?
that's
That is insufficient address. my lord.
Insufficient.
Refused is here. Refused is
Insufficient.
insufficient.
Have you checked the location map?
Same registered address. My lord, I have sent it at the registered address.
Yes. Then
And also for defendant number 2, which is Eastern Herald, your lordship would kindly have a look at the first page of this screenshot thing which I have given, the printout. Kindly says their address is J3 DDA Flats, Kalkaji, New Delhi, 110019.
where from you getting? Page number 1.
First page here.
हाँ,
First page.
where?
Not here.
अच्छा. J.
Kindly
J3.
sees my affidavit of service, my lord. In the speed post receipt, my lord, this has been indicated that I have sent it here. J3 DDA Flats, Kalkaji, New Delhi.
and this is what it's
And Nagpur, and this is
insufficient address.
showing as again insufficient address
Insufficient.
in the postal tracking report.
Nagpur has
Yes.
But this is from their website again.
Hmm.
And the other one is Nagpur
Insufficient
today.
address,
That is
whether
the,
it has written back to you.
it's on the way
it is on the way back. I have not received the article.
this is
And my lord, defendant number 1 is Nagpur today.
Hmm.
It has come back with endorsement refused.
Nagpur today. Where is the address?
Nagpur today, the second
8
page,
Nag Road.
19 Great Nag Road beside Dainik Bhaskar, Nagpur. So my lord, we have sent,
yeah, there's
we have got the addresses from the website. Otherwise, we would not have known. Now, my lord, just to indicate in a nutshell, my lord, the facts, the plaintiff, my lord, is a consultant.
Consultant.
Yes. The plaintiff number 1 is a consultant. The plaintiff number 2 is a LLP where he is, my lord, the one of the, my lord, designated partners. The plaintiff number 2. That is his limited liability partnership. If my lord kindly takes a look at the application once, but I have indicated in paragraphs 1 and 2 that I am a professional chartered accountant, my lord. I have a chartered accountant's degree from 2009. Now, my lord, this LLP was formed in 2021.
Where it is?
That is in paragraph 2. And my lord, paragraph 3 and 4, I have indicated the scope of my expertise and what work I do. Paragraphs 3 and 4.
Yes.
But paragraph 5, if my lord is pleased to take a look at, I have various overseas clients also to whom I render my services as a consultant that I have indicated in paragraph 5.
Yes.
Mostly in United Arab Emirates and Singapore. Now, my lord, what really happened, may I indicate in a nutshell, my lord? There was a company called Sunland. I'll give you lordship the full name. Sunland Projects Private Limited. There was dispute with regard to two brothers of that. The company was really owned by the two brothers. Because I had sided with one brother, as in I am rendering my services to that one brother, I have been arraigned as party respondent in a NCLT proceeding, company mismanagement and oppression, and certain criminal cases have been lodged against me by the other brother. I am nowhere connected with the family. Now, what the defamatory articles are, these online news companies have published that I am facing 16 years of jail. There is no, the investigation has just started. There is no charge sheet frame, nothing is done. And I've stated that on. Despite that, my lord, they are publishing as if I am facing 16 years of imprisonment. So my entire business, both in India and abroad, are getting
Going to the jail for 16 years, it is a good publication.
I have nothing to do. I have been falsely implicated. But I have nothing to do. I have been falsely implicated. And my lord, also in the articles also which have been published, there are false statements made, which is not the facts.
Where is it?
Yes. Kindly, my lord, takes a look at my paragraph 7.
Is for the falsifications.
Yes. These are the statements. Kindly takes a look at Annexure A, which is, my lord, at page 24. And Annexure A is Nagpur today, which we are told that they have removed. But identical wording, your lordship would kindly see Annexure B, page 40. This is still there.
Page 30.
40, my lord. May I place it? Vivek Agarwal of Auditech 360 facing 16 years in jail in major criminal investigation.
Audited 360
Is the LLP. That is my LLP. The plaintiff number 2.
Audited 360.
Yes, yes.
$16 years in jail.
Yes.
In major criminal investigation. Correct.
Then kindly sees just after the picture, my lord.
Agarwal
Such and such a co-accused in the case of Sunland Projects, which alongside its directors face a criminal investigation, alongside a case lodged in the NCLT. Kolkata Police lodged FIR on such and such, accusing Mr. such and such, promoter of fraudulent share transfer. Then, and the warrant to search has been, my lord, posted there. I do not know, my lord, how they can get hold of this. Kindly see page 41.
Warrant to search suspected police.
The warrant to search has been copy pasted. in the news article.
Next page, this is forwarded from the by the OC to the court, forwarded by the OC. Sumendra Sorovar Thappa, eta ora lagi.
Against whom? Warrant against whom? Pratik Kumar Sardar. Warrant
And-
against Pratik Kumar Sardar, no?
Yes, that
Look,
is the
it has been
investigating officer.
Investigating officer.
Yes, but they could not have got hold of this because this is a document of the police station, Ravindra Sarovar police station.
No, issued by no. It is issued by the court. Chief Judicial Magistrate Alipur 24. It is warrant of arrest is being issued by the court.
Yes, but kindly see page 42. It is the police station stamp which is
Correct,
forwarding
correct,
to the court.
correct. There is a procedure. If court is issuing the warrant, it will go to the police station for execution.
So they are publishing this in the article. Now, my lord, this goes on page 43. If my lord kindly takes a look at page 42,
Yes.
bottom last 3 lines. And they're highlighting by italics and quotations all these things. Certainly at the instance of somebody else,
No,
but
this with regard to the 42.
yes,
42, who is the co-accused? There is no denial. You are the one of the accused.
no
correct.
denial.
Also in the home raided GT, because the warrant of arrest has been issued
Yes,
to take his possession, but only with
search
the-
warrant. This is a search warrant, not an arrest. Search.
correct search warrant for that has been issued by the London magistrate.
Yes,
And only with regard to vehicle audit act facing 60 years in jail. That
there is nothing. There is no order, nothing which says that
correct.
they are
That
facing.
is the only.
That is the thing. And my lord, they could not have published this warrant.
No,
My lord,
that-
this, my lord, your lordship would not see my lord, in any newspaper or something. Warrants. So my lord, this is really my lord,
Investigation hasn't come.
investigation hasn't started yet.
Hasn't culminated into a charge
Culminated into a charge sheet. There's no charge sheet as on date framed against me.
correct.
Investigation stage. Complaint is there, investigation stage. Then your lordship would kindly also have a look at page 43. But because all are similar, I'll only trouble your lordship with one. But kindly see the second paragraph onwards. Such and such a co-accused and alleged conspirator faces up to 16 years in imprisonment on counts of fraud, forgery, such and such. However, if he is likely as a conspirator to receive lighter jail term if convicted. But the heading is faces 16 years.
Yes.
Now kindly sees the last paragraph at page 43. This is directly affecting my business. Now, Annexure B is so far as defendant number 2 and Annexure C is so far as defendant number 3. I'm not troubling your lordship with that. Your lordship would see the same wording is there. Just a cursory glance, my lord. Your lordship would see same thing, same my lord, copy
This
paste
is
of the
defend
warrant.
number 1.
My lord, defendant number 2.
40 and 43.
40 is defendant number 2. 1 is my lord 24, but they
24
have
is-
removed.
24 removed.
One has removed.
Then 25.
40 is defendant number 2.
40 is
And my
defend
lord,
number 2.
defendant number 3 is 47.
40 and 43 defend number 2.
40 to 46 defendant number 2.
40 to 46.
45. 45. 46 is a blank page. My lord. 45.
46.
45. 46 is a blank page.
It's a part of the document.
No, with regard to the article, when that okay, 43.
43.
Yes. D2 and
Yes. Now, my lord, why I had to run to court, your lordship would kindly have a look at page 62.
yes.
This is one of my clients, probable clients in UAE. This is such and such from Dubai, UAE. Hope you remember me. We met at a common gathering such and such. However, to my utter shock and surprise, I came across news article published in such and such. About yourself and Auditor 360, the said news articles alleges that you are a conspirator involved in forgery of some cases. Further, it mentions that your company's earnings are questionable. You're involved in fraudulent activities. In such circumstances, it's difficult for me to join hands with you professionally. Please get all things sorted first and then let's talk business. Then also the next page, page 63.
Yes.
Again, referring to these very new articles, they have said that they are not eager to transact with me.
Who is my Nag Mantri? Mahanti? Mahatari?
He is the chief executive officer of this company, my lord, BNBE Homes.
Consultant.
I'm a consultant, so my lord, I
Client.
give my
So you are client.
yes, my probable client, I should say, not my client, but my probable client, who has refused to transact with me.
Scope of our work is by contract.
Now, my lord, page 50.
Later, engagement letter.
Yes.
Page 52, if my lord is kindly pleased to take a look at. This is my scope of engagement with this company, Sunland. Page 52. Only as a management audit, financial monitor, and accounting advisory services.
Yes.
To say that I am not a
Where is that? Latest engagement of management, audit, financial monitoring, accounting, advisory. Yes.
Page 53.
58 বোধ হয় এটা
হ্যাঁ,
নিজের হাতে লেখা
দুটো আছে তাই জন্য এটা সেকেন্ড 53 টা দেখো 53 was renewed thereafter.
No, this was renewed.
This is
Page
that-
53, clause 4 is still, my lord, for 12 months. That was renewed by the letter at page, my lord, 56. 57.
Yes.
So, my lord, we filed the suit.
Hmm.
My lord, thereafter, after filing of the suit, kindly comes to page 92.
Top left side, we'll get the date.
Your lordship would see the date of this publication on the top page 92. I'm sorry, my lord, page 92.
Yes.
Last time when I accessed
On the left hand side, top, your lordship would see 17/2/2025, right at the top, my lord. Top left.
Hmm.
This is on 17th of February. But again, this has been published.
17th of February, this is the printout.
Yes, yes.
1530. But
So this remained in the website.
But the publication is
I showed it from page 40, my lord. That publication remains. So I'm showing it that even as on date, it remains.
As for D2.
For defendant number 2. This is defendant number 2.
Yes.
Because one has removed.
Page 97 is defendant number 3.
Page 97 is defendant number 3.
Same report.
My lord, now they have published my photograph also.
Yes.
Page 97, they've published my photograph also.
Who published that?
This is defendant number 3. And
But page 90. Achha, okay. Yes.
But and because it's okay. Because this is some juicy news or sensational news, now somebody else is now copy pasting who is not a party to the suit, and I've advised my clients to take out an application for addition of party also. Kindly see page 101. This is not a defendant who has recently published this.
Okay, it's not the party. Huh?
Yes, so I am not praying for order against him right now because I cannot without him being a party. I'm in the process of taking out an application. But kindly restrains the other defendants from publishing, and kindly sees my prayers now. Because only restraining here won't do. Prayer B is really what I am pressing for. Because why I am pressing prayer B even at this ad interim stage, is because of this third party now who is copy pasted from a website and now is publishing. So, the facts are such that possibly, at this stage, at the interim stage, your lordship would pass this order in the nature of mandatory injunction. Judgment ko lagao. Nandan pick.
Yes.
That's all. That's all. But this is really affecting my business. That's the whole thing.
What is the case for?
Defamation suit. Well, may I show the prayers in the print? I'm really sorry. I should have. I should have. I'm sorry. Kindly pardons me. Page 88.
Yes.
Could I take your lordship's leave?
The plaintiff has filed the suit for damages of rupees 10, 00, 00, 000, along with other prayers. Along with the prayer for perpetual injunction. Okay. Plaintiff has filed the present application being GA1 of 2025, praying for interim relief. Counsel for the plaintiff submit that the plaintiff is a professional chartered accountant and is registered with the Institute of Chartered Accountant of India with effect from 1st of April 2009. The plaintiff is the plaintiff number 2 is engaged in rendering service like management, audit, process built-ups, virtual chief financial officer services, financial and risk advisory, mergers and acquisition, corporate restructuring, structured finance, wealth advisory, capital market solutions, startup solution, and other financial and advisory service as LLP with the plaintiff. As LLP with the plaintiff.
Lordship,
Defend number 2.
Plaintiff number 1 is the designated partner of P2.
And the plaintiff is the plaintiff number 2 is the partner.
Plaintiff number 2 is the partnership firm, my lord.
So how the plaintiff is connected? Where you mentioned?
Plaintiff number 1 is the lordship. It's here. Para 2. Plaintiff petitioner number 1. It would be cause the incorporation of petition number 2 as a designated partner, founder.
Please, the plaintiff number 1 is the designated partner and founder of the plaintiff number 2. Police. On 25th of July 2024, the plaintiff number 1 was informed by one Chandan Singh that he came across a news article on the online web portal of the defendant number 1, in which the statements were made about the plaintiff being involved in the criminal proceeding. Police. After getting the said information, the plaintiff has searched online web portal of the plaintiff number 1, defendant number 1, from which the plaintiff number 1 found that the said article have been published in the website www.nagpurtoday.in with the caption audit tech AUDITECH dash 360s dash Vivek Agrawal dash facing dash 16 years in jail in criminal investigation. Full stop. The plaintiff submits that the plaintiff also came to know that another publication was made in the website Eastern Herald, EASTERNHERALD.com, wherein it is also published that Vivek Agrawal Auditech 360-16 years jail criminal investigation. Full stop. On further search, the plaintiff has also found that another publication was made against the plaintiff in the website www.cinetalkers.com with the same allegation, with the same article. Full stop. Counsel for the plaintiff submit that. Counsel for the plaintiff submit that the plaintiff has been engaged by one Sunland Project Private Limited for management, audit / financial monitoring, accounting and advisory services. Full stop. Against the Sunland Project Private Limited, an NCLT proceedings has been initiated, wherein the plaintiff has also been made as party to the said proceeding. Against the Sunland Project Private Limited, a criminal case has been initiated, wherein the plaintiff has also been made accused in the said proceeding, and the said proceeding is under investigation before the police authorities. Full stop. Counsel for the plaintiff submit that the defendants, particularly the defendant number 2, has also published the warrant of search issued by the London Chief Judicial Magistrate, Alipur Court, Alipur 24 Pargana South Court in the said website.
All the 3 defendants have published.
All
the 3.
Counsel for the plaintiff, all the defendants have published the warrant of search issued by the London Court of Chief Judicial Magistrate, Alipur 24 Pargana South. The plaintiff submit that after going through the said publication made by the defendants in their website, third parties are also started publishing the said warrant in their publication. He submit that though the NCLT proceeding and the criminal case has been initiated against the Sunland by
Sunland Projects Private Limited.
Private
page
Limited.
50.
Private Limited. But in the said case, the plaintiff has been falsely implicated. But the case initiated against the plaintiff is still under investigation. No trial has been concluded. No punishment has been awarded. But in the publication made by the defendants, it is found that the plaintiff is facing 60 years in jail in minor criminal investigation. Counsel for the plaintiff submitted due to the said allegation, which is not correct. Only the case is pending for investigation, and no punishment has been imposed by the court, due to which the reputation of the plaintiff has been badly affected, and the plaintiff is also facing great difficulties in his business. Counsel for the plaintiff submit that unless and until the defendants are not restrained from making any false allegation by way of publication stating any conviction of 16 years jail, which is not correct, the plaintiff will suffer irreparable loss and injury. The plaintiff further submit that due to the publication made by the defendants, the other third parties are also started making publication on the false allegation. Considering the above, this court find that the plaintiff has made out a prima facie case and balance of convenience and inconvenience in favor of the plaintiff. It is further found that the publication made by the defendants that Vivek that the plaintiff Vivek Agrawal of Audit Tech 360 facing 16 years in jail in major criminal investigation is not correct. Thus, the defendants are restrained from their man, agent, representatives, and servants are restrained from publishing or posting any such statements concerning the punishment of the plaintiff in the pending investigation, and also restrain and also direct the defendants forthwith take out the articles from the website wherein it is published that Vivek Agrawal of Audit Act 360 facing 16 years in jail in major criminal investigation. Full stop. On or before क्या बोला? Not to publish बोला है ना? Not to publish the so उसमें करो till 9th April 2025 and the so directed to withdraw, take out the publication by आज कितना तारीख है? 6 तारीख by 12th of March 2025. Full stop. The plaintiff is directed. Full stop. The counsel for the plaintiff has handed over the track report wherein it reveals that the defendant number 1 has refused to accept the notice. As regard the defendant number 2 and 3, it was returned unserved with the endorsement insufficient address, but this court find that in the website, in the address which is mentioned in the website of the defendants number 2 and 3, the plaintiff has sent the said notices to the defendant on the same address, but unfortunately the same has written as insufficient address. Full stop. Accordingly, the plaintiff is directed to send the copy of the print, documents and the present application by speed post to the defendants at their registered address again.
Also send a copy of via mail.
And to submit the affidavit of service on the next date.
Also with it an email lodged because they are all online
also
publications.
And also
That
to
is, email will-
along with the plaintiff is also given liberty to send all the documents with the email address of the defendants.
I'll send it by email.
Let the matter appear on क्या date बोला था? 9th April. 9th April 2020. Next.
So grateful.
Appellate site. किसका है आंधे तो?
My lord, item number 1. I'm sorry. Item 81 of your lordship's monthly list. The interim order is expiring today, 6th March. Mentioning upon notice.
My lord, I appear for the respondent. For the purchaser, man. I appear for the respondent.
You are for the purchaser?
Yes.
Who is for the defendant?
The defendant number 1 is the
We got. So and so appearing for the plaintiff. You are the defendant, no?
I'm the defendant, my lord.
Defend
one of
number?
The purchaser would be defend number 1.
Sensations appearing for the plaintiff, sensations appearing for the defend number 1. Counsel for the plaintiff submits that though the matter is listed as item number
81 of your lordship's monthly list.
81 of the monthly list, but the interim order granted earlier is going to be expired today and paid for extension of interim order. Considering the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 10th of April 2025 or until further order, whichever is
My defendant number 1, my lord.
Instead of defendant number 1, kindly mention defendant purchaser. So that will work.
one बोला ना, dependent within bracket purchaser कर लो.
Straightforward.
Let the matter remain in the list.
Great.
Yes.
Is a contempt matter. 16.
Hmm.
Your lordship had corrected presence of the person in, and then your lordship had given an undertaking. My instructions are, in spite of giving an undertaking, it's still being flouted. Kindly take up the matter on any date. Notice that Howrah property, your lordship remembers, the gentleman had stepped into the box and given an undertaking. We have photographs as of today also with the time date stamp that we set up a container there and sitting in the property deployed.
क्या आज का present personally present वाला है? Presence है? नहीं है.
Notice because otherwise matters are generally less. I think there are more pressing injunction matters which take up time.
That's why I have alternately I am taking one day content, one day new motion, one day adjournment. But that way only this court can go for. Otherwise, it is very difficult.
With this appellate side list also it becomes more.
That I will not say anything.
Yes. Please suffer,
ठीक है इसको as let it be same position in the list. It will come on Wednesday. Every matter is urgent, sir. What can be done? One person, thousands of matter. What application? Fix, you will say. Then you have to go. You have to wait till May. My list has gone to the first week of May now. If you want to remain in the list, let us see how far the court can go. Correct. It is urgent motion, na? It will come, no problem. No further interim order. Okay. Let call the Hari isko.
May I have your lordship kindly to mention one urgent motion, the item number 149 of today's list.
149?
149 of today's list, my lord.
Yes.
The urgency is this, my lord. The son has lodged an FIR against the mother. The allegation is that, my lord, the mother and the late father are holder of a joint account. Now, after the date of the father, my lord, the amount has been transferred to, because, my lord, as is very, the either a survivor, my lord, because the amount has been transferred to the mother's account. Mother is having a joint account with the son. So that's why, my lord, that account mother has withdrawn for her personal, my lord, use. Now, son suddenly, my lord, has filed an FIR on the ground that this amount has been misappropriated and used up by the mother. And, my lord, the next date, my lord, the learned magistrate has taken cognizance, my lord, I have come up for quashing of the FIR. Since, my lord, the petitioner contention is before the lower court below that this FIR, my lord, cannot be, my lord, ought to have not been filed, and no criminal case ought to have been initiated, because this is
the age of the mother.
Mother age is, my lord, subject to correction, my lord. She is a senior citizen above 70, my lord, and she is also, my lord, suffering from various ailments, my lord. He has to, my lord, undergone various medical checkup, and suddenly, my lord, the son, my lord, out the blue has filed this.
So what is the stage when the FIR was lodged?
But the FIR was lodged in the year 2023, but the cognizance has been taken 2024. But after cognizance has been
case.
Yes, my lord.
The complaint case.
Well, complaint case, my lord.
So what will happen? Complaint case.
Complaint, but the whole difficulty is, my lord, there she has to come up every day, my lord, and if the matter, my lord, your lordship.
Sir,
No, my lord,
you are the experienced. You are the experienced person in the complaint case.
No, not
Firstly,
complaint case, my lord.
evidence
She said
before
direct,
charge
direct, direct.
Evidence before charge will be taken,
No,
and
but this is-
thereafter,
subject to
when
correction, it
the
is
matter
not a
will come
complaint
for the
but it is a police
consideration of
case.
the
My lord.
charges, you file an
It is a
application
police
for.
case, my lord, not a complaint case.
That's why I'm asking.
Yeah,
you,
my lord.
complaint.
It's subject to correction, my lord, it's a police case.
So police case, when the police case was initiated, what
Well,
is
the
the FIR number?
Police case, my lord, the FIR number, my lord, that 15th, 11th,
Whether she was arrested? Whether she was arrested?
No, but she has taken bail.
Anticipatory bail.
No, my lord, she surrendered before the magistrate. She was enlarged. She and her daughter, both. But my lord, the harassing is going on, my lord. Because that's why, my lord, I want, my lord, the petitioner has come up for quashing of the FIR because the FIR is an administrative
All of
process.
causing, sir. All of causing.
But next date has been fixed, my lord, in the last week of March.
See, charge sheet is not filed.
But they are about to file the charge sheet, my lord. That is why I am
charge sheet
happy.
file, it is good for you. But then
But
you
again, my lord, I have to sought for discharge, my lord. Before that, my lord, if I can, my lord, succeed, then, my lord, this entire process, mother, my lord, ailing mother, but the son has come up. But it is the unusual flavor, my lord. This is normally the very, my lord, unusual thing, my lord. 149, your lordship can hear, subject to your lordship convenience any day.
That's why this court is taking only.
I know, my lord, the lordship predicament, my lord, I know, my lord. But any day, my lord, since, my lord, she's an ailing lady, my lord, she has to regular, my lord, undertake medical checkup and all these things. And daughter, my daughter is living with mother against daughter also.
Item number
149 of today's list.
Suffering for the petitioner. Though the matter is listed as serial number 149 of day's list, but the learned counsel for the petitioner submit that the petitioner of the present case is a senior citizen, and as such he prays for upgradation of the matter so that the matter can be taken off a hearing. In view of the submission made by the counsel for the petitioner, taking into consideration of the senior citizen, case of the senior citizen, let the matter appear on 20th March as item number 2.
Grateful to your lordship.
My lord, may I permitted to mention, my lord, today's item number 152, my lord. My lord, in this matter, lower court has extended the interim bail till 10th March 2025, my lord. And after that, there is a date fixed for evidence, my lord. If some preference can be given, my lord.
Come. Yes. Come next day. Yes. What is the, it is evidence. You face the trial.
Interim bail will fix for, my lord.
Interim bail granted by the lower court.
Lower court, my lord.
Then,
my lord, it is extended till 10th March, my lord, on Monday.
so once the bail is granted, so what do you want from this court?
My lord, for quashing of charge sheet, my lord.
Okay, when the matter will come, we'll see to that.
My
Not all matter can be.
My lord, item number 185 in today's list, my lord, the daughter of the opposite party number 2 is a official, and she is continuously pressurizing the petitioner. Both the petitioners are senior citizens. She is continuously initiating legal proceedings.
What the proceeding you filed here?
The quashing of the
FIR.
case, my lord, proceedings.
Let first once a senior citizen be over, then we'll see to that. Yes, call the list.
Lordship, the Jalpaiguri list will be called out, Lordship.
Yes, Jalpaiguri will be called. Yes, who is appearing?
Lordship, item number 1, I am for the petitioner, Lordship. Jalpaiguri matter.
What is the matter?
Today is the first. Lordship, your Lordship was pleased to pass order on 17th May 2024. Lordship, it's an admitted claim. The state respondent said order is at page 12. Page 12.
Submit director release the balance amount of 5,50,000 in favor of the petition within a period of 4 weeks.
Period of Lordship 4 weeks. 4 weeks. Now kindly comes to the next page. I have communicated 15th. I have communicated this order to the executive officer Patigara. And in reply, if Lordship turns to the next page, page number 6, he has admitted the entire thing, and the last he says that hence I am forwarding the last paragraph, third paragraph. Hence I am hereby forwarding this requisition for outstanding amount 5 lakhs so that payment can be made at the earliest. He said that there is no fund. He is asking for funds.
Correct.
Direction was for him to pay the funds within 4 weeks.
Issue notice.
Lordship, Lordship, I shall notice.
So appearing for the petitioner. The petitioner has filed the present application, praying for filed the present contempt application on the allegation that the alleged contemner has not complied with the order passed by this court dated 17th May 2024. Full stop. Petitioner is directed to issue notice upon the alleged contemner and to file the affidavit on the next date fixed. Release the matter on 13th of March 2020.
Grateful. Grateful.
Next.
From civilian to criminal judge is promotion or demotion? I've heard, my lord, that now he became the criminal judge.
You heard wrongly. Now this court has become an all-rounder.
You know that? Only we are deprived. Why this is discrimination? I will meet the Chief Justice.
Yes.
Lord, my client is present today also. There is a
The Lordship's direction was to file the compliance report. না না করুন তোমাকে নিয়ে এসছি ওই জন্য পারেনি শেষটা তোমাকে ধরেছে
Yes.
Let us have the copy of the compliance report. We can go through the same.
Not be satisfied. Then
Yes, yes.
As of I am a civil lawyer, so according to my ability, I have.
I am also a civil judge.
Now my lord is not. No one can say. I can say. But kindly take trouble to see page 3 from the.
Let me have the copy.
Give the copy.
No, join bol leave. Just to give. May I read?
Okay, you give the copy.
I'm given.
Come the next day.
No, my lord will be satisfied first.
What interested?
No, my lord.
Chairman.
Now, my lord, in the year 2009, an advertisement was published for filling up the total post of primary school teachers, 1411 vacant posts. Among the said vacant posts, the post of recruitment exempt category, you are dealing with exempt category, 313 posts. Out of said exempt category, the vacancy determined of Bengali medium only, they are making it very short. Bengali medium 254. Out of 254, what was the subdivision? Bengali unreserved, Bengali scheduled caste, Bengali other backward class, Bengali scheduled tribe. While giving appointment in 2009, 254 posts of exempt category was filled up in the following manner, and list of cut-off marks in different category was shown. But this is very important, will be for my lord. What are the cut-off marks? Last appointed. Then it's turnover. I state that in the above manner, the entire vacancies were filled up. I state that according to the recruitment rules, 157 posts were reserved for died in handless category. Out of 157 posts, 42 posts were filled up among the died in the candidates, and 57 number of died in applicants were processed for absorption, and rest 58 numbers. Now the vacancy cropped up for your consideration. 58 numbers of died in handless vacancies are likely to remain vacant in absence of eligible candidates. Accordingly, these councils thereafter send a proposal to fill up these remaining 58 posts of died in handless category to the candidates of exempt category of land loser by way of conversion, and response thereof. DSC by memo dated 12 March 2012 approved the proposal for recruitment of 58 posts of land loser category. So it is now singled out from
Land loser.
Now my lord kindly come to.
But Mr. Mr. Basu, it is permissible. It is permissible.
That is not the subject matter.
Okay, no, but I am asking the question. Okay, okay,
Both are unreserved category.
okay. Okay, continue.
No, Article 14 discrimination. This is from same category as carved out.
Okay, continue.
Now, my lord, kindly turn over how it was filled up. My lord, then, my lord, I state that the implementing the order dated then this 19th April 2016 order came into force, which says that which panel you have prepared after the 458 candidate is erroneous. There, my lord, the litigation starts. Then your lordship directed to recast this from on the basis of 19th April 2016. Then, my lord, I make it very short for your lordship. While implementing the said order of 2016, the alleged conspirator has calculated the panel earlier prepared and discussed the candidates on the basis of eligible cut-off marks. What I have did, as of illustration, in respect of undeserved candidates, before recasting the panel, which was approved by the School Education Department, the first candidate obtained 25.50 marks, and the last candidate obtained 22.90 marks. While in the recast panel, eligible one candidate obtained 25.74 and last candidate 23.63. That mistake was rectified. And this panel was prepared. Your Lordship, thereafter I have given category wise this Bengali exemplary category scheduled caste. First is 23.24 and last two was included 22.79. Am I clear to my lord?
No. Illustration, the education department first candidate obtained 25.50 and the last candidate obtained itna. Wherein the recast panel eligible candidate obtained
This was wrong.
25.
This was wrongly recosted. That's why this 2016 notification was given.
Correct.
Make it correct. And
Correct.
you will also be directed to implement.
Implement that.
After implementation, what is the situation?
Hmm.
You will also get from this second paragraph. Next paragraph. So for the first candidate in SC category, 23.24 was the first person, and the last two was recasted 22.79. Okay,
No. Where it is?
followed page
So
five.
far first candidate.
Page 5, my lord. Kindly come to as of illustration.
Acha,
following
2.79.
paragraph.
Yes.
For the first candidate.
Correct. Correct.
This is the recast panel.
Correct.
This is the position for 4 categories I have given in categorically.
Correct.
According to me, this is the implementation of 2016 notification directed by my lord to comply. Now the problem comes. What I am saying is recasting has been made but not yet implemented up till now.
That is the problem.
Recasted has been made, not been implemented. Now your lordship is considering a writ petition filed by learned friend. What is his prayer there? To appoint him. Recast and appoint him. That's why given this percentage. He is not coming under this percentage at all. It is much below.
Not coming under 22, 22.79.
He's 18 or something odd.
Okay.
Problem your lordship has to decide with very sensitive. This appointment on the basis of the wrong recasted panel. I use the word wrong. This is our fault down the path. I must candidly. They were recruited in 2012. If today, my lord, this recasted panel directed by my lord is being implemented, I have taken instruction, 8 candidates will be losing his job. Who was working there since 2012. But my learned friend's client, the writ petitioner, cannot be absorbed there. Now, this is the reason why.
So how the if the repetition will not be affected, how the 8 other candidates will come up? Then the 8.
Who are not challenged, who was not before my lord? Both will be included, they are not before my lord, who will be excluded, they are also not before.
Correct.
But in any event, if this is implemented also, writ petitioner will not be benefited. He is out of the zone of that. I was giving my thought, my lord.
Create the super
There, no problem. I accept, my lord, a tender apology on behalf of my client. Fault was there. He wrongly.
Yes, Mr. Badi.
Marada, I have to
Go through.
Go through. I have to come back. And so far 8 candidate, 10 candidate, my lord, that is not. Now the law is settled. 26,000 candidates have been declared unfit throughout those panels.
No,
Now they have prepared. My lord, they woke up from slumber after the order of the court, even after issuance of the contempt rule. That I have to go through. I
Okay,
have
you
to
go
check
through.
up.
You go through it.
Yes.
Because now whatever the fact, that is fact with regard to your eligibility. Please see that your eligibility.
Not only eligibility, whether my lord, in true sense that order has been complied with.
Correct. Correct. That's why. If they have casted, if they have recasted, if they will recasted, if they have been recasted, if it is
Whether
illegally,
the earlier panel, whether the panel, whether
Let us
the it is a. I will have to go through.
It was wrong. That's why you are tendering apology.
Mala, I was hearing one thing about from this. I was in a court, in another court. Mr. Kollan Bandyopadhyay was there. Now, my lord, the Mr. Bandyopadhyay was submitting before the court of law that when he was in Supreme Court, that what is the matter? No, SLP, there no merit, no merit. That At the same time, the Advocate General of the Bihar entered into the My lord, I'm in this matter. Oh, you were in this matter? Yes, SLP admitted, interim order granted. That means when Mr. Basu is there, something is there. Otherwise, otherwise, yes. I will check up.
Otherwise,
I will check up and I will satisfy you.
That's why I'm telling you, go through it.
Yes. No, very fast not. You have came after 3, after issuance of the non-presence of the contemptor, issuance of the contempt rule, thrice the court passed an order. So I believe, my lord, there will be something which will.
Mr. Basu knows in our circuit bench, we used to appear in every court and in a circuit bench. Once we find that some of the senior advocates have been engaged from the Calcutta, then the judges will also know something is there. In some...
Say my lord is not in court. My lord is safe. And my lord is sitting in the throne.
So,
allow me, my lord.
When I came for the first day, I say,
yes.
If I am not satisfied, I will not come.
So, appearing for the petitioner.
After my submission, he will not come.
The alleged contender filed affidavit of compliance. After serving the copy to the learned counsel for the petitioner, let the same be kept with the record. Counsel for the petitioner press for time to go through the compliance filed by the and to make appropriate submission and go through the compliance filed by the alleged contender and to make appropriate submission on the next date fixed. In view of the submission made by the counsel for the petitioner, case is adjourned. When? Within a week or 20 March? Let the matter appear on 20 March. For the time being, the personal appearance of the alleged contender is dispensed with.
After compliance, nobody will engage Mr. Basu. After compliance. If it is a compliance and your lordship will always.
I don't appear for state.
Let's
You'll also fix one?
20. Yes, call the next.
Side matter item number 1.
क्या पिटिशन क्या नाम है? ये है, अलियास भी आएगा. The matter is listed as to be mentioned for correction in the order dated 13th February 2025. In the order dated 13th February 2025, in the cost title, the name of the petitioner has recorded as Lakshmi, Lakshmi Bairagya, Bairagya Das. Though in the cost title of the writ petition একই আছে. Cost title of the revisional application, the name of the petitioner is recorded as Lakshmi Bairagya Das alias Lakshmi Bairagi Das. ठीक है? In view of the above, in the cost title and in the order dated 13th February 2025, the name of the petitioner shall be read as Lakshmi Bairagya Das alias Lakshmi Bairagi Das instead of Lakshmi Bairagya Das. This order may be incorporated with the order. This order may be treated as part of the order dated 13th February 2025. Next. Yes.
I am for the petition amendment, item number 2. I am for the opposite. Item number 10.
क्या हुआ? नहीं फर्स्ट कॉल कर, फर्स्ट से कॉल कर, 1 and 2 करो. हाँ, आइटम नंबर 1 2 बोलो ना.
I am for the petition amendment. I have come up with a supplementary affidavit. If your lordship kindly permit me to use, I have already served a copy of this supplementary to my learned.
Why supplementary?
Certain documents inadvertently not annexed, although mentioned in the petition.
What?
Well, the evidence of the witnesses.
Have you served the copy?
Yes, yes, I have served. If you also kindly take it.
Well,
Well, the earlier on occasion, your lordship has heard out this matter. Well, this matter pertains to an in order of maintenance granted by the learned family judge, 8,000 to the wife and 7,000 to the child. Well, this is a final order of maintenance. Well, there is a batch of litigations between the parties. There are altogether 4 litigations between the parties. The wife was initiated a proceeding under Protection of Women from Domestic Violence Act. Thereafter, the husband has initiated a proceeding under Act 8, praying for the custody of the child. Subsequent thereto, the wife has preferred a 498 proceeding, and at last this proceeding under 125.
what has happened to the domestic violence?
It has been dismissed on contest, holding that there is no domestic violence. Because the genus of the proceeding under Protection of Women from Domestic Violence was the alleged dowry demand and torture thereto, which allegedly prompted the wife to leave the matrimonial home and to take shelter at the paternal home. In the course of evidence, the wife adduced herself and her mother as a witness therein. The mother, while came in, and also the wife also, while evidence was adduced and they were cross-examined, it is categorically admitted by them that there is no dowry demand. Consequent thereto, the learned judge disbelieved, learned magistrate disbelieved the domestic violence and disposed of the proceeding. Now, in that domestic violence proceeding, while the adducing evidence, opposite party member, the husband,
It was disposed of on merit after evidence.
On merit it was.
No appeal.
There is an appeal. Appeal was preferred before the appellate court. That was also dismissed. The order of the magistrate was affirmed. Against that, till date, no application for revision has been preferred before this honorable court. This is the status so far as the DV Act is concerned. Now, so far as the DV Act is concerned, in that case, the husband has adduced 2 independent persons as a witness, along with himself to be an witness in that proceeding. Those persons are associated with National Insurance Company. They have come up with the documentary evidence to indicate that the wife has employed or wife is associated with the company as an agent, and there is a document to that effect, and she has an earning therefrom. This was on record in the domestic violence proceeding.
He was the LIC agent.
She is an national insurance agent.
Agent, that's why.
NIC. Now, subsequent thereto, during the pendency of the domestic violence proceeding, the husband has initiated a proceeding under Act 8. In the Act 8 proceeding, the husband specifically mentioned that on 31st of January 2015, the wife left her matrimonial home with the child. The wife used an opposition to that document. She admitted that she herself left the matrimonial home without giving any allegation of torture, which allegedly prompted her to leave the matrimonial home. The Act 8 proceeding was ultimately when an order was passed for giving an visiting right to the husband. Near about
what is the age of the child?
12 years. 12 years. Near about 1 year after, near about 9 months after, the wife came up with the application under section 125. Now, in the application under 125, there is no details about the torture. The word used is systematic torture. She claimed on 31st of January 2015, she was allegedly driven out from a matrimonial home by the parents-in-laws and the husband. She filed her affidavit of assets in that proceeding. In the affidavit of assets, she categorically disclosed that she is an unemployed, she doesn't have any income. She also suppressed her assets in the paternal property from where she is getting rent. The rent is coming under one end, and that is being divided among the others, including her. She herself suppressed her income from the National Insurance Company. She did not provide any income tax return and also the bank statement, because the income, whatever she is receiving from the National Insurance Company, is directly credited to her bank account. husband, while adducing his evidence and while cross-examining the wife, categorically put this into question, categorically exhibited this document. The learned judge completely disbelieved the entire
What document you produce?
My lord, I have produced her admission in Act 8 case, the written reply he has filed.
Admission?
Admission in Act 8 case, the written reply she has filed. I had produced the evidence of the employment related documents.
Correct. Have you adduced or have you produced any document or any document where exhibited that she is earning from the NIC?
It is associated with NIC. That document
Associated with regard to whether what she is earning the income. Have you adduced any evidence on that? First thing. Second thing, with regard to the landed property, what she is getting and what quantum of the amount she is getting, these two evidence have you got?
Quantum I cannot, because the document I had, if your lordship kindly sees from page number 107 onwards of my revisional application, your lordship will find the nature of the document. And in fact, she has also admitted this fact that she is not demonstrated all these issues in her affidavit of assets and liabilities. That she admitted in her cross-examination. My lord, if your lordship sees section page number 107, this is an appointment and certificate of registration.
Yes.
Now, lordship would kindly come to page 108.
Yes.
My lord, this is an identity card issued by the company.
What is the 107 is what is the 107?
This is an
appointment
certificate of registration
in the insurance company.
Insurance company, will it?
Yes. And 108 is
The identity card or the certificate issued. My lord, finally find that registered on the valid from and valid to, the three dates are mentioned over there. At the middle
registered.
portion, will it?
Yes, registered on May 19.
19, valid from
19.
19 and valid to 2022. This was adduced while this was in between 19 and 2022.
Correct.
Now, lordship would kindly come to page 109 to 114. These are the documents indicating that she is one of the shareholder of the ancestral property. If your lordship kindly come to page 113, your lordship will find that her name is appearing. These are mutation certificates and accessory.
Correct. See, with regard to the landed property, having her share does not amount that the property generate income. So this property is there, then if this property is there, then you have to prove that this property generate income and she got this amount. So she is having the income from the property.
She admitted in her evidence.
Show me. Yeah, okay, continue, no problem.
I'll show you. She
So 109 to 114 the landed document.
Landed document. Now, lordship would kindly come to the split document. My lord would kindly come to the document. Page 190.
Yes.
My lord, this is a registration form for admission issued by the school where the son is studying. My lord would kindly see column number 7, mother's occupation. Private teaching.
Yes.
So, my lord, these are the relevant documents which I have indicated that she has some income to maintain herself. Now, lordship would kindly come to
yes,
page 271. This is the written objection. 271. This is the written objection the wife filed against the application under Act 8. My lord would kindly come to 5th line from the bottom of the page.
Yes.
The opposite party wife stated that she is capable to maintain her minor son with regard to such disease of a minor son. Bottom. Paragraph K.
What is the disease?
Well,
What disease he was?
he was suffering from some speech related disease, and he was undergoing a speech therapy. That is, she has disclosed in her 125 application.
Yes.
So these are the documents which at least prima facie indicates that the lady has some income to maintain herself. Now, Lordship would kindly take the supplementary affidavit where the evidence of the OPW2 and OPW3 are annexed, which your Lordship will find in page number 18. Is of the OPW3 minute.
Yes.
This OPW3 is the senior divisional manager of National Insurance Company Limited. As per his evidence, he has adduced a document which I have already indicated to your Lordship at page number 107 and 108,
yes,
that she is associated with National Insurance Company.
Jayanti Das along with her identity card. Yes.
Now, Lordship would kindly come to page 21.
Yes.
Well, this is the evidence of the development officer under whom the lady has been working.
Yes.
My lord, kindly see the chief. My lord, it's from the top, it's fourth line. Under me, one Jayati Das is working as an agent of National Insurance Company Limited on commission basis.
OPW2.
OPW2, will it?
OPW2. Oh, yes. Who is
21?
Who is he? Surijit Mukherjee,
The
development officer of the National Insurance Company.
Under this development officer, the lady is being
Correct.
working as an agent.
Correct.
Under me, one Jayati Das is working as an agent of National Insurance Company Limited on commission basis, and she is working for last 2-3 months. The commission of the agent is calculated on the basis of the business given by the agent, and it is directly credited into the account of the agent. May I pause here for a moment, minute? The income of the lady would have been easily proved if she has provided her bank statements.
Correct.
She has not provided that in her affidavit of assets.
Correct.
My lord, would kindly come. I'll just indicate that how she has evaded the provision. My lord, would kindly come.
Yes.
To page 89.
89 of?
Sierra, Millet.
Yes.
Furnish copies of the bank statement, point number 9. Furnish copies of the bank statement of all accounts for the last 3 years. She has not given that. No details.
Furnish copies of bank account of all accounts for the last 3 years.
No statement has been given.
But
kindly see.
Have you put the question to the witness with regard to this?
Yes, my lord, the question was put to her. My lord, kindly see clause G, point number 3. Share in any ancestral property. No.
Yes.
My lord, kindly see the next point, point number 4. The petitioner has one savings account but did not disclose the details.
Yes.
Now, my lord, would kindly come to page number 91.
Yes.
Paragraph 5, point number 1. Brief description of nature of business, profession, vocation, or self-employed. Not applicable. Now, my lord, kindly read this with
Yes.
Page number 87.
Yes.
Well, kindly see clause A, details of income of the deponent. The petitioner has no source of income. Now, at least so far as the income is concerned, this is explicit from the record that she has income. She has purposely suppressed this and also tried to obtain an order on the matrix that she is a destitute. Well, this consequence of giving false information by way of an affidavit of assets is itself imbibed in the decision of Rajneesh versus Neha, once he has affirmed the affidavit and verification. Now, Lordship would kindly come to the cross-examination of the lady pertaining to the proceeding under 125 itself, Millet. Let's come to page 139. Millet, at the middle portion, which starts with, I used to work as a private tutor. I used to work as a private tutor before marriage and after marriage, and I did not work as a private tutor after driven away by me from my matrimonial home. But I have indicated to your lordship the document of the school of her son where she herself demonstrated as a private tutor. But may I continue?
But she has stated that I used to work in the private tutor before marriage and after marriage and did not work after marriage. Okay.
I noted in the resignation of the registration of the admission of my son in the year 2016 that my official occupation at the time was private teaching. My name has been recorded as an agent in National Insurance Company Limited.
Where from you reading?
Well, at the same page.
Paragraph?
Well, at the paragraph I have indicated. Just
I noted registration of the admission. Yes. Yes. Continue.
Well, the next point, my name had been recorded as an agent in the National Insurance Company Limited. My development officer used to operate my code of that insurance company, and I had been given some commission for a few months thereafter that my agent code has been dropped. Nothing has been brought on record that her agent code has been dropped to this regulate. I did not submit any paper on that aspect for dropping my agent code, and if required, I can submit the proper on that respect. It is a fact that I am the owner of a dwelling house 48B/1 Koilashpur Street with my brother and mother because my father gave that property while I remained in my paternal home after driven away me from my matrimonial home. It is not mentioned in my asset and liabilities that the said fact of getting property in my name. In that house, there is a tenant. It is not a fact that there are 4 tenants in a house. It is a fact that after realizing rent by my mother from that tenant, some money is given to me by mother for my and my son's maintenance because at present my mother looks after us. It is a fact that I did not mention about the tenancy or about my agent in insurance company in the petition under application under section 125 CRPC and also in the affidavit of my assets and liabilities. Well, these are the admission by the wife so far as our income is concerned. Now, these lead us to a situation that why she left her matrimonial home. Well, it would kindly come to the application she preferred by way of an 125. Well, I would kindly see page 38 of my revisional application, Millet.
Yes.
Well, I would kindly see paragraph 7. But kindly remember this, that these 125 is being filed at least 11 months after the domestic violence proceeding has been preferred. 498 a case has been preferred where the specific contention of the lady is she has been driven out from the matrimonial home due to torture because of dowry.
After 11 months?
After 11 months.
Yes.
Now, Millet, in paragraph 7, the narration of the torture is systematic torture. Nothing more, nothing less. Paragraph 8, the contention is she was driven away.
Yes.
Nothing more, nothing less, Millet. Now, Millet, I'll visit your lordship to come to the Act 8 reply again. I have put that by way of a cross-examination also to her. If your lordship be kind enough to come to page 270 for once. Well, back to that, subject to correction, kindly. Well, if your lordship kindly take the supplementary affidavit for once, paragraph page 6. Page 6. It's page 28, Millet.
Yes.
Page 28, paragraph 12. Millet, this is the plaint I have filed under Act 8.
Yes.
Millet, this contention is this, that on 31st day of January 2015, the opposite party wife, accompanied of the male child, went to her parents' house, but in spite of frantic attempts on the part of the petitioner, she did not return back to matrimonial home. This was the specific contention I have advanced. Now, Lordship would kindly see page 270 parallelly, how she has dealt this issue.
Paragraph
G, page 270.
Yes.
That the statements made in paragraph 12 is partly admitted by the opposite party wife, and she went to her parents' house accompanied by her minor son on 31st 2015, but the opponent opposite party wife denied the fact that no frantic attempt was made to bring her back. So, Millet, at least from
Yes.
but this is a written objection file. So at least from these two documents, if read together, the very contention that she was driven out from the matrimonial home is not very happy or is not very appearing from the record. Now, Lordship would kindly come to, before going to the proceeding of the other proceedings, my lord, I will draw your lordship's kind attention to the cross-examination done by the lady to the husband in 125. Well, I would kindly see I can ask. Well, I would kindly come to page 151. This is the cross-examination done by the lady. If your lordship sees this cross-examination, except a single suggestion at page 152. This is the cross-examination of husband.
Okay. Yes.
Except a single suggestion at page 152 to the effect that it is not a fact that well, it is fifth line from the bottom. It's not a fact that I drove away my wife causing torture upon her on 31/1/2015. There is not a single whisper about the demand of dowry or any torture pertaining thereto.
Yes.
Therefore, Millet, 125 application doesn't contain about anything about torture. The parallel proceeding averments made by her doesn't support the contention of torture. The cross-examination done on her behalf does not put any question to the extent of the torture. Now, Lordship would kindly come to the evidence adduced by the mother in the proceeding under Domestic Violence Act. Well, there had been presently no scope for bringing this person to the witness box, because in the 498 proceeding, they have filed an application that she is suffering from speech-related diseases, is unable to give her evidence, and as such, her evidence has been expunged in 498.
Of the mother. Mother-in-law.
Mother-in-law. Well, that document is also with me. If your Lordship want, I can produce. Now, Lordship,
What is the stage of the 498?
Well, the evidence of IO
Going on.
last evidence of IO is going on.
Other than mother, who is the witness?
Others were the witness. The complainant was their witness.
Correct.
One of her family relative or uncle by relation was a witness. These are the issues. Now, Lordship would kindly come to let's kindly come to page 9
Of the revisional application.
of the supplementary minutes.
Page 9.
9 minutes.
Yes.
I came here as per direction of my daughter.
Yes.
My daughter has told me what to tell. My affidavit is prepared by my lawyer, and I only put my signature. But I have just drawn this attention to your Lordship because the evidence in chief has gone by way of an affidavit. So the moment it is by way of an affidavit, it will be the copy paste of the application preferred. So the cross becomes a bit relevant for this.
Correct.
Now, Lordship would kindly come to the next page, page 10. If your Lordship kindly see, 8th line from the bottom, which starts with the word also.
Yes.
May I start from a bit earlier? I used to go at the house of my son-in-law.
Yes.
And they also used to come at my house. We have gave several things to my daughter on her reception, but not on demand. The Bauvat ceremony was held after one day of marriage ceremony. After marriage, there was no demand of dowry. Now, Millet,
Yes.
kindly come. Page 12. Eighth line from the bottom. The word sentence starts with after.
Yes.
After getting pregnant, my daughter left the job. Before delivery of child, my daughter lived in a matrimonial home. My daughter has fixed a board for private tuition, but not yet commenced. My lord would kindly see the date 20th of July 2017, and Lordship kindly relate this with her admission in the registration form of the son, where she admits that private tuition is a profession. Now, Millet, the reason behind this entire feud is
Yes.
a dispute cropped up between the two families on the day of reception of the brother's marriage of the petitioner. The son-in-law, that is the husband, was not invited in the reception. The wife initially did not want to go there. The family members from the wife's family came to the house of this son-in-law. There was a chaos for which the husband has initiated a proceeding.
That is not required in the
But
revisal
that is not
application.
required, but Lordship
This is a revisal application only to say that this has not been considered by the London magistrate while awarding the maintenance. Yes.
I'll not
Only
go
come
into
to the award order passed by the magistrate. This has not been considered. If it is considered and given the reason, then you are out. If it considered not considered, then the court has to see. If it is the what are the evidence? What are the document you have pointed out? Whether this all the things has been taken into consideration by the London magistrate and given his finding. That's all.
That is not given. That is not given, Millet. And in fact, Millet, so far as the issues I have pointed out, I did not want to waste your Lordship's time, Millet. If your Lordship sees the cross-examination of the wife, categorically these issues has been put out. Now, Millet, Lordship would kindly come to the observation portion of the learned magistrate.
Page number.
And this is a part of the certified copy, Millet. I cannot page.
At the last one.
Last one, Millet.
Okay, okay. Yes.
If your Lordship kindly come to inner page 6.
Yes.
The learned magistrate judge, while disposing of this application, heavily banked upon the issue of the husband leaving his job or for resigning from his job, who was working as a who was working in the HDFC bank as a assistant branch manager or something like this.
Who?
The husband.
Petitioner.
Petitioner was, but he himself admitted in the affidavit of asset that he has resigned therefrom. And this was also categorically put in the cross-examination because while he was associated with the branch, there was a car loan. He was paying from the money. Once he was there, there was some investment for him, which he has had to liquidate for relinquishing of his debt. And presently, he is maintaining his nets by doing private tuitions, which is a categorical statement made in the affidavit of assets.
Why you have left the job? And you left the job of 38,000 rupees per month and you started taking the job of the 10,000 rupees.
Question I had to put to my client. The issue was, well, although it was not on record, issue was, your Lordship knows in the private sector undertakings, pendency of the criminal cases is an issue. He was directed either to resign or to take a transfer at the border of the Assam.
But that is not the objection. That is not the objection raised by you. I mean, your written objection in the 125 application.
I could not. The reason behind is this because of the resignation letter. Because if
you might have been given the resignation, but in the proceeding 125 application, you filed the written objection. In the written objection, you could have been taken.
I could have been, but
taken the ground. Yes, I have given the resignation due to this, but you have not taken
that. But that is not there, but my humble submission before your Lordship is on two aspects. A, once the desertion is not proved and the document or the evidence on record indicates the periphery on which she claimed to have been tortured and deserted is a questionable thing, whether the leaving of the matrimonial home can be considered as a ground for desertion or it's a voluntary desertion on the part of the wife. B, Millet, once from the record it is further revealed that there has some income of the wife and the affidavit of assets has been introduced by the law, whether there was any liability on the deponent to demonstrate the nature of the income and to come up with a plea that I earned this, but this is insufficient to maintain myself. And if she or he does not do so, and that means that he or she is not approaching the court of law with clean hands, and if so, then whether the party can be entitled. These are the two questions I'm putting to myself. These are the two circumstances on the large issues which my humble submission the learned judge did not take into consideration. Let me kindly come to page 6. In page 6.
Yes.
Considering the evidences on record, it is found that the petitioner did not adduce any other witness to corroborate her evidence. She did from the middle, Millet.
Yes. I am there.
She did not lodge any complaint as soon as she was driven away from a matrimonial home. Yet it is found that the opposite party has filed a matrimonial suit for divorce. Well, that is not correct. I have not filed any matrimonial suit for divorce, which was initially filed, but ultimately that has been dismissed for default. I did not pursue that.
But you have filed.
I had filed, but I have not pursued that. It has been dismissed for default. And the suit is pending before the court. This is the second part, which is contrary to the record. The petitioner has filed a criminal case and a case under PWDV Act. The opposite party has admitted by cross-examination to the petitioner that she was driven away from a matrimonial home on 31/1/2015. But I have not admitted anywhere that I have driven her away. The opposite party may deny such fact, giving suggestion in denial form that he and his family members did not drive away her from the matrimonial home. The petitioner may state in her cross-examination in the case under PWDV Act that she left her matrimonial home and came to her paternal home on 31/1/2015. And she may state further in her cross-examination that she had stated in her written objection in the case number Act 8 of 3 of 2015 that she went to her paternal house accompanied by her minor son on 31/1/2005. But those facts do not suggest to infer that she left her matrimonial home voluntarily on that day. The evidence cannot be considered as admitted fact of the petitioner in this case, that she left her matrimonial home voluntarily on that day because the said petitioner has stated in evidence in this case that she had been driven away by the opposite party and his family members on the demand of money. Well, may I pause here for a moment, Millet? Millet, this is settled propositions of law that an fact admitted in a parallel proceeding need not to be proved in another proceeding, and that can very well be looked into. In fact, that was the fulcrum of Rajneesh versus Neha. So in view of this, these observations is contrary to the record.
Have you brought the certified copy of the DV evidence before the court?
Yes.
That exhibited? This evidence which she had led before the DB Act.
Her portion has been exhibited. Her portion, so far as the
How it is exhibited? The statement was before the learned court.
Yes. This was Millet. Millet would kindly come to page 138. At the middle portion.
Yes.
Millet would kindly come to the
How you will take? How much? You will take time.
10 minutes.
You will continue.
Yes.
You will continue.
Over to the next day, I think.
That is the problem.
Take some time to conclude.
How much time you will take?
10 minutes. 10
minutes.
10 minutes reply.
Okay. Other matter released. Yes.
Millet would kindly come to the middle portion of the.
Now, if any urgent matter, please sit. I will take the matter. No problem. If any person wanted to mention the matter, you take it. I will take the matter. Okay, let's going on. If any person wanted that you wait, I will take the matter. Before rising, I will take. No problem. Yes.
Millet would kindly come to the middle portion. The paragraph starts with the witness is shown. The certified copy of the deposition in M43 of 2015, and it is pointed out the sentence written in further cross-examination of PW1 resumed on 18 to 2017. On 31st January 2015, I left matrimonial home and came to my paternal home. I had been, but then she improved her version just to circumvent the situation.
Okay.
This was category, everything. So far as the Act 8 is concerned,
okay.
So far
Next.
as the DV is concerned, this was indicated.
Okay. Next.
You would kindly come. May I continue where I was? Page 7, second sentence. Page 7. In a page 7. It is fact that the petitioner came to her matrimonial home after marriage with a hope that she would live in a matrimonial home for the rest of her life. But she had to leave a matrimonial home and has been refusing residing at her paternal home. All these facts conjointly suggest believing the court that the petitioner did not leave a matrimonial home at her own will and she did not desert her husband. The opposite party cannot prove his defense in view of section 125 subsection 4 of the CRPC. The citation referred by the learned advocate of the opposite party are not befitting with the facts of the instant case. Now, I should kindly come to the last paragraph of the page, which starts with the word the learned advocate. The learned advocate of the opposite party has contended that the petitioner filed miss case number 43 of 2015 under PWDB Act, and the learned Metropolitan Magistrate 20th Court Calcutta was pleased directing the opposite party by his order dated 3rd of July, 3rd of March 2016 to pay the petitioner the sum of 10,000 towards the monetary relief. But this was the interim relief initially granted, which she has suppressed, and that's why the interim order was from the date of the order in 125. Now, my lord, kindly come the next page, second paragraph. It is further found.
Yes.
It is further found from the certified copy of the order in miss case number 43 of 2015 that the said case under section 12 of the PWDB Act was dismissed by the judgment dated 11th of March 2020 of the learned Metropolitan Magistrate 20th Court Calcutta, that the petitioner was present at her paternal home on 3rd of February 2015, and thus the petitioner could not prove that on that day the respondent caused upon the domestic violence. She had been residing in her paternal home since 31st of January 2015. The said judgment of the learned Metropolitan Magistrate 20th Court Calcutta in miss case number 43 of 2015 was affirmed by the learned Additional District and Sessions Judge 2nd First Track Court, Bhavan Calcutta, in criminal number so and so by his judgment dated so and so. The said judgment cannot be taken into consideration in this case because the petitioner has filed the case under section 125 CRPC for relief. She is duty bound to prove the case in accordance with law. The petitioner has every right to claim maintenance as per the law under the different provisions, and she is entitled to get relief subject to proof. The grounds of dismissing the said miss case number 43 of 2015 cannot be taken into consideration in the instant case. Considering the evidence on record, it is found to this court that the petitioner did not leave the matrimonial home at her own will, and she did not desert the opposite party voluntarily. The petitioner has stated in her evidence that she has no income to maintain her and her son. She has further stated that her son is a student of class 5 of Haryana Vidya Mandir School and she needs money for her son's education. Her sons require school expenses yearly of rupees 40,000. She has further stated the opposite party is an employee of HDFC Bank and gets a salary of 35,000. The learned advocate for the opposite party has submitted that the petitioner has stated in her objection in the case number Act 8 that she is capable to maintain her minor son with regard to such disease of her minor son. It means that petitioner has sufficient income to maintain her and her son. The learned advocate for the petitioner has submitted that the opposite party is legally bound to maintain his wife and son. The petitioner has no independent income to maintain her and her son, and that is why she is entitled to get maintenance money from the opposite party. In this context, it is found from the cross-examination of the petitioner that said case 3 of 2015 has been disposed of. The said fact as stated by the petitioner in the written objection cannot be taken into consideration as an admitted fact in the instant case. The parents, the parties to the case are liable to their respective facts as they asserted in the respective case. Now, I'm going to kindly come to the last portion of this paragraph. The paragraph starts with the petitioner has stated in a cross-examination that her matrimonial home is near to the para of her husband, her paternal home. She used to work as a teacher before and after her marriage in a private school. After a few months of her marriage, she had to drop her service as per the wish of her husband or family members. And I have indicated that her mother stayed due to pregnancy. When she was pregnant, she left the said service. She used to work as a private tutor before and after the marriage, and she did not work as a private tutor after driven away from a matrimonial home. She noted in her son's school's admission registration form in 2016 that her occupation was private teaching. Her name had been recorded as an agent in the National Insurance Company Limited. Development officer used to operate her code order of the insurance company, and she had been given some commissions for few months. Thereafter, her agent code has been dropped. She is the owner of the dwelling house of this. But after considering this, the learned judge did not make any observation, rather made a contrary observation without considering the specific evidence adduced in this case. My lord, kindly see, the paragraph starts within the same page, considering the above referred facts, it is found that the petitioner used to earn something being a private tutor. There is no evidence that at present she earns as a private tutor as allegedly by the opposite party. There is no cogent evidence to believe that the petitioner is getting considerable amount of money by inducting tenant in the house. No conjecture and surmise can be taken regarding the income of the petitioner as alleged by the opposite party. My lord, my humble submission is this. My lord, the principle of appreciating of the evidence must be equal for all the parties. If today the husband has suppressed his income, he is liable to face an adversarial inference. If today the wife has suppressed his income,
No. See, wife has suppressed the income will come into effect provided you have proved. You have proved she was working in the admission register of the daughter or son, whatever it may be. The name she has stated that she is working as an agent. You have brought the NIC agents, National Insurance Company agents, stating that she was the agent of the NIC, and whatever the amount she was getting, it has been transferred directly to the account of the petitioner. Third, with regard to the income from the landed property, the joint property, these are the three things which you are telling that the income of the petitioner. It is the husband who has to prove, yes, she is working. See, if a person is working, having 10,000 rupees, 1,000 rupees, 8,000 rupees, whatever it is, the court has to scrutinize whether the amount which she is getting, that is complete to the wife for her maintenance. That is also one aspect. Here, you naturally you have proved the case that she was working or she is working, whatever it may be, but you have not proved. You have not proved the income, what income she was getting. See, it is the case. The evidence has come on record from the LIC agent. Yes, amount has been transferred to the account. LIC agent stated that he has no knowledge about the account number. Correct. So you are the appearing for the respondent or opposite party. What is your duty? Immediately you have to file an application under section 91 to protection of the if she has not disclosed in the affidavit, you are telling that she has not disclosed. But it is your also duty. The court will see with regard to the non-filing of the affidavit or suppression of fact, that is different thing. But with regard to the proof of the income of the wife, and that is to be proved strictly. It is a criminal case. It is a criminal case. It is a proof, strict proof. It is not the appropriate with regard to the only but yes, you have given the evidence, the court can consider. The if you could have been given the notice under 1991, produce the document, produce the account, and you can call the bank. That could have, you have not done so.
May I subject to correction by your lordship. Well, the basic contention of the 125 is this: he has no income, she is a destitute, and she is unable to maintain herself. This is her contention. She nowhere came up with this story that I have an income, but that is insufficient.
That's I'm telling. That's what I'm telling. She has admitted. She has admitted. Even in a cross, you also brought the document. Yes, she was working. But with regard to, but at the time of passing the order for awarding maintenance, the court has to justify how much amount she is entitled for. Whether she is entitled or she is not entitled. Admittedly, till date, she is the wife. Correct. Admittedly, she is the wife. You might have been given the evidence she was private tuition. Private tuition, okay, you cannot prove the private tuition. But with regard to the agency, you could have been proved that. That has not been so. How the court can determine, yes, she was getting rupees 8,000 or she was getting rupees 12,000. Only 1,000 is enough, but another is. So for that, how the court can ascertain to that effect?
But it's subject to correction, Millet. Millet, the situation subject to correction by your lordship, Millet, situation is probably a different after the Rajneesh versus Neha has been introduced. Millet, the
अरे वो दो
Two SCC 324. Well, I would kindly come to page paragraph 63.
yes.
Well, at paragraph 63. At
Yes.
present, the issue of interim maintenance is decided on the basis of the pleadings. Well, this is even interim maintenance, where some amount of guesswork or rough estimation takes place so as to make a prima facie assessment of the amount to be awarded. It is often seen that both parties submit a scanty material, do not disclose the correct details, and suppress vital information, which makes it difficult for the family courts to make an objective assessment for grant of interim maintenance. While there is a tendency on the part of the wife to exaggerate her needs, there is a corresponding tendency by the husband to conceal his actual income. It is therefore become necessary to lay down a procedure to streamline the proceedings, since a dependent wife who has not other source of income has to take recourse to borrowing from a parent's relatives during the interregnum to sustain herself and the minor children till she begins receiving interim maintenance. Well, then it deals with the subsequent proceedings, and ultimately your lordship will find that paragraph 65, the party claiming maintenance as a spouse or as a partner in a civil union, live-in relationship, common law marriage, should be required to file a concise application for interim maintenance with limited pleadings, along with an affidavit of disclosure and assets and liabilities before the court concerned as a mandatory requirement. On the basis of the pleadings filed by both the parties and affidavit of disclosure, the court would be in a position to make an objective assessment of the approximate amount to be awarded towards maintenance at the interim stage.
Correct.
Now, may let's kindly come to paragraph 72, which is in direction form.
Yes.
Keeping in mind the need for a uniform format of the affidavit of disclosure of assets and liabilities to be filed in maintenance proceedings, this court considers it necessary to frame guidelines in exercise of our powers under Article 136, read with Article 142 of the Constitution of India. The affidavit of disclosure of assets and liabilities annexed at enclosure 1, 2, and 3 of this judgment, as may be applicable, shall be filled by the parties in all maintenance proceedings, including pending proceedings before the family court, district court, magistrate courts concerned, as the case may be throughout the country. The applicant making the claim for maintenance will be required to file a concise application accompanied with the affidavit of disclosure and assets. The respondent must submit his reply to the affidavit of disclosure within a maximum period of mallet. I'm skipping this. Mallet would kindly come to then 72.8.
Yes.
The pleadings made in the application for maintenance and replies filed should be responsible pleading. If false statements and misrepresentations are made, the court may consider initiation of a proceeding under section 340 CRPC and for contempt of court. Mallet, once it is a settled propositions of law that once a conduct invites a criminal act, then there cannot be any deviation.
Correct.
Today, after this affidavit of assets and disclosure, once by adducing evidence, I have been able to indicate that she has some income. At least there was a scope for the court to call for a fresh affidavit of assets if required.
Why? It was your duty. You have not filed an application, initiated a proceeding under section 340.
And I have.
What has happened to that?
That has not been disposed of. That has been kept pending.
Why? They cannot.
Well, that has been.
Court cannot once the court.
But that has been. There was a 340 proceeding.
When you have filed the 340 proceeding.
Well, it has been filed. It is mentioned in my written objection. It is mentioned in my written objection. My lord, kindly come to page 57, paragraph 26.
Before filing your objection, you filed the 340.
Yes,
This is the objection.
yes, because she has suppressed.
And that has not been
That
decided.
has not been decided.
So what is the fate of the when the proceeding is disposed of? What is the fate of the 340 now?
That is basically cyanide. That is basically cyanide.
Yes, which yes, 26.
My lord, I do not have, obviously, I could have filed a 91 application asking for the document. But Lordship, kindly appreciate this fact. I do not have any access to the income of the wife. Whatever the limited information I had tried to venture this. This is one aspect of this. Another aspect is her suppression. The third aspect, whether she is at all entitled to.
See, that two aspect is different. With regard to whether she has been driven out from the house, that is one aspect. That is evidence the court will consider after hearing this. Correct? What you have placed, let me hear that. And with regard to the service, that is also you have proved some to the extent. Only the problem is the
sufficient.
income is
Whether
sufficient.
the income is sufficient or not.
That is the.
Well, my humble submission will be, Millet, that once from the record I have indicated that
Because in the maintenance case, the court has to see this quantum has to be consideration with regard to the desertion
and the sufficiency of
sufficiency.
Millet,
And even in this matter, this Neha, in this kindly come to that because many days has been passed because when I was dealing, kindly come to the paragraph 91. 95, 90.5. 90.5. That is the
it's an hard
correct. That is
that's why I have never argued before your lordship on the issue of my resignation, because the able-bodied theory principle is absolutely bounds me to maintain. I cannot argue on that. The only issue is this: once from the record I have indicated that her desertion is questionable, she did not approach the court of law with clean hands, and there is a question regarding her income.
got your point.
These are my humble submissions, Millet. Millet, only one thing I'll just indicate to your lordship, Millet. I do not know, but learned judge has imposed a cost of rupees 10,000 upon me. Millet,
maintenance case cost.
Millet, that is not recorded over there. If your lordship kindly comes to the last page at the ordering portion, first paragraph.
The director to pay the monthly maintenance for the pay 8,000 and so on. Yes, I got it. 10th day of access with effect from the month of September 2020. Month of September 2024. This is the order from the date of order.
From the date of order.
And you are getting the interim maintenance. You are paying the interim maintenance.
I was paying the
What is the amount?
But that was the amount of 7,000.
In this matter.
In this matter, initially there was a 10,000 in the domestic violence which I have paid. Subsequent to dismissal of the domestic violence, there was no payment. There was a gap of 9 months, I believe, between the dismissal of the.
Yesterday, 11 months, whatever it may be.
9 months between that period and the. I was paying 7,000, but
7,000 was paying.
7,000 has been paid
till this order.
But there is some area is there.
No, whatever it may be, areas they will recover it.
Some area is there,
So
but I have been paying.
So why the call 10,000?
This is there, Millet. Millet, I have indicated to you on the point of the desertion. I'll just rely upon our decision. I'll just indicate the paragraphs. I'll not the.
Yes.
Paragraph.
Which one?
Millet, the Debnarayan Haldar 2003-11 SCC 303.
अरे वो ले ना यार.
Paragraph 18 to 20. 2003.
Sir, You keep your mind in here.
My lord, I had to download this from non-true print because once I'm downloading from the true print, the headers are getting. That's why, my lord, I have to. My lord, the
Which
relative-
paragraph you are
18 to 20, my lord.
18.
18 to 20.
What is the proposition?
The proposition is on the issue of the desertion. These are my.
Thank you. Yes, sir.
Like, proceeding under
Come on the next day.
next day, next tomorrow or next Thursday.
Thursday.
Very well.
So and so appearing for the petitioner. Huh? So and so appearing for the petitioner. Name record can. You want name? What is your good name?
Shatadru Lahiri.
Mr. Satadru Lahiri, London advocate appearing for the petitioner. Mr. Aniruddha Bhattacharya. Aniruddha Bhattacharya, London advocate appearing for the respondent OP number 2. Full stop. Anybody is appearing for the state? No. Full stop. Counsel for the petitioner has concluded his argument. Full stop. Due to paucity of time, counsel for the opposite party could not argue the matter. Accordingly, the case is left on. Let the matter appear on 13th March at the top. Yes.
With regard to item number 10 and 11, there is an margin because the date has been fixed on 12 of this month. Until unless pass any order, but the warrant of arrest will be. Some maintenance amount is paid, but I am paying the current.
Give the order, give the letter. Give the file 10 and 11.
Kindly, first of all, your lordship kindly taking up the date. Here are 4828.
Yes.
And here I am challenging for quashing of the order passed by the London Additional District. Initially, the ACJM passed an order.
Where is the order of the magistrate?
Order of the magistrate I have stated in the first page 90. Start from page 90. Order of the magistrate.
Operative
Here,
person.
sir,
The petitioner do hereby get an order of maintenance of rupees 10,000 per month.
Yes.
For the minor child.
Yes.
To be paid in the hands of the petitioner's mother.
Yes.
Only 10,000 to this
Only
child.
10,000.
Correct.
But
This
you
is
must
this.
kindly
Just
bear-
a minute. This order is passed on 15th of March 2024.
Yes.
And from the date of filing of the case.
Yes.
From the date of filing of the case. What was the date of the filing?
Date of filing, my lord, 2007.
Just a minute. बाबू वो जो अभी जो ऑर्डर दिया ना
15
कुछ नहीं छोड़ दो
December 2007.
हाँ
15 December 2007.
15th December
2017. The case was filed.
15th December 2017.
7.
Okay, so from December 2017 you have to pay 10,000 rupees.
Yes.
Correct.
I
Then you
challenge this order before the-
there was no interim maintenance.
No.
No interim
No,
maintenance. Then you are challenged before the London Session Judge. Okay, what is the order?
Altered the matter amount
Hmm.
to the tune of rupees 7,000. That your lordship will get below page
7,000. Yes, 7,000 in favor of the OP number 1.
Yes, 7,000.
And revision share by direct to pay rupees 7,000. OP number 1 is out of OP being the natural guardian.
Internal page
Is
of
succeeding. Okay. Instead of 10,000. So 3,000 you got the benefit of 3,000.
Yes.
Correct.
Now, my lord, current amount I am paying. There was some due. That is to the tune of rupees 5,67,000.
Correct.
Now, my lord, my humble submission, my lord, thereafter they filed an execution. But I have also challenged that execution. The execution case, my lord, 12th of this month, date has been fixed. Until and unless your lordship pass any order.
So how the execution order can be challenged here? You're not paid, file the execution. Where is the?
I am contesting this. In the meantime, I have filed the application restitution of conjugal life.
Maybe.
But I
See,
won't get
as on date, there is an order upon you to pay rupees 7,000 to the child from 2017.
Yes.
Correct. What is the due amount? What is the due amount?
Due amount of 5,67,000.
5,60,000. Correct. On the date of filing of the execution petition, the court has passed an order. Where is the order for payment?
Order for payment as per order, as per order.
No, that order in the execution. You challenge that 5 lakh has been. Where is the order that? Because you have mentioned that the court has passed an order.
Next better.
Where is the order?
Order 25 September 2024.
Page number? No order. Do not disclose any order.
But I have stated in list of dates. If you also kindly see the.
You have not enclosed the order. You filed the revision application without the certified copy of the order. How? Where is the certified copy of the order? Wherein you have been directed to pay 5 lakh within 1 month or.
Notice I have challenged. Page 49.
Sorry.
You also kindly bear me.
Sorry, sir, you are not enclose the order. How the court can.
You also kindly see. Notice I have challenged.
Maybe notice how the notice can be challenged in the execution proceeding. You go and file them before the learned court.
I shall definitely go before the learned magistrate.
Yes.
But you also kindly give me some time to pay the amount.
You go and pray before the learned court. You are not paying for the child only. Court has given. So appearing for the petitioner.
She is earning.
So appearing for the petitioner, comma, the petitioner has filed the present revisional application, being agreed and dissatisfied with the order passed by the learned session additional session judge Raghunathpur Purulia in criminal revision number 11 of 2024, dated 31st of August 2024, wherein the learned additional session judge has modified the order of maintenance passed by the learned
Judicial Magistrate Second Court Program.
Passed by the learned Judicial Magistrate Second Court Raghunathpur Purulia in
Miss case number 84 of 2017.
In Miss case number 84 of 2017, dated 15th March 2024, by directing the petitioner to pay rupees 7,000 per month. Directing the petitioner to pay rupees 7,000 per month to the hands of the mother of the minor, being the natural guardian, from the date of filing of the Miss case number 84 of 2017 within 7th of each succeeding month, instead of rupees 10,000 as awarded by the learned judicial magistrate. Full stop. This court did not find any. Counsel for the petitioner submits that the opposite party has filed an execution proceeding for payment of the maintenance amount as directed by the learned additional session judge, Raghunathpur Purulia, and prayed for a stay of the interim order. This court did not find any merit to pass any interim order at this stage, and as such, interim order is refused. Let the matter appear. The petitioner is directed to serve the copy of the application along with the document to the opposite party within a week from date. List the matter on 20th March 2020.
20th March.
20 March 20 March 2025.
But you also kindly bear me 1 minute. I have already served the copy, but I have not get the
affidavit of service is not.
Affidavit of service.
And
before my lord rises my lord serial number 8 my lord.
This both are same order. Why two applications?
Well, execution I have challenged.
So, the only order you pass an order in this case.
But 11 is execution challenging matter.
11, where is the list? Item number?
11.
11 is 4829. 482. 11.
Both
Item
copy has
number.
been.
And 10. The petition is directed to serve the copy of the petition along with all documents to the opposite party and to file affidavit of service on the next date fix. List the matter on 20th March.
On the same day.
Lordship, if I may be permitted to mention item number 3.
Mm.
It's a very small thing.
Mm.
Matter has already come up before your Lordship.
Mm.
I have come up for quashing of an FIR under section 498A on behalf of the husband.
Mm.
The matter has been compromised long in the year 2018.
Mm.
On the last occasion, your Lordship has only directed me to bring the copy of the agreement where it is been signed by the wife that it has been settled. That I brought. All I'm praying for is an order for service so that I can come up and.
Then you file by the supplementary affidavit. How this can be?
This I will file, but at least I maybe get an order to serve the copy.
What?
Serve the copy to the opposite party.
There's
so
no order.
There's no order.
Let me see first.
Only that much.
First, the court may see the what is the. Yes.
My lord, may I beg to be excused to mention a matter, my lord, item number 30, my lord. Wherein, my lord, I have challenged an order of, my lord, learned sessions judge, my lord. My lord, by, my lord, reversing the order passed by the learned magistrate, my lord, where the maintenance was directed to be paid only to the child, my lord. We are paying maintenance to the child, my lord. There is no objection, my lord. It some has been enhanced. We don't have any objection to that. But, my lord, learned magistrate was proceeded on the basis of the fact, my lord, then the wife made a declaration and it was submitted before the court that I have voluntarily left the court. On the basis of that, interim order was not passed at this stage, my lord, order was huge, and subsequent stage of the proceeding, it was never challenged. Even in the revision, it was not challenged before this court that it was the document was made under the coercion or threat or undue influence, my lord. But the learned, my lord, session judge, without looking into the document, without having been challenged by the wife, my lord, who has he rescinded his, my lord, right that I have already left voluntarily, my lord. Now he has, my lord, passed the learned session judge directed to pay an amount of 9,000 for the wife, and, my lord, the amount of 2,500, my lord, that has been 4,050, my lord. We are not, my lord, my child, my lord, I don't have any objection. But without, my lord, having any challenge, even before the sessions court, how, my lord, the learned sessions judge has, my lord, modified their order, my lord. The finding itself, my lord, shows, my lord, while passing the order, my lord, if your lordship is kind enough to see, my lord, that the learned page 15 and 16, my lord, specific finding has been recorded by the learned trial judge while passing.
What do you want at this
My lord, at this stage, my lord, so far as this, my lord, order of the session judge in for paying maintenance may be stayed, I will serve the notice. So far as
how the child may.
no, so far child is, my lord, concerned, I am doing, and I will pay the enhanced amount even. I don't have any objection. But, my lord, learned judge, my lord, in spite of the finding having been arrived by the learned trial judge, reversed the finding even when the document itself was challenged either in the court, in this court, or before the learned session judge.
So in which proceeding the learned session judge has enhanced the maintenance of the wife?
No, my lord, learned trial judge did not even pass any order on the basis of the document. It is a specific finding that since the wife has voluntarily
The matter
stated,
went to the session judge.
session judge, my lord, wife moved the application. Revisional application.
Revisional application
Yes.
regarding
my lord, payment of maintenance to her and her.
Without the order of the London magistrate.
Yes.
Without
That is, my lord, yes. That is the subject of challenge. And the own documents he has not neither challenged. It has been recorded by the learned trial judge, not before the session judge. It was
when the matter is fixed before the
my
magistrate.
lord, on 12th March. 12th March. 12th March.
Come on 13th.
13th, my lord.
13th ये मैटर को ना 13th में
13th.
13th को इसको ऊपर रखो.
My lord, my lord. And the supplementary affidavit, my lord. My lord, some translated copy of from Bengali to English, my lord.
Come with on
My
lord. Item number 30 be placed ऊपर कर दो 2 या 3 नंबर में कर दो 3 नंबर में कर दी. At item number 3.
Deep.
My lord, may I be permitted to mention a matter? My lord, item number 53 of the monthly list, my lord, the interim order passed by your lordship is expiring today.
हमारा कोई है न all the. Where are you all persons?
My lord, this is the order and I have also served a notice on the opposite party, my lord.
Twice I taken the interview. Where are you?
Calculate করে নিন আছে কিনা তাই আপনাদের এখানে আছে ক্যালকুলেট করে দেব মান্থলি
Nobody is there, my original side. Who will take the dictation?
I'm grateful.
My lord, my lord, item number 8, my lord.